everybody back. All right, so I mentioned to council that what I have done to this point is I have the request to charge submitted by the state. I've got Mr. Bryan's first request to charge. There's an additional request to charge from Mr. Bryan and the defendant's first request to charge, McMichael defendants, I should say. What we did is I took those requests and put them all together in one large document just to see where there was duplication on the charges. And then based on that draft, I narrowed down into the draft you received last night, what I'm calling draft number 2, which is really just a clean copy. I've taken, in places where, say, there were 3 different requests on the same issue, I have put in the draft charge you received last night what I distilled down into an appropriate, or what the court believes is an appropriate charge. I realize that this does not include all of the charges that have been requested. This obviously is everybody's opportunity to raise whatever issues you have with respect to the charge the court has picked, and we'll go ahead and discuss those on the record. In the draft you received last night, there's also some, I'm not sure how it came through as highlighting or gray, but there you'll see there's some highlighting in that in there. Most of that is the headings that will point to the issue of law addressed in the charge. There's also some highlighting in places where I just need to go ahead and clean up the charge, and we just hadn't had excuse me, an opportunity to do that before sending it out last night. So my plan is to go ahead and get through those drafts that the court, or the editing issues the court has at this charge conference also. Generally with the charge, the court will put a draft together, includes the headings just so everybody knows what's there. I give the jury a copy of the charge, but it does not have the headings in it. It's just basically the charge as read. I don't read the headings to the panel, just so everybody understands. Those headings are simply there for directory purposes more than anything as we go through the charge in the charge conference. Everybody understand where we are? My thought is the best way, and this may not work, we'll see. The best way to go ahead and get through this charge is I'm going to go through what I've got and make some of these edits that I know I need to make. And then I'll go back through and go around the room for exceptions or objections to the charge. Everybody understand what we're going to try to do, or how we're going to try to do it?
Yes, Judge.
Okay. All right, so what I'm going to do is just start on page 1. I'm going to start going through, and anywhere it looks like I need to make an edit, we'll go ahead and make that on the record so everybody's clear what that edit is. So on page 1 of the draft charge, there's the prefatory language, and then I've got indictment and accusation. On page 2, issue and plea of not guilty, presumption of innocence, burden of proof, and reasonable doubt. Page 3, grave suspicion, and then evidence generally. And
It's just to make sure I'm understanding our format, excuse me. If you want us to note anything at this point as you go through, just if we're reserving exceptions.
No, what I'm doing is I'm just going through right now. I'm going to give each party the opportunity, once we're done, so everybody knows where I am with the charge, to go ahead and make their own objections or exceptions.
Very good.
Okay.
Thank you.
Page 4, stipulations. The court has some editing there. The main thing that I've got is I read them a stipulation charge, which is the stipulation charge I usually use. Since I drafted that stipulation charge, it looks like a pattern charge has come out, and this is the pattern. I'm inclined to go ahead and charge them on stipulation the same way I charged them during the trial. I'm going to go ahead and note that. So that language that's in or on page 4 is going to change a little bit, and we're going to use the court's existing stipulation that's already been used. Continuing on, page 4, direct and circumstantial evidence. Page 5, expert witnesses. Page 5 also, and I want to explain the court's charge. There is, on page 5, a credibility charge. The pattern charge, I think, comes now in 3 or 4 different parts on credibility. And when the new charge came out, there was an effort, at least in the circuit that I generally preside in, to try to consolidate those 4 separate charges into one that flowed better and put credibility in one more compact and I think more easily discernible charge. And so you'll see in that credibility of witness charge all of the ideas from the 3 or 4 various credibility charges that are out in the pattern have been consolidated into one. And I'm happy to address any questions on that when we get to the objections or exceptions. But that's page 5. Page 6 is prior statements, single witness corroboration, and accomplice. Page 7 continues with the accomplice, and I've got some questions about that I'd like to hear from counsel on. Page 8 is coerced unknowing participant, not accomplice. We continue on to defendant's choice not to testify. Page 9, statement of defendant. Let's see, I've got an edit here. Yeah. And the way I'm going to read that is before you may consider any of these as evidence, because we're talking about a number of different statements from a number of different defendants, you must determine whether the statement was voluntary. So I'm referring generally to statements and then specifically at the end indicating that each individual statement needs to be addressed. So I've dropped off the its statement was voluntary. We continue with voluntariness defined, burden of proof as to voluntariness, corroboration. 10 is the Bruton charge that we've already, I believe, we have already charged the same language. Then there's limiting instructions. I do have a question about that. I'm not going to get into the edits until I hear from everybody on the limiting instruction. Prior difficulties also I have some questions about, so I'm going to wait on edits there. Identification is on page 10. Page 11, identification burden of proof. And then fingerprints. Page 12, definition of a crime and intent. Page 13, no presumption of criminal intent, parties to a crime, principal failure to prosecute, and knowledge. Page 14, just an edit I need to do, let's see. And that would be that a crime was being committed. That's the edit there. So that's knowledge on 14. I've just made the edit. It's first paragraph reads, on the other hand, should you find beyond a reasonable doubt that a defendant had knowledge that a crime was being committed. Continuing on, we got conspiracy. And conspiracy, additional instructions, conduct and presence of parties, venue. Page 15, offenses charged, malice murder. Page 16, motive, felony murder, causation. And I do need to add in, I'll hear from the parties on what exactly, if anything, we should add in on the felony murder pattern. Going on, assault, aggravated assault, weapon on 16. 17, firearm is a deadly weapon. Determining if weapon is offensive. False imprisonment, attempt. 18 is conjunctive, disjunctive. I need to address which counts we're referring to there. Affirmative defense definition. And that would be acts, looks like plural. Justification, grounds for arrest, right and duty to execute a citizen's arrest. Page 19. Synonymous terms, must make the arrest contemporaneously, probable cause is not enough, and then probable cause. Probable cause is a question for the jury. Page 20, may not arrest on suspicion alone. Duty to inquire. Arrest, right to resist unlawful arrest. Illegal arrest, right to use force. And then criminal trespass. 21, duty owed to a trespasser. Burglary in the first degree, intent to commit theft. Burglary entry amplified. Burglary intent to steal amplified. Page 22, affirmative defense. Justification and use of force in defense of self or others. Page 23, to fill in the felony. As long as it's not a fire alarm or something. It's just something going on. Okay. All right. 23, reasonable beliefs explained. No duty to retreat. Justification, use of force in defense of property. 24, excessive force. Revenge. Verdict generally. 25, multiple defendants. Verdict form. I think the verdict form, I need to make sure they understand that they're going to be received. Well, I'm planning on doing 3 separate verdict forms, one for each defendant. So a special verdict form for each defendant. Court has no interest. Sympathy. Page 26, responsibility for sentencing, deliberations, unanimous verdict, and retire to the jury room. So that is what I have in the draft charge. Looks like I had fewer edits than I thought I needed to make. So it is apparently pretty clean the way it is. So let's go ahead and start with any objections or exceptions. I'll start with the state.
Thank you, Judge. First off, the state has no objection to the stipulations charge being read the way the court previously read that charge to the jury. So no problem with that from the state. With regard to credibility of witnesses, the state understands the consolidation, and the state thinks that this is fine. However, when we get to page 6, the top of page 6, where we're looking at in determining the credibility of witnesses and any testimony by them in court, in addition to the factors upon which I've instructed you, you may consider the following. And 1, character for untruthfulness if shown by opinion of other witnesses or reputation, or by specific evidence of specific instances of conduct which may relate to the witness's character for untruthfulness. Not sure we had any of that as evidence in this case.
Yeah, those 3 subsections are dependent upon the evidence. Looks like I didn't go through and edit them. Let me just take a quick look.
Would you like us to weigh in if we're able to?
Yeah, if we can agree.
Oh,
then
yes, I think 1, 2, and 3 just did not come into evidence in this case. So I would agree with the state in removing them. So in order to do that, you would just not include the phrase, "this would include evidence of."
Well, I think it's the whole...
It's actually the whole section.
Oh, okay.
Yeah,
All
it
right.
starts that section. Normally under these circumstances, what I would do is just remove that entire section, starting with in determining the credibility, if none of those 3 factors exist.
We would agree with that. And you guys, you okay if I speak? Or
Yeah, and if I don't agree,
Okay.
I agree though.
All right. Yes, we would agree with knocking all that out on the top of page 6.
I understand you're speaking for both
For the
McMichaels.
McMichaels, yes.
Mr. Goff?
We would join in that.
Okay, so we'll go ahead and remove on page 6, starting with in determining the credibility down to the prior statements heading. Okay.
I can just say this, Ms. Donikowski, if you went back to page 5 under credibility of witnesses, for some of these little things that we may be able to agree with, one of the dots is any evidence of bias toward a party. If I think it should be towards or against a party. Does the state have an issue with that?
Well, bias towards a party could be bias in favor or bias against. So if we want to change the wording, which I'm not sure we need to do, it would be any evidence of bias for or against a party.
I would prefer that, mostly because we use that sort of language in the jury instruction, in the voir dire.
I don't have any problem. I mean, it's changing the language from the charge, but based on what's being requested, I understand the issue.
We join in that.
All right, we'll go ahead and do that. All right.
So then we have on page 7, of course, we have our single witness corroboration and then accomplice corroboration. And what we have here under part, 1.31.93A, it says only give it if applicable, and I think I included it out of an abundance of caution, not knowing who was going to testify. The testimony of one accomplice may be supported by the testimony of another accomplice. Well, we didn't have that. We only had one person testify, so, and we didn't have any accomplices who were unindicted parties, so I think that comes out.
Well, that's, when I went through this, I'm wondering about this, the whole accomplice language, there was no additional testimony,
From an accomplice, period.
period. I assume this is something that's going to be raised by the defense.
It is, Your Honor. We don't see evidence that is appropriate in that regard. Accomplice just seems to muddy up the water, and I can't even give an example of where it might have been arguably in our case.
I assume the state was gonna withdraw it.
Right, I'm not sure it applies, and that's why I brought it up, because I'm not sure accomplice does apply, because normally it's the getaway driver who's already pled guilty, they take the stand and they're the accomplice, and we don't have that in this case, like a testifying accomplice. So the state will go ahead and withdraw it, given the facts of the case.
Yeah, just to be clear, I heard both the state's witnesses and the defense witness. I mean, I understand the party to a crime theory, but both indicated that on the day that there was no communication between Mr. Bryan and either one of the McMichaels, or before for that matter, and we didn't get into anything after, and we only had one of them testify.
Correct.
So, yeah, under those circumstances, I'm going to remove the accomplice language that starts on the bottom of page 6. That's 131.92. Takes us to the top of page 8. Yep, to the top of page 8. So we're moving all of what is now page 7. Okay.
So
Everybody-
then I think-
just want to make sure everybody follow what we've done.
Yes, I think it does go down to defendant's choice not to testify on page 8.
That
though.
is,
I think
actually,
all-
that's true. 131.94 is additional accomplice language.
Correct.
Yes. So that brings us down to the bottom of page 8, which is defendant's choice not to testify. Thank you.
Right. And the state is fine with, all of the statement of the defendants, choice not to testify, all the way through page 9. And then, obviously, the brutal charge had already been agreed to by everyone and already given. The limiting instruction was placed in out of an abundance of caution because the state was unsure of what would actually come in. Normally, this limiting instruction is there for possession of firearm by convicted felon, 404B acts, and other things along those lines. At this time, I think the only thing it may be required for is, I think the defendants had asked for flight at one point in time. I think someone had asked for flight.
I
Yeah,
did.
yeah, there was a request for flight.
Arbery definition.
All right, I'm trying to find. if
Well,
it-
and I'll tell you,
Mhm.
just to clarify this and move into that, yeah, I don't intend to charge on flight. I think there's very clear instructions to the court on where it would be, if it would even be appropriate to charge on flight. But that doesn't mean that you can't argue facts that might be consistent with flight. But as far as the charge, the court does not intend to charge on flight.
And I thought I had requested it as well, and I was prepared to withdraw that. Obviously, Renner versus the state had been, they thought, impacted by the new evidence code, but as a result of Rawls in October of 2020, I don't think a charge would be appropriate, even though it is available under 1.36.10. But I disagree that we have not had a limiting instruction. The court gave one limiting instruction to the jury yesterday to disregard a question and to not allow it to be impactful to them. The question was incendiary and inappropriate, and as a part of your admonition, you also asked the jury to disregard, and I would consider that a limiting instruction.
So I understand what Ms. Hoag's saying. I'm actually talking about 1.34.00, which says sometimes evidence is admitted, for a limited purpose or against some parties and not others. Such evidence may be considered by the jury, and then it has a few reasons why it could be considered. So I'm not sure that this limiting instruction, as it is written here, is appropriate, since we're not going to charge on flight, and we didn't have any other evidence that came in under that.
Yeah, I'm open to a proposed instruction. I understand what you're saying. I haven't decided I'm going to give an instruction because I've already provided an instruction with regard to the question asked yesterday. I'm open to language. I'm not sure that I don't think that the limiting instruction charge in 134.00 applies to that particular circumstance. So I'm not going to charge this because this is limiting. This is trying to instruct them whether it's artful or not when it's done, what evidence can be used for and what it can't be used for. So I'm not going to charge on this. If there's a proposal with regard to the question that was asked yesterday, I'm open to it without having made a decision about whether I will charge it.
Is it, however, appropriate, since you have it right under Bruton, as the dovetail into how they're to consider the statements of a defendant only against that defendant and not anyone else? So that's the only piece of evidence that I can remember that came in for only one use or for a limited use.
I believe that's already in here, and it should be.
It's in there.
Page, do you see it?
It's on page 7,
7?
Yeah.
131.93B.
Wonder if it did.
No, it's not. So I just removed 7. I thought prior statements. There's the prior statements and single witness corroboration.
Oh, I see. So on page 7, Judge, if you look, there's a sentence under statement by one defendant at joint trial, 1.31.93.
Okay.
Okay?
Joint trial. Got it.
And actually, that actually probably needs to be put back in, because that, despite not being accomplice testimony per se, it does say any out-of-court statement made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made that statement, and only if you find such statement was voluntarily made. So that actually, I believe, does apply 1.31.93B, given we had that in this particular case.
I think that is what I was referring to. I agree. The only thing I wouldn't want, and I don't think you were asking for, is that last line concerning accomplice, but.
Yeah.
Correct.
Hold on. Bear with me then. Let me look, because I thought, because once we get into 9, okay, so it looks like the best place to put that instead of just floating out there. Let me be very clear about it. This language at the bottom of page 7 probably needs to be moved to just above the Bruton charge language on page 10.
State agrees.
That sounds good to us. as
That
well.
way, all of the statement language is in one place. Okay.
Concur.
All right. I think I heard a concur from Brian.
You did,
Okay.
but you did hear concur on the flight issue.
No, I'm not there yet. Let me,
Oh,
I realize we're jumping around a little bit. I need to go back to you on that. So the 13193 language, except for the last sentence, is going to move to above Bruton language. Okay.
All right. And then the state had requested prior difficulties between the parties. Obviously, that came in through the February 11th testimony.
Your Honor, we object to that. I don't think that's an appropriate use of the prior difficulties. The February 11th came in as information that informed the decision-making of the defendants. I don't think there was any indication that there was a chase or an intent to arrest or detain as a result of what happened on February 11th. I think it was another attempt to do what just had happened on February 23rd. Prior difficulties, in the way that it's classically used, is quite different from this. It is hand in hand with sort of a revenge. And these witnesses said they didn't know each other. I don't know you. All I know is that you are, there was a black male who met this description that we've seen on videos, but we've never seen in person. And when I saw him on video again on February 23rd, I behaved this way. But I don't know him in any way. And let me throw this out too. My other concern about prior difficulties, I recall in at least one, maybe more, you all might recall, of the jury instruction summaries. What do you believe you know about this case? There was this one person who wrote out some pretty detailed information that they believed that that one of the McMichaels had been having that Ahmaud Arbery had been having an affair, and I'm using affair in a nicer way than what they put on the questionnaire, but had some sort of experience with the McMichaels' daughter, and that these guys were seeking revenge for that experience. So the idea, that would be the classic revenge, which comes out a little later, which we oppose. I think there would have to have been proof that there was knowledge of these people, not that you are using a video to identify an individual later on.
The state's position is that evidence of prior difficulties or lack thereof, which is why I'm assuming Mr. Bryan would want this, between the defendant and the alleged victim have been omitted for the sole purpose of illustrating, if it does, the state of feeling between the defendants and the victim and the reasonableness of any alleged fears by defendants or alleged victim. So in this case, we have self-defense, which is I was put in reasonable fear of receiving serious bodily harm or death by Travis McMichael. Well, there was a prior interaction between the two of them that he described in detail on February 11th, 12 days before the homicide. The state feels that it is very relevant that the jury know that evidence or lack thereof, they can consider it for the reasonableness of his fears or the reasonable apprehension of the victim, which of course, that's part of the aggravated assault charge. And of course, there's a cautionary sentence at the end: whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. So while Ms. Hogue may be correct in the sense that we often have I was afraid of him because I've known him for years and he beat me up in high school and therefore that was the nature of our relationship in the past, we don't necessarily have that here. We do have 12 days prior to this homicide and interaction, and I believe on on direct examination of Mr. McMichael, Mr. Sheffield had him talk about why are you breathing so hard? What's going on while you're making this 911 call? So I think that is appropriate to talk about the alleged fears of the defendants or alleged victim.
Judge, if I may add something, I kind of agree that this charge should be, and it's not the classic prior difficulties like in a domestic but if we could change one word, I think it would make sense for everybody. And instead of difficulties, which seems to imply they know each other, if we could change evidence of prior difficulties to evidence of prior interactions, a more neutral term, because they don't know each other. It's an incident that informs Travis McMichael and may inform Mr. Arbery. I think it would make more sense in this particular case.
I would suggest if we were going to do that, I have reservations about the charge, but the word instead of interaction would be encounter. I think that actually most accurately describes the state of the
I don't have
evidence.
a problem with encounter either.
Let me think it through, because Ms. Hogue, I think accurately points out, normally this charge is not, it's presented for the prior difficulties, not any indication of a lack of prior difficulties or interaction. Let me think that, I'll come back to that. Let me just think it through a little bit and see if there's some way.
And Your Honor, if this helps, I always enjoy charge conferences because I like the give and take, but I would withdraw my objection to it based on the arguments that I've heard. I do prefer changing the word difficulties because I'm not quite sure that matches in case.
Well, yeah, and that word is the word in this
Yes.
charge. So, and what I mean by that, not just that it sits in the pattern, but that is the defining word in the charge. I mean, it either works that way with that idea. My concern is changing the word changes really the nature of the charge too much. That's why I'm going to think it through. I'll come back to that.
All right. So with regard to our next section, which is identification, we have two sections. We have 1.35.10, identification reliability, and then we have 1.35.11, identification burden of proof. The court obviously noted that I did not put in the reliability one, and the reason for that is this is not a case of mistaken identity. It's not a some other dude did it case. It is not a case where we have anything in dispute. Officer Minshew showed up on the scene and there's photographs of all three defendants standing there. It has not been any sort of identification issue. They were all identified by law enforcement officers who took the stand, and Travis McMichael took the stand and said, yes, that was me, that's what I did. So this charge in the state's mind is not really appropriate because it really talks about the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident. We don't really have any of that. Possibility of mistaken identity, don't have that. Was the witness's identification influenced by factors? Well, this isn't an identification case. So the state only did the burden of proof because it is the burden on the state to prove their identity, and we believe we have done that. But this charge, 1.35.10, is really in an identification case, so we didn't propose it.
Well, and 135.11, so is that being withdrawn?
Oh no, 135.11 we feel has to be charged. So it's really 10, identification reliability, that starts on the bottom of page 10 and goes to the middle of page 11, that addresses identification by some person who may know or not know that person. But we do feel 1.35.11 should be charged.
Well, if we deal first with 1.35.10, we also had sought to ask that it be excluded. It does not seem appropriate.
And I added that in because normally it comes in and the pattern 13511 was asked for without modifications, so it wasn't terribly clear what specifically was being asked. I don't have any problem removing the identification, but if we're going to keep 13511, it needs to be tailored, because right now, at least what I understand, let me look real quick.
Well, can I throw this out, Your Honor? I think when we originally began the case, we were not sure what the state was going to be asserting with respect to who had been on that video the 4 other nights before. The state did draw back from that, even though you did not give a stipulation that it's Ahmaud Arbery. All of it's assumed, it's implied, it's assumed, and no one disputes that that's Ahmaud Arbery in the house on those other occasions. That's why I would have wanted to have an identification charge if there had been some dispute about it. But our clients are there on the scene, having called 911, the shots fired, and there the police come, and there they are, and they say, hey, this is what we all did. These are the roles we all took. This isn't a whodunit. So for that reason, I think identification just muddies the water.
We concur.
So are you proposing
None
both
of it.
10 and 11 to be out of it?
Yeah.
The state doesn't object, we'll withdraw 11, because if it, I just put it in there out of an abundance of caution, because in similar situations as this, I've had judges not read 10 and read 11, but we can take it both out on the consent of the defense.
Okay, 11 is out then. Which gets us to fingerprints. You'll see fingerprints was requested. I tried to tailor it to the evidence in this case.
Yes, Judge, and I think I had submitted tailored instructions on certain ones of these to tailor it to the actual facts of the case.
Okay. All right, I'm sorry. Go ahead.
And I think you've got it absolutely correct. I think this may be exactly how I tailored it. The state agrees with definition of crime, intent, parties to the crime. The state agrees with having A, B, and C, as D doesn't really apply in this case and has been appropriately removed out of 1.42.10.
I'm sorry, I was one step behind you, Linda. Can you just say where you just were?
Sure, I skipped over definition of crime, intent, and no presumption of criminal intent, as they all are patterned, and the state has no problem with that. I was confirming that the state is fine with, on page 13, 1.42.10 parties to the crime, where A, B, and C are fine, and we've of course removed D, as it does not apply under these circumstances.
Very good.
1.421.
Before we move on 1.42.10, having read what we used to call Kurtz, I don't see how C applies. Advising, encouraging, hiring, counseling, procuring, none of that took place. There's no evidence of any of that. It's either directly commits the crime or intentionally helps in the commission of the crime.
The state respectfully disagrees. Greg McMichael ran into the house and said, get your gun, come on, come with me. That is encouraging someone to come along, and counseled him in the car. Cut him off, do this, do that. So we have Greg McMichael advising Travis McMichael, counseling Travis McMichael, and encouraging Travis McMichael. So we feel that C absolutely applies.
Well, it might theoretically apply to the McMichael defendants. I'm not sure I could agree to that, but it definitely doesn't apply to Mr. Bryan, and I think the court needs to tailor the charge, bearing in mind that there is case law out there that would suggest upon request of the defendants that the court would separately charge as to each one. We haven't asked for that, but I do think here, given the importance of the issue to Mr. Bryan, the court needs to limit the application of the C to the McMichael defendants only, because there's absolutely no evidence and therefore nothing for the jury to consider as to whether he advised, counseled, hired, or procured someone else to do this. That is limited, if to any defendant, to the McMichael defendants. We specifically object to telling a jury that suggesting to the jury there's a factual basis from which they could find that Mr. Bryan could be guilty of murder or any of these other charges under subsection C, because he can't as a matter of law.
Well, Your Honor, that's for the jury to determine, and if the law doesn't apply to those facts, the jury will find that the law doesn't apply to those facts, because what they're going to do is they're going to look at the facts, and see if this applies. And that's their job. So to advise them on the law and go, well, this only applies under this circumstances, I think that might be the court commenting on the evidence, because you're saying, okay, it only applies here, it doesn't apply there. They're the finder of fact, and they'll decide which law truly applies under those facts.
That's fine, if that's really where the state wants to go. But Mr. Bryan is entitled under law for him to be charged with him. We could ask that all of the charges be tailored to him and then separately to each of the McMichael defendants. We have the right to ask for that. We're trying to be, I don't know, I don't want to use to say the word team player in dealing with the prosecution in a criminal case, but we're trying to work with everybody here. But it's unfair to Mr. Bryan to just throw that charge out there and let the jury think that that applies to him when we know that subsection C does not and cannot under these facts.
And we would object to the court indicating that subsection C applies, if it does, only to the McMichaels. I suppose the state could come up with, they'll have to come up with some argument if they're asking for party to the crime for Mr. Bryan, and they'll be making an argument either under B or C, or A, I guess. So if they believe that they might tiptoe into C with respect to their argument as it pertains to Mr. Bryan, then we wouldn't have to worry about separating these charges out.
Well, language, I mean, it's or language, so it's disjunctive. The court in its charge is never commenting directly to the jury on the evidence. We're simply providing the jury with the law that they then use the facts that they have determined and apply those facts to the law. Counsel will know what the law is, and if the position is there's absolutely no evidence that this is a basis for party to a crime, I'm sure that will be pointed out. I am concerned that if I start breaking this out, particularly on parties to a crime, given the importance of that legal theory in this case, that the court is going to start moving towards a line that I don't want to move to, which would be a comment on the evidence and what would be appropriate under the circumstances for each particular defendant. I understand what you're saying, how there could be separate charges, but under these circumstances, it's very clear, and I think actually the new charge makes it easier. I mean, you got A, B, and C. The argument is C simply doesn't apply to Bryan. That's an argument that can be made. I'll think it through, but I'm inclined to leave the charge the way it is.
And then principal failure to prosecute. Obviously, this is often used in a co-defendant case where only one co-defendant is here and the shooter's already been convicted and the getaway driver's on trial. The state put it in there out of an abundance of caution. I don't know if defense counsel objects to it or wants it in.
Doesn't seem to apply.
You're on principle?
Right, 1.42.11.
I don't think it applies either. The McMichaels do not.
Your Honor, the state's presented evidence, whether that was their intent or not, suggesting that other people were involved in this thing. Other witnesses, and I'm not going to name them by name, who, my understanding, had to hire counsel to defend themselves during this investigation. I think that, as I'm sitting here, and I'm subject to conferring with co-counsel, but you've had several witnesses testify and referenced in this case that arguably were a part of the same chase that the state is attributing to these defendants. I'm surprised the state wants to withdraw it, but I just asked the court, I'm going to confer with co-counsel, but I was kind of liking the charge.
The state's not withdrawing it. The state was asking if there was an objection or if the defense counsel were okay with it. And I have absolutely no idea what Mr. Goff is speaking about other people involved in this chase. So the state would like it in, but I didn't know what the defense position was on that.
Well, I'll leave it in for the time being. Mr. Goff, if we need to address it, we'll go ahead and address it.
Knowledge, obviously, should be included. Conspiracy, the state is asking for, on page 14, 2.02.1, 2.02.20, and 2.02.30. This is the law on conspiracy, and I understand that the defense is going to object to this because the evidence has been that there was no pre-planning beforehand where they sat down and had a meeting at somebody's house to determine what they were going to go ahead and do. And there's no evidence that they were in phone communication while all this was going on. However, the law is that there can be a tacit agreement. It can be a wink and a nod. There can be a, okay, you go this way, I'm going to go that way kind of thing. Because it actually says the existence of a conspiracy may be established by proof of acts and conduct as well as by proof of express agreement. The state's not contending express agreement here, but it can be established by proof of acts and conduct. And it's for the jury to consider. That's the exact line at the bottom. Whether or not a conspiracy exists in this case is a matter for you to determine. How do you determine? Presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances, if any, give rise to an inference of the existence of a conspiracy. The reason this is important to the state is because of the immediate aftermath. The immediate aftermath, meaning Greg McMichael going up to his son and telling him basically what to say. You had no choice, you had no choice. Going over and talking to Mr. Bryan and then coming back going, oh, he's got video about this. Going around and speaking to a number of people on the scene, inserting himself into the corner, trying to talk to an officer to find out what was happening. This presence, companionship, conduct, immediately after the commission of the alleged offense in the state's mind allows them to determine whether or not it gives rise to an inference of the existence of a conspiracy. And that is why we are asking for all of this, because that is something we are going to argue. Greg McMichael attempting to go ahead at the scene and talk to all of these people and insert himself into that part of the investigation to get his narrative out.
Your Honor, the McMichaels object to any charges on conspiracy. Number one, it was not included in the indictment. They were not charged with conspiracy. Number two, the things that the state really is seeking in their presentation of evidence throughout this case has been party to the crime, already strongly dealt with in 1.42.10. The court well remembers that there is evidence that there had been no communication, not even the existence of the telephone numbers or Facebook connection of the McMichaels to Roddy Bryan before February 23rd. Conspiracy is not proven, even if every single thing that Ms. Dunikoski is alleging, is arguing, is proven, it still is not a conspiracy because it was not any agreement to engage in illegal behaviors. There's nothing illegal about one going up to one's son and providing comfort. There was no evidence that there was any attempt to mess with, to change, to hide, to hinder the investigation, no attempts to change the videotape. Greg McMichael at the scene, realizing that there was a videotape and the police immediately getting the videotape, means that that videotape, as their experts testified, as their GBI forensic folks said, has not been altered in any way except for the cuts that the agent himself made in order to be able to review it and manipulate it in ways of slowing it down or speeding it up. There is no evidence of conspiracy after the fact if the communication between these parties does not involve a conspiracy for a common agreement concerning an illegal act. There's no illegal act or attempt to hinder the apprehension of anyone in this case or do any damage to the evidence or obstruct in any way. Now, you had looked at some of the, did you want to jump in?
Your Honor, we likewise object. We adopt the excellent argument made by
counsel. And I would point out to the court that I've been raising this issue constantly through this trial, that every day we go, the state brings us ever closer to requiring a severance to protect Mr. Bryan's rights. You know, whatever's going on between the McMichaels after the fact, there's just no evidence that Mr. Bryan has done anything after the fact that would justify this charge. And again, it's putting us in a position where the spillover from the McMichael defendants is going to deny Mr. Bryan a fair trial. Your Honor, I don't even understand conceptually how the state proceeds here. I thought, maybe I missed a day in law school, but I thought a conspiracy had like an agreement and an act in furtherance of it. What the state is doing here is conflating the two, that you don't have two separate elements, that they can say something is proof of an agreement that never existed, and therefore they can get this charge. It's just not tailored to the facts of this case. It's opening up a Pandora's box, Your Honor. The jury, they're going to be having the jury sitting back there thinking that Mr. Bryan is conspiring with the McMichael defendants because there's a video that the jury's heard that he made. And then how am I supposed to be responding to that? This is it's inappropriate. It raises a whole host of inappropriate issues. It's going to force us into a posture. Of course, I'll have to confer with Mr. Bryan over the weekend about it. It's going to force us into a posture to ask for a severance.
Your Honor, I'm going to cite to Carpenter versus the state, 305, Georgia 725. This is a Georgia Supreme Court case from April of 2019. Of course, it cites to Edge versus the state. It is not error to charge on the subject of conspiracy when the evidence tends to show a conspiracy, even if conspiracy is not alleged in the indictment, which we all know. In this particular case, the Supreme Court of Georgia said, listen, the totality of the jury charge is what the juries are considered. It's not in isolation. And here they said the instruction on conspiracy, the trial court charged the jury that the prosecution had the burden to prove every material allegation of the indictment beyond a reasonable doubt. You're going to give them that. And in this case, the trial court also charged the jury in connection with its instruction on conspiracy that a conspirator is responsible for the acts of other parties to the conspiracy only insofar as those acts are naturally and necessarily done to further the conspiracy. Obviously, that is right there in the middle of 2.02.20. So that is the same charge we've got. This, in Carpenter, the state's theory of the case was everyone was a party to a crime. In that case, the party to the crime had to be, was felony murder based on a marijuana drug deal, and then the subsequent armed robbery situation that ensued. And they also then cited to Ware versus the state, another 2019 case where the jury charges as a whole adequately informed the jury that the defendant could only be found guilty of felony murder if the predicate felony was the proximate cause of the victim's death, and the charge on conspiracy was not error. And in that case, to give conspiracy along with party to the crime, that was appropriate. So we ask that you go ahead and give the conspiracy charge, as it is not error according to the Georgia Supreme Court in Carpenter versus the state.
Even if the first two portions would be relevant, Your Honor, the state is pursuing two separate conspiracy theories. They're pursuing a conspiracy theory on the chase, and now they're pursuing an after-the-fact conspiracy theory on conduct afterwards. Your Honor, I would respectfully ask, if the court doesn't strike the entire conspiracy charge, that the court specifically strike 2.02.30, because that conspiracy is not supported by the evidence. It's basically, I mean, the constitutional implications of three people who are at the scene of a death and are arguably not free to leave and compelled to remain, to be trying to use that as an after-the-fact conspiracy, that is just wrong on a lot of different levels. If the court's going to give any part of the conspiracy, at least take out 2.0230. It's one thing to say that they want to argue a conspiracy to chase Mr. Arbery, however wrong that would be under the evidence, but to come back with this second alternate conspiracy theory, independent of that, which is highly prejudicial to Mr. Bryan and not adjusted to the evidence, that's just wrong. We ask the court not to allow that portion of the conspiracy charge.
All right, let me just think it through. I'm familiar with the law and the fact that conspiracy doesn't have to be alleged in the indictment. Clearly, it was not alleged in the indictment. I still have some concerns about what is being alleged as the conspiracy versus the state's theory, as I understood it all along, on parties to a crime. which is further muddied, I think, in this case by the fact that you've got a father and son, and so the whole contact and companionship charge, let me think it through, because again, this is one of these charges, I may not permit it as a charge as far as any arguments associated with conduct. Reasonable inferences made from the evidence may be the better direction, but let me think it through. So I'll take that under advisement. That's 2.021, 2.022, and 2.023. I'll come back to that.
Thank you, Judge. Venue is pattern. Now, on offenses charged, the defendants are charged with the offenses of malice murder, felony murder 4 counts, aggravated assault 2 counts, false imprisonment, and criminal attempt to commit a felony. That seems appropriate. And then malice murder is the new jury charge, which seems appropriate. State asked for motive, top of page 16. Felony murder, and that has the right 3 charges underneath it. And I think where we have causation, which is the pattern under 2.10.30, once again,
Should be the same 3.
it should be the same 3 of aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment as the 3.
It's on top of page 16. Yeah. We're catching up to you here.
Your Honor, with regard to motive, if we can start with that one, because I don't think there's any objection to the offenses charged per the pattern jury instructions. I am, as I sit here, I'm not aware of any evidence of motive submitted by the state, tendered into evidence in this case.
Correct, and that's why we want the charge, because it says the state does not have to prove motive to prove murder. So it prevents the defense from getting up here going, they didn't prove to you that he had a motive to do blah, 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 blah. The state doesn't know what's in the mind of Travis McMichael, Greg McMichael, or William Roddy Bryan, and we don't have to prove that they were motivated by one thing or another thing. What the state has to prove is that they committed the act. So we actually truly really want this to rebut any argument by the defense that, aha, they didn't prove motive, therefore they have not made their case, which is why this is always included. However, the state does feel that it did prove some motive, and that the state is going to make reasonable inferences about some motive evidence. And that evidence of motive is going to include Travis McMichael writing down the very first thing on his written statement is, my gun got stolen. And so motive is, I'm angry about my gun getting stolen. This guy probably stole it. And this is a reasonable inference the state is going to go ahead and draw, that he's angry about his gun being stolen. He wants to blame somebody, and this is a perfect person to go ahead and blame. So there is a reason to have this in there, especially since the state does not have to prove motive to prove murder. And we don't want the jury misguided, thinking, well, they didn't prove murder, they haven't proven motive, therefore they haven't proven murder.
Yeah, I mean, it seems to me the crime is defined as it's defined. There's a lot of things the state doesn't have to prove. Singling out what it doesn't have to prove emphasizes that. I'm not sure how the state's going to argue that the gun was the motive when the overwhelming evidence in this case is contrary to that, but that's their problem. Any evidence of motive has been admitted for your use seems to imply that evidence of motive has been submitted. Again, the state seems to be arguing both ways, that there was no evidence, they don't have to prove it, but yet there was evidence from this gun being stolen. So I would object to 2.10.12 being given in this case.
Your Honor, first, I object to the whole charge, 2.10.12, but even if you accept the state's argument about not having to prove motive, that's the first sentence. The second sentence about evidence of motive, I agree with the McMichael defense. I didn't hear it, and specifically in terms of Mr. Bryan, and again goes to whether he should have his own separate jury instruction, separate apart from the other defendants. There's no evidence of Mr. Bryan having any motive in this case. So if they want a limiting instruction based on the evidence they can articulate that I haven't heard yet on the McMichaels, that's one thing, but there's no evidence of motive with respect to Mr. Bryan. If the state has some, maybe the state would enlighten us.
The chart, it's an accurate reflection of the law. I think it covers a number of various things that the jury may be looking at. You know, one of the things about Georgia law and people's general lay understanding of the law is Georgia's position on motive. And I do think it's appropriate to charge the jury so the jury understands what Georgia law is on it. So I'm going to go ahead, I'm going to go ahead and keep it, having considered the objections of counsel.
Thank you, Judge. So aggravated assault,
Can we go back to 2.10.30? The line, you are going to be including the felony of aggravated assault, false imprisonment, and criminal attempt
To commit false imprisonment.
Okay, and are you doing ands or ors?
Let's see. You may find a defendant guilty of felony murder if you believe that he caused the death of another person by committing a felony. I guess it should be just in this language, by committing a felony, semicolon, as just previously charged. Aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment are felonies in the state of Georgia.
And should we just move the paragraph that you have, the second paragraph of 2.1020 down to that sentence then, so that you're not repeating it?
Yeah. And as I was writing that, I was thinking we're repeating it within a sentence of each other, so we'll just look at it. Well, actually, by committing, no, I think it is a separate thought, so let me think this through. I think the language probably in the 2.10.30 should be along the lines of, you may find a defendant guilty of felony murder if you believe that he caused the death of another person by committing one of the felonies just described. That covers it, and that way I'm not repeating it.
yes, Judge, that's fine.
Okay, so I'll drop in there. Okay.
The aggravated assault charge is acceptable to the state because it covers both instances we have here as we charged in the indictment, deadly weapon and object, device, or instrument when used offensively, such as the pickup truck. It also appropriately charges the two ways the state has let the defense know that the aggravated assault with the shotgun is to cause a violent injury to the alleged victim. The aggravated assault with the pickup trucks is to intentionally commit an act that placed the victim in reasonable fear of immediately receiving violent injury. And so the next page, topic 17, as to count 6 of the indictment, the aggravated assault was made with a deadly weapon. And that is count 6. I'm trying to do the math in my head. And as to count 6, material element of aggravated assault was made with the object, device, or instrument when used offensively.
I think you
That
just
is
misstated.
correct.
That's count 7.
That's count 7.
Yes.
Correct. And so the state is fine with how the aggravated assault is laid out. 2.20.22 is right out of the pattern charge. And then we have 2.20.23.1.
Which is actually the new pattern, I believe.
Right, and I failed to include it obviously because it's the new pattern.
But I do think the court added that because it's being charged both ways, so it needs to be both sets of charges.
Correct. And the state is fine with that particular pattern charge. 2.26.1 is, of course, the statute. Attempt is also 2.01.10.
Hold on. Coming back to the aggravated assault, I submitted an aggravated assault charge that was considerably different. Doesn't look like much of it survived the process so far. But, you know, we did, and I resubmitted it today, a special instruction on unanimity, an excerpt from the previously submitted one. There's nothing in here that adequately addresses the requirement for unanimous verdict in the context of the aggravated assault charges, which is why that was submitted today. Also, Your Honor, we would contend that, and we've resubmitted today, the subsection that I would now refer to as last clear chance. I think that when you're talking about an aggravated assault, the motor vehicle in the context of a chase, I think you need to charge a jury that in that context, you need to consider whether the defendant, whether the deceased effectively had the last clear chance to avoid contact with the vehicle. If this is in fact a citizen arrest case, if I misspoke, feel free to.
No, that's me clearing my throat.
I don't know if that was some kind of secret code, but I just want to be sure. All right.
It's an allergy code.
All right. Your Honor, in a chase case in a citizen arrest, if someone pulls their vehicle up ahead of somebody, in that context, it's different than if they're just going down the street and somebody comes out of the blue. And that, of course, gets to issues I know the court doesn't want to get into. But I think in this case, the jury needs to be charged that if Mr. Arbery could avoid contact with the vehicle, whether he's legally required to stop or legally required to step off the road, when he has the last clear chance to avoid the contact with the vehicle and he doesn't exercise it, then the defendants can't be held responsible or can't be held liable for that. I mean, I don't understand why a principle that makes perfect sense in a civil context has no application in this one. Now, if the state's theory is that, you know, that this was a revenge thing, I mean, I think there's still a charge we haven't gotten to yet about revenge. I mean, that's certainly one thing, but from Mr. Bryan's perspective, he doesn't know this person, there's no relationship with him, he's not even there on February 11th. I think a jury needs to be able to consider whether Mr. Arbery reasonably thought he was in fear if he thought that Mr. Bryan was trying to attempt a citizen's arrest or assist in a citizen's arrest. That's a very different context, and with all due respect to Ms. Dunikowski, there are no prior Georgia cases, none whatsoever, that address the application of an aggravated assault with a motor vehicle in this context. The only case that's even remotely close is the one cited by this court in denying the special demur. And when you go back and look at that case more carefully, there's a lot more going on there than a motor vehicle. The person's actually struck with the motor vehicle, if I recall, flips over the front of the vehicle, and ends up being stabbed or stabbing well, I can't remember, the driver stabbed him or he stabbed the driver. Clearly a very different context. And I'm asking the court give the portion that I've resubmitted today, in considering whether one or more of the defendants attempted to commit a violent injury with a pickup truck, you may also consider whether the danger associated with the operation of the pickup truck and the resulting fear, if any, was avoidable. That is to say, contingent or conditional on the voluntary actions of the deceased. If the totality of circumstances established that the deceased could reasonably have avoided the danger and attendant fear associated with an allegedly assaultive act by his own conduct, whether by stopping, slowing down, leaving the public street or highway, running to the lawn, to the neighbor's house, jumping in a pool, climbing up or beside a tree, or other object, you may consider whether Mr. Arbery had the last clear chance to avoid any such danger and contributed to that danger by his own conduct. And again, that kind of gets to the heart of what this case is about. This is, as I understand, the state is contending this was an unlawful citizen's arrest. And Mr. Arbery is assumed ignorance of the law is no excuse. He's supposed to know the law just as well as everybody else who was out there that day. And to say that conduct that otherwise might be viewed as creating a fear, in that context, if Mr. Arbery could reasonably think these people were trying to stop him or detain him, pursuant to the citizen arrest statute, then yeah, he has a duty at some point to get off the road. Yeah, let them go to jail for false imprisonment if that's what's going on. But to be charging them with an aggravated assault that he could have avoided by submitting, that is not adjusted to the law. And we need some kind of charge. That's the best I've come up with. I'll defer to co-counsel if they've got a better way to handle it. But we've got to address the fact that this supposed chase with these motor vehicles is in the context of a citizen arrest. And that's very different than the context in the case that Your Honor cited in his order, which if I recall, there was I think it was a prior difficulty. It was either prior difficulty or they had no prior relationship. The person had no reason to know what was going on. That's very different from this context. Mr. Arbery knew what he did that day. He knows the conduct that's reflected on the videos. And under those circumstances, I think the court has to do something more than simply charge the jury with the statute and let the jury try and sort it out. And certainly, if questions start coming back from the jury, better that we address this issue today and over the weekend than be sitting here in real time while the jurors are coming back with a question, which is reasonably foreseeable, and then we're going to have to find a way to address this issue. Or, as we apparently plan to do with so many other issues, when the jury comes back and asks a logical question about gaps in the law, we're just going to tell them that's all we can tell you. This, somehow, some way, we need to be addressing that the aggravated assault statute in the pattern charge does not address the facts of this case, and it needs to be adjusted to them.
So you referred to something that was filed this morning. I don't have that. Was I provided a copy of it?
There was no courtesy copy. The original copy filed in the courtroom with the clerk this morning is what I'm referring to.
Okay, I haven't seen it. I'll go ahead and look at whatever was filed.
Thank you.
State disagrees completely, as there is no supporting case law here, and there is no duty to retreat. The victim of a crime is a victim of a crime, and to allege that the victim contributed to his own victimization by not avoiding the criminals enough, that's not the law for aggravated assault, Your Honor. So we totally disagree with what was handed to the state this morning. Defendant's request to charge, it's the first page unnumbered and the second page unnumbered on unanimity. You are going to charge the pattern on unanimous verdict, and that is sufficient.
And for the record, Your Honor, all I've done is break down paragraphs of charges already submitted to the court. There's nothing new there. These are simply broken down so that on appeal, we don't wind up in the posture, well, you know, there's a three-page instruction submitted and one portion of it isn't quite right, so we're not going to present any of it. That's why I've resubmitted the same things broken down the way they are. So there's no surprise here to the state.
Your Honor, can we have a comfort break before you go to the next?
Yeah, let me make sure we're all where I understand we are. We have just addressed these arguments on aggravated assault. It looks like we had touched on false imprisonment being the pattern and attempt being the pattern, which then got us to the top of page 18. That's where I understand we are, and that's where we'll let's go ahead and take a 15-minute recess.
Thank you, Judge.
Thank you.
Stuff sometimes. And if I touch the printer, that's a sure way to make it jam up.
It's like anybody touching the screen here. All right, we're back on. So it took me a little bit longer to get back on. I was getting a copy of the request to charge, Mr. Goff, that you filed today. I see you filed another motion for mistrial.
A motion a day. Not literally.
Flipped way, but
This is actually a different motion for mistrial. I wouldn't file the exact same thing. That would certainly try the court's patience. This is a legal theory not pursued in the Musladin case that's been previously referenced, although these two cases are cited.
well, let's go ahead and take it up then. Let's get back to the charge. charge in just a moment. I didn't realize I had another motion for mistrial, which needs to be addressed on a timely basis, so this is the first time I become aware of it. I'll go ahead and see, Mr. Goff, what you have.
Your Honor, we cited Moore v. Dempsey and Frank v. Mangrum. Their case is cited footnote in the Musladeen case, but we're filing this motion for mistrial based on inherent prejudice in the proceedings in the case. I have recounted, incorporated in all the previous issues that have been brought to the court's attention. I have added information, I believe, since the last time we addressed the court on the related motion. And I have also added in a couple more articles relevant to this matter, and I have attached the photograph that I took yesterday. I think that's Exhibit 1 of what the demonstration looked like yesterday on the lunch break from the steps at the top of the foyer to this courtroom. And you can see, Your Honor, that not only are the individuals participating in this event well within the First Amendment perimeter that we had requested at the beginning of the trial, they're well within what I understood to be the court's parameters for that. You can see speakers. I can't identify them from behind and their views obstructed, but they are the speakers at yesterday's event who are apparently several well-known, nationally revered figures in our country, speaking literally at the front door, I would guess 5 to 8 feet, probably 7 to 8 feet, beyond the front door to this courthouse. I see what looks like a microphone stand in between them. They are literally, you can see the gentleman to the rightmost gentleman is literally standing next to the pillar of the courthouse, Your Honor. This is an event that is literally at the courthouse door with more people than I can count outside. We have police barricades, but even the barricades themselves are barely go past the flagpole. Your Honor, in the attached articles, it's 2 and 3. We've got multiple Black Voters Matter signs outside. We've got a T-shirt. I can't read in this picture, but I'm sure it's not flattering of Mr. Bryan. We have another article that's attached, which has, of course, we also have a bunch of folks here that have been referenced previously in this case. But in the next article, we have the Black Pastors Matter sign outside the courthouse in an article about the same event. We have another picture from a different angle, and again, you can see, Your Honor, that the police barricade barely goes behind the courthouse flagpole. And again, you can clearly see you've got people up on the courthouse steps during this event, literally standing. It looks like one of them's leaning against the middle courthouse pillar in this case, for this courthouse, Your Honor. And you have Pastor, and that's Exhibit 4, you have Pastor Jamal Bryant, a revered figure in both the liturgical community and the community at large, calling for a prayer wall against racism amid the Arbery trial. I can't say that I was outside. I don't know if they completely ran around the courthouse as they intended, but clearly, again, there's a lot more going on here than ministry. This is advocacy against our client, and it's troubling. Directing your Honor's attention to Exhibit 5. This is a picture, which I don't know why the printer is not better than it is. It's brand new. But Your Honor can see, and I'm sure Your Honor has been seeing through the trial, the public gallery, we know that the first pew is cordoned off for security purposes. And then we have 2 other full pews or benches, and then we have a partial bench behind it. The picture is taken from the second seat on the front row of the jury box. I think it was yesterday. And it's very clear that that location, which is where Juror 380 sat for much of the first week of the trial, I've lost track of where they all sit. They changed from recess to recess. But it's pretty clear that pretty much everybody in the jury box, which is, depending on the time, 9 or 10 out of the 12, have an unobstructed view of the gallery in this case. Now, you know, I have asked the court, and I understand, there aren't a lot of cases on this issue. And the Supreme Court itself, although it's given an indication, several of the justices on the First Amendment issues, they are technically open. So it's not that I don't appreciate the struggle that the court has in dealing with all this, but we have several jurors who would seem to be subject to influence or intimidation just by the comments that were made during the jury selection process. And particularly, Your Honor, we have an issue with Juror 380 at this point. I don't know what to do about it.
Well, I've read the motion, I've seen the facts, and you don't need to go over it.
Then I won't. But I have made it, filed the motion for the record. I stand on the argument that was presented. I would ask the court to grant a mistrial of this case based on the inherent prejudice to Mr. Bryant.
From the remaining defendants. Understand. Hearing nothing.
Yeah, I think what we were just discussing, Your Honor, is that the court has made us aware that you're checking in with the jurors, and you're doing that regularly. Obviously, you can't do that today. But by Monday, we would hope that the court would again check in with the jurors to make sure that nothing has happened over the weekend where they may have learned about this, got notified about this, and feel a certain way about it, by simply reminding them to talk with you should they have seen, heard, or gotten some information. And at that time, if the court reports back, then we might have something to talk about. Your Honor, on behalf of Greg McMichael, we take a similar position just expressed on behalf of Travis McMichael. Our position is that the First Amendment assembly of these people to say what they wish to say is nearly sacrosanct. We have no issue with it at all. Our concern, as just expressed by both counsel for Mr. Travis McMichael and Roddy Bryan, is whether it is having any influence on our jury. And right now, I don't know if it has or hasn't. I take it that we're depending upon the jurors to self-report each day based on the court's instructions to them each evening. I hope that's sufficient. But if after the verdict comes in, if there is a verdict, and we find out that jurors were exposed and didn't report it, it could create problems then on appeal from any conviction. But right now, we don't have any facts upon which to base the motion for mistrial based on jurors being influenced by the public, though it does concern us. So the balance between their freedom to say what they wish, which we respect, and our right to a fair and impartial jury, uninfluenced by outside forces, is what's at stake here. And again, we just depend on the court's authority to inquire of them whether they have been exposed and influenced in any way by anything that's going on outside this courtroom.
May I add one more question? Yesterday was the first day where there was, really the first and only day where there was a larger crowd and bullhorns. The idea that a juror could hear that during deliberations is of great concern to us. And so we're perhaps inquiring, and it doesn't have to be done here in open court, that the court also is aware that if those sounds could come into the courthouse, that they'd be prohibited.
So I'm not going to say where the jury deliberation room is, and because I think that just creates the possibility that folks could try to figure out where in the courthouse would be appropriate. I will tell you that whatever was going on outside yesterday, and I think you're right, yesterday was a significantly larger crowd than we've seen most days. I don't recall any disruption in the courtroom itself. Where I was for the day yesterday, I did not hear what was going on. I'll make sure that we check and make sure that there isn't any outside influence that is or could potentially affect the jurors during deliberations. I think that's an appropriate step, and I'll go ahead and do that from the state.
Thank you, Judge. We ask that you deny Mr. Goff's motion for mistrial. There's absolutely no evidence here that the jurors have been influenced in any way by the first and only larger crowd that came yesterday. No evidence that they even knew it was out there. No evidence that they have been intimidated or influenced in any way. Mr. Goff then says witnesses are subject to intimidation as well. No evidence has been presented of the witnesses coming into this courtroom having been intimidated in any way, shape, or form. And then he brought up the court itself and intimated that the court might have been influenced by all of this.
I object to that. As a mischaracterization of the motion.
It's on page 6.
Yes, I'm aware, I wrote it this morning. It doesn't say that. It says that the concern is that people are attempting to influence the presiding judge. That's not saying that the judge is being influenced, but I'll come back to that when I have the last word.
Your Honor, Mr. Goff is a brilliant lawyer. These briefs that he has filed are detailed, and he has filed a ton of pretrial briefs that the state has had to respond to. He is very, very smart. He is very, very calculating, and he's a good lawyer. Because on November 12th, he stood up in this courtroom, knowing full well he was on television, and made comments about Al Sharpton and then black pastors and Colonel Sanders, all knowing full well it was being broadcast on television. That was not ineffective assistance of counsel by any stretch of the imagination. That was strategic. He got the response he wanted because he has filed a motion a day based on a continued drumbeat of, well, see, people are coming and people are responding, but they're responding to what he did. They're responding to what he strategically, knowingly, intelligently did so that there would be a response so that he could then complain of it. That is good lawyering right there, because now he's motioned for a mistrial based on something that he caused. You cannot insert reversible error into the case yourself. You can't go ahead and do something and then go, oh, well, it's reversible error when you're the one who did it. But he is attempting to go ahead and do that, which, by the way, once again, not ineffective assistance of counsel, brilliant lawyering, and we ask that you deny his motion for mistrial.
Of all the things I've been called all around the world of the last month, I don't think brilliant was any of them. But let's take this up, Your Honor. The motion was legitimate. I didn't ask for anything that wasn't done in federal court 30 years ago. Because it was intuitively obvious then that it's a problem. It's intuitively obvious today that it's a problem, and it has been. The idea that a lawyer standing up to defend his client with appropriate motions made in a courtroom somehow can waive the client's rights by having raised the issue, that's a troubling concept, Your Honor. And let's be clear, this motion is not a motion to recuse. We have never filed a motion to recuse in this case. We've never even suggested that the court should do so. We've asked all the court officers in this case to disclose any basis that might arise, and we assume that when we don't receive information, that there's nothing to discuss. That's not the issue. The issue is the attempt of people in the media, or people using the media, particularly people that are associated with the Arbery family or their lawyers, whoever it's coming from, however it's coming, there is pressure being exerted on these jurors. There's pressure, consciously or unconsciously, being put on witnesses. There's pressure, conscious or unconscious, being placed on this court. That is the problem. It doesn't matter whether the jurors are being influenced. It doesn't matter whether the court is being influenced. It doesn't matter necessarily that the witnesses are being influenced. but it does raise serious questions about the propriety of the proceedings and the integrity of the process itself. It is unfortunate that this case raises in a way that maybe hasn't come up before, with the activities of third parties. Now, I'm not saying that the state had no role in any of the stuff that's gone on in media frenzy or the GBI from the beginning of this case, but obviously much of what's happened is the result of third-party activity in this case, spectator activity, for lack of a better phrase. The state's fundamentally mistaken, and I think the court is not giving full credit to the argument that's being made here. Yes, if there's actual prejudice here, if the jurors are all staying up saying they can't be fair, if Your Honor were to stand up saying you couldn't be fair, if a witness were to stand up saying I can't feel like I can tell the truth, that would be actual prejudice. And we wouldn't be having this discussion. The court would, on its own, sua sponte, be taking appropriate action to ensure the rights of these defendants. I have no doubt about that. The question here is inherent prejudice. That does not require any affirmative activity in the gallery. It doesn't require any affirmative statements of jurors or anybody else. The argument is that it is inherent prejudice. Now, this is not 1915. This is not 1923. There are not thousands of people outside with pitchforks in baseball bats. But I would respectfully submit to the court that this is the 21st century equivalent. This case has been infected by things that have nothing to do with the guilt or innocence of these defendants, largely without as far as I can tell, it's not like the state is out there during this trial giving press conferences or something, but still, third parties are influenced in this case. They've been doing it from the gallery in this courtroom. They've been doing it outside. This is what a public lynching looks like in the 21st century, with all due respect. They don't have to have 10,000 people outside. They don't have to have 100,000 people outside. Perception is reality. We have sealed these jurors off. We hope we have. We have sealed them off. And it doesn't matter how many people are outside. It doesn't matter how violent they appear to be. It doesn't take much. And you've got witnesses and you've got jurors who are worried about their careers and their livelihoods when this case is over. And they'll be aware of what's going on. They certainly were aware of it before they got here. They talked about it during the voir dire process. Just because they haven't put a gallery up, they haven't put a podium up outside with a hangman's noose on it, doesn't mean that this isn't a trial, despite the best efforts of this court. This isn't a trial that's been infected by mob violence of a woke left mob. And whether people realize that they participated in that or not, I'd like to think that the vast majority of the people outside this courthouse really have no interest in anything but justice. I want to believe that. And from a lot of the people I know out there, I think that's true. But the perception is the reality. And the media have fed that perception and created a reality, whether it's true or not, just like other people have created a false narrative, and the falsity of that narrative has been made very apparent through the trial of this case. That becomes the reality. This is what a mob-dominated trial looks like in the 21st century, and we're asking for the mistrial.
All right, the court, having heard from the movant as well as the parties, denies the motion for mistrial. I think the court's position has been accurately stated previously. I thought it appropriate, given the mistrial filed, that we have it on the record. We're going to take a lunch break. We're going to be in recess for an hour. Thank you. Anybody have any idea where the remaining collection of souls could be?
We can proceed without Mr. Sheffield. We didn't. I ran out just right before the first day we had to go to lunch. We didn't think we'd go to the lunch house. And the district attorney's office didn't offer to share any portion of their lunch.
My micro cell? That would have worked.
Somebody share a cookie with me, briefly.
Yes, yeah, a little bit.
Yes.
Yeah, we can proceed as well.
My sincere apologies.
Okay, we're back on then. All the defendants present represented by counsel. We were on page 18 with the state.
Thank you, Judge. All right, page 18, at the top we have conjunctive, disjunctive, which actually is the pattern 1.4015. And the state just requested that it be specially tailored, and the court is correct. It is both count 7 and count 9, where we have an and, which of course in legal terms for demurs means it's an or. So what we have is on count 7, did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck or a Chevy Silverado pickup truck, an object, etc. And then we have count 9, which of course is in violation of the personal liberty of Ahmaud Arbery, did unlawfully chase Ahmaud Arbery through the public roadways of the Satilla Shores neighborhood in pickup trucks, and did attempt to confine and detain him without legal authority on Burford. And that is under criminal attempt to commit a felony. So we asked for the conjunctive, disjunctive on both counts 7 and count 9. And then we have the affirmative defense, of course, justification, and then the statute 17460, grounds for arrest, citizen's arrest. Now, when we get to the bottom of page 18, we have right and duty to execute a citizen's arrest. The state objects to this particular charge. This particular charge provided by the McMichael defendants cited to Long versus the state.
Hold on a second, let me get there.
Sure.
Sorry, grab the wrong one. Hold on. Which number was it?
This is their request to charge number 3.
Got it. Okay, go ahead.
All right, so what we have here is we have something that says it is not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon, and after a felony is committed, any private person may arrest the felon with the same view upon reasonable and probable ground of suspicion of his guilt. That is what they have requested. The problem is, Judge, they have based it on a case that doesn't apply to the facts as we have them here, and that is Long versus the state, 12 Georgia 293. It's from 1852. So Civil War was over 1865. Women got the vote in 1919. So this was in 1852. The thing about this case that's really interesting is that it's kind of the first bribery extortion case. So what we've got is we got a guy, and he's in a wagon, and he's got wagon wheels behind him, and he's going down the road, and these guys jump out, and they go, aha, you have the stolen wagon wheels. And he goes, you know, I didn't steal these wagon wheels. They're like, yes, you stole the wagon wheels. We're going to take you to jail. We're going to take you to jail. And he's like, no, go talk to this other dude. He knows that I didn't steal these wagon wheels. And they kept going, we're going to take you to jail. We're going to take you to jail. So after this goes on for some time, they said, except if you wanted to pay us off, maybe, we won't take you to jail. So they go to his house. He goes ahead and pays them off. If the court looks closely at the case, you'll find exactly how he paid them off, which is highly unusual, and I won't mention it here, but it's distasteful. And he pays them off. So they go ahead and they go off. and they tell him, you got to get out of town now. Instead, he goes to the sheriff and he goes, hey, sheriff, these guys just robbed me by intimidation because they said they were going to throw me in jail and they were going to arrest me and they were going to do all these things because I committed this crime of having stolen wagon wheels, which I didn't. But instead, they said, well, pay us off and we'll go away. You just have to get out of town. So the men who are actually on trial in Long, the guy Long, he's actually one of the men who was extorting money from the victim. And what the court said was, hey, if you're going to go ahead and do a citizen's arrest, Defendant Long, it's not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon, not extort the felon. I mean, if you really think they're a felon, you can't go ahead and extort them by going, well, if you don't want us to take you to jail, why don't you pay us off? And what the court held there is that that is intimidation, and it's illegal, and they were convicted. Now, the Long case is cited in 81 cases here in Georgia, but it's always cited for the proposition of intimidation. It's kind of the statement of this is what intimidation is all the way back to 1852, where you cannot basically act in the capacity of a citizen's arrest. I mean, here we are in the middle of Georgia. There is no police force. It's 1852. We're talking wagon wheels. We're talking a guy riding horses with a wagon. So at this point, the court's going, if you're going to arrest somebody, you arrest them. And that's where this dicta comes from. It's not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon. It has nothing to do with, hey, regular citizen, you are at the Shell gas station, and there you are, and you witness a carjacking. You have a duty to go over and arrest the carjacker. Okay, we all know that there's numerous carjackings, murders, everything else that happens in front of a whole bunch of people, and those people all run away. They don't bother to arrest the gun-toting armed robber or the gun-toting carjacker. So this is not actually what the state of the law is. There is no affirmative duty on a citizen who witnesses any sort of crime, a murder, a rape, an armed robbery, an aggravated assault, to affirmatively go and arrest that person. None whatsoever. So, number one, there is no affirmative duty on a private citizen when a felony is committed to apprehend the felon. That is not the state of the law right now. In addition, this is based on a case from 1852 that was saying, once again, hey, if you're going to act as law enforcement, if you're going to go ahead and make an arrest, make the arrest. You don't get to extort money from the person you're threatening to arrest. Now, this defense is probably going to come up here and go, well, it was cited in Johnson versus Jackson in 1976. And it was. But that case actually was a law enforcement officer who's pulling up in his driveway. And there's a strange car there, and there's two strange guys, and they're coming from his garage. Turns out they're brothers. So he gets out of his car, it's dark out. He's like, hey, what are you guys doing? What's going on here? In traditional fashion, they both answer at the same time with completely different answers. So he's very suspicious because, hey, they've come in from his garage. He doesn't know them. They're here. He doesn't know what's going on. They immediately bolt and try and run him over with their car. So they go and they run him over, or try to run him over with the car. He, of course, home from work, he's a law enforcement officer, pulls out his gun and goes ahead and starts shooting at him. What happens? He shoots one of them in the back of the head through the rear of the car. This particular case is actually a civil case, all right? At issue here is the relation between landowner and burglar or felon, the owner's right and authority to arrest the felon, and the allowable force and effectuation thereof, and the duty owed by a landowner to one who is there for the purpose of committing a felony, all of which is for the determination of the jury. But once again, remember, this is a civil case. This is a man who is at his own personal property and sees them going into the garage and starts questioning them. They then try and run him over with the car, and then he shoots and kills one of them. He was sued by the parents of the young man who was shot in the back of the head, fleeing. So, while trying to identify the two strange men unlawfully on his property, Jackson was violently assaulted when Johnson swerved his automobile to strike him, causing Jackson to fear for his life and also making it impossible for him to read or take down the license tag number of Johnson's car, of course, as he went away. So this is the most recent case that actually is sort of on point. And they go ahead and they then cite to, I'll find exactly where they cite to it. They cite to Long over here about it is not only the right but the duty of a private citizen when a felony is committed to apprehend the felon. And they go on to cite that. In addition, they then cite to another 1890 case and then a 1926 case that a private man has quite as much power to arrest a fugitive felon where the emergency calls for immediate action as a public officer, and while doing so is equally under the protection of the law. So that case really is not similar to this case at all. I think that this is a misstatement of the law as it applies to the facts of this case, and the support for it, these two cases that they cite, one of being a civil case from 1976 with the U.S. Marshal in his driveway, really doesn't have the same facts that we've got where it's a duty of a private citizen. So my fear, of course, is that charging them on this law, the defense is going to get up here and go, well, he had no choice, he had to do it, it's his duty to do it. It's not only the right, but the duty of a private citizen, making it seem as if there's consequences to him if he doesn't do it. There are no consequences to him if he stands in his driveway and does absolutely nothing. But this charge actually makes it seem, and they're probably going to argue, that there was some sort of duty, therefore some sort of consequence to him, which is not the law. We ask that this charge not be given.
All right, that was a McMichael's request.
Allow me to retort. If I may say, speak from a seated position here, now I have notes and computer and all that. Well, the Long case is, in fact, the first case in Georgia's history that cites the citizen's arrest statute. And it cites it in the exact same wording that it existed in our state up until 2020, when it was modified and changed very much. The fact that it's an 1852 case shouldn't count against it. I think count one is murder, which goes back to the Code of Hammurabi about 3,500 years ago. So the age of a law makes no difference to it. And I find it of interest and like to add this for the court in considering this statute, that the Georgia Supreme Court didn't come into existence until 1846. So we were only 6 years into the existence of the Supreme Court when Long was decided. And Long was, in fact, a citizen's arrest case. That's the defense that was raised. And it was very well analyzed in that old case. And I also would like to point out, too, for the court, that many people confuse the citizen's arrest law by calling it a Civil War era statute, or sometimes we've heard it referred to as a slave catching statute, both of which are false. The reason it's called Civil War era statute is because Georgia codified its code in 1863, as we all know. That was the first code of Georgia. And the statute that the code included on citizen's arrest in 1863 had been in existence since the year 1215 in the statutes of Winchester in England. It was then English common law, was brought to the colonies. It existed in its present form in the colony of Georgia, and then when we became a state, it was in our laws, as all of our laws were then, scattered in pamphlets and cases and statutes until we got it all collected, the first state in the nation to collect all their laws in one place and call them the official code of Georgia. And that was 1863. Now, jumping forward then to 1976, the case Ms. Dunikowski just mentioned, which is Johnson v. Jackson, 230 Southeast 2nd, 756, or 140 Georgia Appeals 252. It's a 1976 case. I'd like to read a paragraph from it. It cites the statute as it existed in 1976 in the exact same words it existed in 1852, as well as it existed in 1730 when Georgia became a colony, and 1787 when we became a state. Same wording. And then that case, Johnson v. Jackson, goes on to say this: It is not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon, and after a felony is committed. Any private person may arrest the felon with the same view upon reasonable and probable ground of suspicion of his guilt. This 1976 case is citing Long v. State from 1852. Then it goes on to cite, a private man has quite as much power to arrest a fugitive felon where the emergency calls for immediate action as a public officer, and while so doing is equally under the protection of the law, citing Croom v. State, an 1890 case. And then it goes on, and he apparently has the right to arrest under certain circumstances in order to prevent a felony from being committed, which felony has not yet been attempted, citing a 1959 case. And after citing those cases without overruling any of them, of course this is the Court of Appeals, but it didn't go up to the Supreme Court, none of those rules have been overruled. They go on to say of Jackson in this case from 1976, this is the U.S. Marshal who was off duty, came home, found the two brothers sitting in an idling car in his driveway with his garage door partly open. Based on those circumstances, he wondered, what are these two guys up to? So we inquired of them, why are you sitting in my driveway in an idling car and I can see my garage door open? And that's when, after one of them gave him his wallet, they drove off and he fired 2 shots at them and killed one of them. And so this was a civil case for wrongful death. And the court says Jackson, the off-duty U.S. Marshal, attempted to make a citizen's arrest. And this is right after what I just read, the paragraph I just read. Based upon what he saw prior to the assault and flight of the deceased, which resulted in the fatal shooting. What are reasonable and probable grounds for suspicion is for the determination of the jury, as is whether the circumstantial evidence was sufficient to establish the commission of a burglary. That's the crime he suspected, was burglary. The questions of whether the force used was reasonable or whether the killing was under the circumstances necessary, because he raised a self-defense claim, because the car hit him and knocked him over. And so the analysis is very similar to here. It converted from an attempted citizen's arrest into self-defense when the car nearly ran him over. And so they were saying under either situation, those circumstances likewise are to be submitted to the jury. So while Long is an old case with a very convoluted and fascinating story behind it and an interesting history, it's still being cited all the way up into the 1970s and beyond. And it's never been overruled. And it basically just states what ultimately became the code of Georgia anyway, and the statute that we're operating under. But the language that we've taken from the case is still good law, and we defend it and ask that the court give it to this jury.
All right, the request number 3, which adds the right and duty language. The court finds actually the statutory language, which is right above 17460, covers citizens' arrest. As to these cases, they're addressing circumstances that were before the court at this time. I think the statute it's either the original statement, depending on how you look at the history of it, a restatement, but it is an accurate reflection of the law. The added language about the duty of a private citizen, the court's not going to charge on. So again, we're just going to stick with the language of 17460, which is that charge above. So of course not going to, and the exception to the objection to the charge is noted.
Your Honor, while we're talking about the citizen arrest statute, Your Honor, I have a continuing disagreement, I think, with co-counsel on the statute. The first sentence of the statute covers any offense. The second sentence covers felonies. So effectively, the first sentence covers misdemeanors. And there is no misdemeanor here to discuss. Either Mr. Arbery committed a burglary on February 11th, or he committed a burglary or committed a burglary on February 23rd, or he committed no crime at all. If the felony that you're intending to commit if the crime that you're intending to commit when you trespass is a theft, it is a burglary. So there is no factual basis in this case for charging the jury about arresting someone on a misdemeanor, which under Georgia law has to be within the presence or the immediate knowledge of the person making the arrest. But there is no misdemeanor that would justify the actions of the McMichaels on the day in question, or Mr. Bryan. So it is inappropriate to charge that first sentence of the statute, but it's not supported by the facts of the case. And that leads us to the problem that we have on the next page with making an arrest contemporaneously. Now, I've already submitted argument to this court and a charge a long time ago, and I know the court's aware of it because the court, I think, borrowed some of it in what the court has put together. But there is absolutely not a single case in the state of Georgia that says that a felony can only be arrested immediately. That time, that proximity in time, there is not a single case in Georgia that says that in a felony case. So why are we including, the only reason we're including that language is because it ties to the first sentence in the charge on the previous page that doesn't apply to this case. There's no reason to be charging the jury about arresting someone for an offense in his presence or immediate knowledge. The second sentence, felonies, is what applies, and therefore there's no reason to be giving this charge requiring a temporal proximity between the observation or the development of the probable cause and the arrest. I mean, I'll let Ms. Donikowski argue. I mean, to me, this is a huge deal in this case, and it's unsupported.
Your Honor, if I may, I think Mr. Goff has moved ahead to another jury instruction, so if we're,
Let's keep on track.
yes, if we're
Trying to
heard
do
on
this in
that.
a linear fashion so we
Thank
don't
you.
bounce all over.
Oh,
Let's, when we get there,
okay.
well, and we're almost there.
Oh, I thought Mr. Goff was actually talking about 17460.
I was simply pointing out the connection between the one I started with and the one behind it. But technically, we're talking about 17460, 2/3 down page 18.
Okay.
That
In
was-
that context, then, go on.
Above the right and duty to execute, but that we would like to be heard, we have a very different opinion of that.
So regarding 17460, to address Mr. Goff's concerns, first off, Mrs. Hoag is absolutely correct. Frank Hoag, Mr. Hoag got up in opening statement and said, totally agreed with this statute. That's what he actually talked about in opening, that a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. It does not distinguish between felony and misdemeanor. So the first assertion by Mr. Goff is, well, this applies obviously to misdemeanors. That's not at all. It says may arrest an offender if the offense is committed in his presence or within his immediate knowledge. It then says if the offense is a felony, and Mr. Hoag actually, I believe in opening said, yeah, that offense has to be committed in the person's presence, and the offender is escaping. So this sentence has two things that have to happen. So it can't be a misdemeanor and he's escaping. It has to be a felony and he's escaping or attempting to escape. A private person may arrest him upon reasonable and probable grounds of suspicion. So the state asks that you put this charge in and do not take out the very first line, because the assertion that Mr. Arbery committed no crime or committed only a burglary, that's not for him to decide. That's for the jury to decide if he committed any crime at all. And they could decide that it was a whole host of things, and not necessarily a felony. So on that issue, that's what our position is, that the statute be read.
Yes, a brief response. I think Ms. Dunikoski's misheard or mischaracterized what I said in opening, but that aside, we do want the whole statute read. But here's the important distinction between sentence 1 and sentence 2. And I've read every single case in Georgia on citizens arrest, and this is clearly the case. Sentence 1 applies to both misdemeanors and felonies, but says those must have occurred in the presence or within the immediate knowledge of the citizen conducting the arrest. And then there's plenty of cases, usually in the context of store owners and store managers, talking about what constitutes presence and immediate knowledge, applicable to both misdemeanors and felonies. I have not mentioned that sentence in opening statement. Don't think that we're going to argue that on the facts of this case. The second sentence, however, concerns only felonies, and it concerns the reasonable and probable grounds of suspicion for the citizen to think that the felon is escaping or attempting to escape from the commission of a previously committed felony. So it does not have to be contemporaneous as it does in sentence 1. All of the sentence 1 cases do require a contemporaneous event near in time to the pursuit by the citizen to apprehend the person, either in the act itself while putting the item in his pocket, or after he's left the store and the alarm's gone off and they chase him through the parking lot. Plenty of cases like that. But the second sentence does not require contemporaneity with the felony. It only requires a reasonable and probable grounds to suspect that the fleeing person that you're now pursuing is fleeing from capture for a previously committed felony. In our case, the felony that we can reasonably suspect has possibly occurred 3 months prior to the fleeing that we witnessed, not that day. We don't have to believe that Ahmaud Arbery committed a felony on February 23rd, 2020 to come under the second sentence of the citizen's arrest statute. It would be similar to, say, for example, you have encountered a burglar in your home. You got him on camera. You were home and saw him. You have a clear identification of him. And then 2 weeks later, you're filling your car with gas at the gas station, and there he is. You see him, and you recognize him. He recognizes you. And you say, hey, you're the guy that was in my house. And he turns and runs. Second sentence of the now repealed statute would authorize that citizen to pursue the fleeing felon, of whom he has reasonable and probable grounds to suspect has committed a felony 2 weeks prior in my house when I saw him there committing burglary or whatever else he may have been committing. So I think it's confused and it's incorrect and it's not the law to state that both sentences require presence and immediate knowledge and contemporaneity with the crime. That is not the law, that is not the case. All of this is to say, we want, unlike Mr. Goff, we want the whole statute read just as it was, just as it is in was in 17460.
With all due respect, Your Honor.
I would like a 5-minute recess so we can confer, because I'm sure that this argument makes perfect sense. I just don't understand it. And this is the ball game here. If there's a mistake in this charge, case closed. The way this is reading to me, it's a directed verdict of guilt. And I don't mean any disrespect by that to anybody. But this is huge. And I think a 5-minute recess, so at least we could all be on the same page. If we can be, would be productive here.
I think we could have the discussion right here. We're just having a charge conference.
It's a charge conference. So, no, because what is in the charge is the statute. So I'm not going to break the statute up. Sounds like there's an interesting discussion that is to be had over this theory on what the statute means. But no, as far as the charge is concerned, it's the statute. That is the language of the statute, now repealed, that the court intends to charge upon.
What is the factual basis? Lots of statutes have multiple parts. We don't charge the parts that don't apply. What evidence does the state have to support an arrest for anything other than a felony and the individual fleeing from it? What is the factual basis for any other theory here? What could I'll put it to you differently, Your Honor. If Mr. Arbery had survived and was on trial for burglary, he would not be entitled to a charge on criminal trespass. So why would be submitting to the jury in this case a criminal trespass charge that's unsupported factually by the evidence? Now,
If I may answer that?
yep.
Your Honor, the defense in this case is an affirmative defense, which is self-defense. Problem is, there's 3 things you can't do and claim self-defense, and these defendants, in the state's opinion, did all 3 of them. So they then need to go, well, how can we justify the 4 underlying felonies? Well, we'll go ahead and say we were doing a citizen's arrest. It's an affirmative defense. It's the defense saying, hey, we were doing a citizen's arrest. The state, of course, is the one who has to rebut that beyond a reasonable doubt. So putting the burden on the state to say and explain what crime it was that Mr. Arbery's committing. The state's position is Mr. Arbery didn't commit any crime whatsoever, and the defendant certainly didn't know about any crime he committed that day. Running down the street on February 23rd, 2020 is not escaping from the felony, which we don't even know when it took place, in October or November, maybe in Satilla Shores, maybe in Douglas, maybe in a parking lot in the middle of the night in 2019. So that's for them to argue. Mr. Hogue put it out there. That's what they're going to argue. So at this point, the statute should stay as it is because it's their statute. It's what they're going to affirmatively tell the jury, and that's what they're going to rely on. The state has to overcome it, and the state will. They knew nothing about any crime he had committed that day. So we ask that this be to stay in exactly like it is.
And Your Honor, the evidence that came into trial with the video on February 11th on its own is, in the video that the state played, is the phrase, I'm sorry.
This is all argument. And I'm not meaning to, I'm trying to stop the whole
Oh,
kind of
that's
circular.
you would stop. You're going to charge the whole.
Yeah, I'm charging the statute. This is all argument. And the fact that the argument exists means that there's probably facts in the case to argue what we have here. It's the statute.
Misunderstood.
Thank you, Judge.
I'm sorry. I did want to. I was the one who started the discussion, and I'm not questioning the court's ruling. But I do think it would be helpful, since the state is saying that there was no misdemeanor committed, maybe somebody could explain to me, so I can understand what we're doing here on the defense side, what the defense contention of what misdemeanor we're talking about, because I don't understand it. And somebody has to have a factual basis for the charge. It doesn't matter whether it's an affirmative defense or not. There still has to be a factual basis to talk to the jury about any misdemeanors that it is contended that Mr. Arbery committed, because it gets into the temporal requirement that the state is trying to graft onto this, which I guess we'll be taking up next. So again, if there's no factual basis for it, then why do we even get into the other discussion?
The objection's noted. Court's indicated we're going to charge on.
Thank you, Judge. So next, terms are synonymous. The court's already charged that in its pre-charge. So that's done.
Except for the additional sentence that the state has added here, the final sentence, a private person may not act on hearsay or information furnished him by other persons, which is directly contrary to the law.
And when you're ready, I can respond to that, Your Honor.
So
If the state's done arguing for that charge, which is,
From the state?
yes, thank you, Judge.
charge
So basically, Judge, we're going to go ahead and cite to the cases that we had in our charge 54. And all of them, for instance, Forehand versus the state, 130 Georgia Appeals 801, 1974 case, yes. Holding that in his presence and the words within his immediate knowledge are synonymous. To justify the arrest without a warrant, the officer need not see the act which constitutes the crime take place if by any of his senses he has personal knowledge of its commission. What the officer sees must be what he sees before the arrest and not afterward. Young versus the state, 238 Georgia 548, 1977. While the actual shoplifting was not done in the sight of the manager, appellant's admission, together with other evidence of the shoplifting known by the manager at the store, were sufficient to bring the offense within the immediate knowledge of the manager. I mean, the person confessed to it, and then authorized him to arrest appellant without a warrant. The terms in the presence of and within his immediate knowledge have been held to be synonymous. And then we've got Winn-Dixie Stores versus Nichols. This is a 1992 case. We agree with appellant that as a matter of law, it owed appellee no duty to confront or arrest the couple she was accusing of stealing her wallet. The alleged crime was not committed in the presence or within the immediate knowledge of Arrowwood or any other employee of appellant, Winn-Dixie Stores, and thus Arrowwood and other employees of appellant were not legally authorized to arrest the alleged criminals. So, Judge, here we've got somebody, a patron of Winn-Dixie, going up to store security and going, hey, that woman over there took my wallet. Well, they held here, hey, store security is not obligated to go arrest her based on her accusation because it wasn't done within the store security's immediate knowledge or presence. They actually cite to 17460. Indeed, the only person who could have effectuated a citizen's arrest was the appellee herself, because she was the only person who, by the exercise of her senses, had knowledge of the crime's commission. They then cite to Johnson v. Jackson, basically stating, and then that's the U.S. Marshal case in the driveway, basically stating the only person in Winn-Dixie that was able to go ahead and effectuate this is the person who saw it, who knew about it, who witnessed it. Not even reporting it to store security allowed store security to go arrest this woman who allegedly had taken the wallet. So in this particular case, that is why we said a private person may not act on hearsay or information furnished him by other persons, because we've got a 1992 case right on point. The court then went on here to say nothing in OCGA 51760, which is the arrest statute, suggests that a merchant is authorized to detain or arrest persons accused by business patrons of committing crimes against the patrons, since that statute expressly involves only the limited right of a merchant to detain or arrest a person reasonably believed to have committed the offense of shoplifting under 16814. So, Judge, I understand what the defense is going to ask, because they cited to a number of cases, and they actually asked for a charge. See if I can find it. Well, maybe they didn't ask for a charge, but I did some legal research. And what I found, Judge, were a number of cases that talk about police communication. And we've got Goodman versus the state, 255 Georgia 226, 1985 case. We've got Grigori, Gregoire versus the state, 285 Georgia Appeals 111, 2007 case.
I'm going to redirect you. You are actually looking at my request to charge number 4. It was just
Excellent.
titled probable cause.
Excellent. I thought it was in there.
Yeah.
I just skipped right
That's
over it.
fine.
So there we go. All these cases I looked up were under request to charge number 4, probable cause by the McMichaels. And each and every one of these cases is police communication, not citizen communication. And we know what police have. They have radios. Okay, so they're able to communicate in absolute real time with each other about things like this. So In Ferguson, 1996, we've got malice murder and felony murder, armed robbery. Basically, she maintains that she was unlawfully seized and that her arrest was illegal because it was without probable cause. And they talk about probable cause. An officer may make a brief investigative stop of a vehicle if it is justified by specific articulable facts sufficient to give rise to a reasonable person of criminal conduct. Okay? And they're talking about an investigative stop at that point in time, which does not apply to citizen's arrest. There is no citizen's detention, citizen's investigative stop. It's an arrest. And they talk about the police, they had probable cause, which can rest upon the collective knowledge of the police when there is some degree of communication between them instead of the knowledge of the specific arresting officer. So most of these cases, in fact, all of them cited by the defense, talk about the collective knowledge of the police. Well, the police are able to communicate because they've got radios, and they're able to communicate to each other that way. And we got 96, we got 2007, we got 85, we've got 2007. So to say, well, that somehow applies in this case, that, oh, a private person can act on hearsay or information furnished by other persons when the statute specifically says within their immediate knowledge, and we actually have a 1992 case right on point. You can't make an arrest based on the lady in the store coming up going, she stole my wallet. So we ask that a private person may not act on hearsay or information furnished him by other persons. We ask that that part of the charge be given.
May I respond, Your Honor? We're objecting to the last sentence of this request only. A private person may not act on hearsay or information furnished him by other persons. Again, I emphasize there's a distinction between sentence 1, citizen's arrest, and sentence 2, citizen's arrest. Sentence 1, citizen's arrest cases are the ones the state is citing to the court right now, because it's required that the arrestor, the citizen who's conducting the arrest, has seen the crime, misdemeanor or felony, or has immediate knowledge of it. And there are cases that say those two terms are synonymous, even though they stretch it a little bit. And the best case to illustrate that is Murney versus the state, M-E-R-N-E-I-G-H. Again, that's another shoplifting case. It's a misdemeanor. And the store manager in Murney did not see the shoplifting happen. The food manager called the store manager in his office and said, hey, this guy just left the store with stolen stuff. The store manager heard the door alarm go off, came downstairs, saw Murney in the parking lot, and chased him along with another employee. So Murney defended himself at trial after he got caught by the police, not by the store manager. He pulled a knife on the store manager and they gave up the chase. But the police caught the guy and then they charged him. And then he said in his defense, they were not conducting a lawful citizen's arrest of me when they chased me in the parking lot. And the case holds that, and their argument was because the store manager didn't see me steal anything. It's all sentence 1. And the court said, no, he had immediate knowledge of it because he got told by another employee that Murney had shoplifted something. And then he heard with his own ears and saw with his own eyes circumstances that supported what he'd been told. And therefore they said immediate knowledge is synonymous within his presence. First sentence citizen's arrest case really doesn't apply here. And all the other cases but one, and it's one I want to point out, and that's important here in this saying that this sentence doesn't apply. All the other cases the state is citing are basically sentence 1 shoplifting type cases, except for one, and it's Denon versus the state at 173 Georgia Appeals 191 1984 case. The state cites that. but just cites it, doesn't give any summary of it. I would like to give it now because it supports our position that that last sentence does not apply, is not the law, and shouldn't be included in the charge to our jury. And here's the basic, as thinned down as I can make it, Judge, of what happened in Denon. And this is critical to our case, so allow me to tell this story. Dr. Denon was at home with his wife. He owned a shopping center. In that shopping center, one of his sons owned a restaurant, and his other son, their names were Tom and Jim, was remodeling another storefront that he was going to open with his partner, Sam. And so while they were remodeling this place, they didn't have a phone, but Tom, the restaurant owner's son, did have a phone in his restaurant. And the two renovators saw this guy outside of the store in the parking lot attacking a young woman. She was running towards them. They came out. They took her to protect her from Wendell, the guy attacking her. And then one of the two renovators, Sam, tackled Wendell and took him to the ground and was holding him on the ground while they were trying to get to a phone to call the police to come get Wendell. Well, Wendell took off. But he came back in his car, and when he arrived, they said, "You've made a mistake. You shouldn't have come back." And that's when they held him on the ground, and all these kids from across the street saw what was happening. They came over, they knew Wendell, and when the police arrived, Sam has Wendell on the ground, and they tell the police that Sam is attacking Wendell. The police officer walks up, sees Sam holding Wendell on the ground. Again, he's protecting this young woman from Wendell. The police officer takes out a nightstick and cracks Sam on the head a couple of times with it, arrests him, and puts him in the back of a patrol car. Now, Dr. Denon, who owns the shopping center, didn't see any of that. He was at home. The other brother called him and said, "Dad, you need to come down here. They just arrested Sam and his other son, who got vehement and was cursing at the police officer, telling him, 'You arrested the wrong guy. Wendell's the bad guy here, not Sam. You believed all these kids. They're not telling you the truth.'" Dr. Denon arrives. He sees Sam in the back of the patrol car. He has blood on his head. And then his other son tells him the story I just told the court. And so Dr. Denon says to the officer, "You need to let him go. You've arrested the wrong person. And you've assaulted him, a felony." And the officer tells Dr. Denon basically to mind his own business, and he turns to leave. And he's now, under the citizen's arrest statute, sentenced to fleeing from capture of a felony. Dr. Denon puts his hands on him to hold him, says, "I'm making a citizen's arrest," says that to the police officer. Well, Dr. Denon ends up pinned up against the car by a couple of police officers, punched a few times, and then he gets taken to jail. He goes to trial. That's why the case is reported, because Dr. Denon got to trial, and he said, "Judge, I want a citizen's arrest statute sentence 2 is my defense, my only defense." Trial court refused to give that charge. Dr. Denon was convicted. And the court wrote, when they reversed his conviction, "It is the law of this state that where there is only one defense on which a party relies, failure to instruct the jury as to the evidence supporting this defense with sufficient clarity and specificity that the jury will not only be required to pass upon it, but do so intelligently, in practicality directs a verdict against the defendant. In that the effect of the failure to charge is to withdraw and deny the defense and to that extent prejudices a defendant's right to a fair and impartial trial. They go on to say only slight evidence requires the giving of a charge, even though other evidence tends to show the non-existence of the fact. It is not so much whether Dr. Denon made an informed and correct decision that a felony or a misdemeanor was involved, but whether his state of mind was that he intended to make an arrest of an escaping offender, or whether he, in anger or otherwise, intended to injure Officer Wagner. We conclude that the refusal by the trial court to present to the jury the sole defense offered by Dr. Denon was prejudicially erroneous and requires a reversal of his conviction. So it's a good case to cite, but not for the proposition that the state has cited it. It says nothing about a private person may not act on hearsay. Dr. Denon did act on hearsay. He got a phone call while he was at home, probably in his pajamas and slippers watching TV. He came down there and all this other stuff ensued, and the appellate court says you should have told the jury about citizen's arrest. You denied the man a fair trial. That applies here. That sentence does not apply to our case and should be omitted. I wouldn't mind if that entire charge 54 was omitted because it all applies to sentence 1. We're not going to argue sentence 1, even though we're happy that the court's going to give the entire statute. It's only 2 sentences long anyway. But
Well, we don't need to go there. I've already charged them.
But this charge, this request, charge 54, is not the statute. It's citing the statute in the name of the charge, but it's citing partly correctly, but partly incorrectly, what sentence 1 means.
I won't try and revisit what the court's already ruled on, but I have a real problem with it. I have a problem with the whole section, but I have a problem like Mr. Ahmaud does with this last sentence. There are cases, I'm pretty sure in Georgia, and I know in other jurisdictions, which apply this same language, this immediate knowledge and presence. That's pretty common across the country in citizen arrest statutes, Your Honor. And in the cases involving law enforcement officers acting under the citizen arrest statute, which is a substantial body of the entire citizen arrest case law, in those cases, police officers making citizens' arrests have been allowed to rely on information provided by other individuals. And the best explanation I can give for the distinction is, Your Honor, when we talk about within the immediate knowledge, what we're talking about is the present knowledge, not knowledge acquired in the moment, but knowledge acquired prior to or at the time. In other words, that after acquired knowledge from other people would be inadmissible, but any information that was possessed at or before the time frame is appropriate, even if it's coming from third parties. And this is exactly that case, where the McMichael defendants, as I understand it, I'm not trying to put words in anybody's mouth, but are contending that they not only saw videos, but received information from other people, and they relied on the information previously acquired on February 23rd. And that is a distinction in terms of arresting someone and then trying to come up with an after-the-fact rationalization, if in fact there is knowledge that has come from a third party prior to or at that time, then that is knowledge within their immediate knowledge. And the state is pushing and asking for too much in this last sentence. And we would ask the court, joining the McMichael defendants, to strike the last sentence of the terms are anonymous state charge number 54 that it currently appears at the top of page 19 of the court's charge.
Okay, so I guess harkening back to some of the discussion about citizens arrest, it is interesting that a lot of the cases do involve shopkeepers and store clerks and subsequent arrests. And I think the way to solve what we have, I don't agree. Well, first of all, given what the courts, the appellate courts, have sort of parsed through in order to get to some reasonable explanation for what the authority is, what you can sort of take from those cases is this hypothetical store manager can't just walk in and assume somebody is running because he has been told, oh, that person might have stolen something. They can't run out and do that. They would need additional information. And some of it is the store videos, for example, that are referenced in some of the cases, or the alarms going off. So there's more to it. So I'm going to keep that sentence, but I'm just adding the word alone at the end of the sentence. So it's a private person may not act on hearsay or information furnished to him by other persons alone. In other words, there has to be more, which I do think starts fitting into the facts of this case, which, as I understand from Travis McMichael's testimony, was there was more to his explanation than simply hearsay as to why he acted. And so I'm going to add that. I'm going to keep the sentence, but add the words so that it's understood that there needs to be more than just hearsay. What that is and what the actions were, or what the actions were based upon, has already been explained to the panel. So that's how I intend to solve that.
Thank you, Judge. The state agrees.
From the
So,
defense,
as far
I
as-
assume there's an exception to that.
There is, my concern is even adding the word alone, so I guess the sentence would read, a private person may not act on hearsay or information furnished him by other persons alone. And I'm thinking now for Greg McMichael specifically, what that may do to our defense. You alluded to other information Travis McMichael had, since he encountered Ahmaud Arbery himself personally on the night of February the 11th. But for Greg McMichael, he never encountered him personally at any time other than on February the 23rd.
There's testimony about him going out to the house and taking other actions. There's other evidence in this case. What this is simply saying is you can't just do it purely on hearsay. Just because you were told to go chase somebody, don't go chase somebody.
Well, it
or
goes
told
on
that
to
somebody
say,
did something, don't go
here-
chase somebody.
Hearsay or information furnished by other persons alone. I mean, information furnished by other persons, would that not be synonymous? That would be video?
I mean, Larry English showing him the videos, or him
Yeah,
seeing the
it
videos.
seems to gut at all the sources of information that we did acquire. I mean, some of it you could say is hearsay. If a person tells Greg McMichael, yeah, I think this, or I saw that, or this is what I know, you could say that's hearsay. If it also says information furnished him by other persons, now we're talking about videos shown him by Rash, still shots shown him by Rash, Diego Perez showing him videos. That's information furnished by other persons alone. And that sentence, therefore, I fear the jury could say, well, that guts Greg McMichael, because that's all he's got. He was never at the house and ran into Ahmaud Arbery himself personally. I'm afraid it would direct a verdict of guilt for our client.
No, I'm trying to think of, again, I'm going to these shopkeeper cases in my mind and thinking, what is the type of information that we've been talking about? Because that's really where this has been parsed, I think, more than any other place. And that is the court justifying how you can get effectively a third party to what was happening, that authority to go ahead and act. And that, in those cases, those individuals are looking at video and looking at other things provided to them by third parties. Now that's in their capacity in the store, but I'm not sure that that's necessarily the.
If you could
Speak up a bit.
Yeah, no, I'm thinking it through out loud. Again, using the
I just want to hear your thoughts. I can't hear it.
Sometimes I need to keep my thoughts to myself.
No, it's helpful for this process.
Yeah. No, I understand what's being said. I think then the alone goes after the hearsay and the rest of the sentence is taken out based on what I'm thinking through here. What I'm inclined to do is that sentence is going to be a private person may not act on hearsay alone. Because I think that then covers the idea that we're talking about here and the evidence presented in this case.
Could I inquire, Your Honor? In terms of saying to the jury, a person can't act on hearsay alone. Hearsay, as we've been discussing it here, is any statement made outside of court, now offered inside of court for the truth without that person, right? But what the court seems to be saying is we're talking about a different kind of hearsay, meaning if Travis talks to Rash and Rash says there's been burglaries in this house or break-ins or trespassing or whatever, or is the court saying, and the court would sanction the state arguing to the jury, the court's going to charge you, Travis can't rely on a statement given to him by Rash because that's hearsay.
Well,
Or Travis can't rely on his mother because that's hearsay. Is that the court's going to allow the state to make those arguments? Which leaves then what? Unless Travis was in the house at the time the stuff was taken and he saw it himself happen, then he's got no evidence about a burglary because he wasn't in the house at the time it happened?
No, that's not.
That's what I'm concerned about.
No, and I understand that. That's not what I understand. So hearsay,
nodding.
so
That's what I'm
hearsay alone would be, for example, if there were no videos, they weren't looking at things. If someone just came up and said, "Oh, I saw a video," and he acted upon it, that's hearsay. But if there's discussion about this video and he's seen it, then I mean that's the circumstances that we get in some of these cases that are out there, where, yeah, the individual's being told what was seen on the video. They looked at the video and acted. So I think there's a subtlety there. I understand where you're going with it. I don't think we're using a legal definition necessarily of hearsay. This fits, in my mind, to the facts of the case, given the case law that's out there. Because what we're talking about here is there's no argument, I think, from the state that Matt Albenzi was out on the street and pointed down the street, and simply based on him yelling or pointing down the street or whatever it is, that's what the defendants acted upon. There was more information there that the defense wants to talk about. If it was just Albenzi pointing down the street or making some comment, I'm just talking hypothetically, that's what this is trying to avoid. That's what this language tries to avoid, because I think that more tailors itself to the cases that are out there.
Is hearsay the proper word?
Well, that's the word that was used in the cases.
May I just jump in for a little bit on the point I think I'm hearing Mr. Sheffield make? It's an excellent one because there are two different uses of hearsay being
How about
used
this?
here.
Unsupported statements of others alone. That's probably what we're talking about here.
And Judge, just to correct the record, Mr. Sheffield just said the state's nodding its head. The state was not nodding its head in agreement with what Mr. Sheffield was saying. The state was nodding its head in understanding of, in my mind, I was thinking, okay, I understand where the defense is going to go in their closing argument. So I don't want it to be on the record that I was nodding my head as if I was in agreement with what Mr. Sheffield was saying as he threw that comment out.
Let's remove the legal term hearsay. It's going to be a private person may not act on the unsupported statements of others alone.
State agrees.
And just to be clear, what we're talking about is the court defining the first sentence of the citizen's arrest statute, terms within that.
I'm not prepared to adopt Mr. Hoag's interpretation of the statute in whole, that we can get to that.
The only cases that define in his presence and within his immediate knowledge that they are synonymous are the misdemeanor cases, the first sentence cases. There are no second sentence cases that define that. I'm just pointing that out.
You know, I'd say the first and second sentence thing that we're talking about is one reason why I think the citizen's arrest statute was a mess before it got changed. It's the mess that we are living with, but those two sentences are applying to two different scenarios, and it just wasn't ever real clear until you read every single case ever reported on those statutes, and then you see the pattern develop that, as Mr. Rubin just said, all of these presence and immediate knowledge cases are usually misdemeanor shopkeeper cases. And then there's very few cases involving fleeing felons, very few.
I understand that.
In the few cases previously, felony cases previously cited to the court, the presence and immediate knowledge requirement obviously did not and could not apply.
Let's get past where we are. I understand the defense then takes exception to what is going to be charged, but I've explained what's going to be charged.
Thank you, Judge.
I want to say the defense, both the McMichaels defendants and the Bryan defendant. Okay.
All right, so next one is must make the arrest contemporaneously, and that is the state's position. The state is basing that on McWilliams versus Interstate Bakeries Incorporated, 439 F. 2nd, 16, a 1971 case, but out of the state of Georgia. And what we have here is we have a guy who goes into the bakeries and does indecent exposure, and a woman sees it. He shows up 4 days later, and she's like, there he is! And they arrest him and detain him for the indecent exposure 4 days beforehand. He then filed suit saying, you know, they falsely imprisoned me because you can't do a citizen's arrest. It's for exigent circumstances. It's for the emergency. It's for the immediacy. If you've got an issue, you know, call the police, have them do the investigation. They take out a warrant. They do what they're supposed to do. And that's basically what Interstate Bakeries said. A private citizen's warrantless arrest must occur immediately after the perpetration of the offense. If the observer fails to make the arrest immediately after the commission of the offense, his power to do so is extinguished, and a subsequent arrest later is illegal. I threw in the word later. That's not actually in the charge. And a subsequent arrest is illegal. And that is actually what we're asking for, because that's what the case law says in McWilliams versus Interstate Bakeries. I believe the defense is going to argue, well, that was a misdemeanor case. It's indecent exposure. So that only applies to the misdemeanor. But here's the problem. If the offense is a felony, meaning the one you just saw is a felony, and the person's escaping, then on probable suspicion, you can go ahead and arrest them. So I'm trying to come up with a really good illustration of a factual basis. Does the court even want me to try and do that right now? Nope? Okay, I won't. I'll just say we would like this state's request to charge number 55, which is must make the arrest contemporaneously.
Your Honor, McWilliams versus Interstate Bakeries is clearly limited to misdemeanor offenses. It is merged with Adams versus Carlisle, which is really the footnote that the state is citing out of McWilliams. And in that instance, the holding is a private person can only arrest for misdemeanor offense when that offense occurs in his presence. And the arrest must occur immediately after the perpetration of the offense. So it's not applicable to the case at bar.
It's a first sentence.
The state disagrees with this first sentence, second sentence distinction that they're making. The first sentence applies to misdemeanors and felonies. The only time the second sentence applies is when someone's escaping. You have to also be escaping. So the first sentence does apply to misdemeanors, and it applies to felonies. And I think Mr. Hogue even stated that and made that very, very clear. So this weird distinction where it only applies to misdemeanors, that is not at all true. You have to, if it's a felony and the person's escaping, then you get to do these other things. Then you can go ahead and chase them down. You can't chase down necessarily someone who's committed a misdemeanor. but you can chase somebody down if they're escaping. So that's really the distinction here between the first sentence and the second sentence. Not that the first sentence is only on misdemeanors. It's misdemeanors and felonies. The second part applies when you're escaping. So I just want that distinction to be made. And here in McWilliams, there was no escaping. And it doesn't matter whether it's a misdemeanor, because the first sentence, immediate presence, if you don't arrest the person who's committed the felony right there and then in front of you, your ability to arrest him later is extinguished. And here's the thing. If the guy's pumping gas, you notice how Mr. Hope said, well, if he's pumping gas and you go up and say, hey, you're the guy from the other day, and the guy runs off, all of a sudden he's escaping from something he did 4 days earlier because you've confronted him. How many minutes of how many days is he escaping? So it begs that question, and I think we're all going to be arguing that, but we ask that this, which is good law, be given to the jury because it applies to both felonies and misdemeanors, because the second sentence only applies under certain circumstances.
But it is, as my understand it though, this entire case is the question of chasing for the purpose of detaining for an arrest. So the question of whether or not it's a misdemeanor or a felony and morphing them all together is just not accurate for the jury and in their assessment. Otherwise, we would not have two sentences in this statute.
If I could just I'm sorry, Kevin. You wouldn't need the second sentence, reasonable and probable grounds of suspicion, if it occurs in your presence or immediate knowledge. You have probable cause if it occurs in your presence. The reason there is a second sentence is because when it's a felony and the person's attempting to escape, there's a lesser burden. It doesn't have to be in your presence or immediate knowledge. You have to have probable cause. And probable cause does not require presence or immediate knowledge. Police officers get warrants with probable cause for events that occurred days earlier, weeks earlier. They get arrest warrants and search warrants under those circumstances. It would render the second sentence superfluous if the definition is as stated by the state.
Your Honor, I don't know, I guess it's the opposite of flattery because, I filed stuff on this a long time ago and it seems like as Ms. Dunikowski's standing here, she hadn't read it. Your Honor, we're conflating two different issues here. The fleeing felon part, Ms. Dunikowski makes a valid point. You can't go back a year later when someone's sleeping in their house and arrest them as a fleeing felon. There has to be some flight, and just because you have probable cause to believe someone committed a felony doesn't mean you can arrest them. But in this case, if there isn't a fleeing felon in this case, then there never could be. This is the very definition of a fleeing felon. It doesn't have to be fleeing immediately after the crime, but he's fleeing nonetheless. And what Ms. Dunikowski is trying to do here, I may take that back. I should not say what she's trying to do. That's not fair. What her argument is trying to do is conflate the issues on the first and second sentence with whether they're escaping or not. Escape has nothing to do with the first sentence, which respectfully has nothing to do with this case. The escaping part has to do with the felony arrest. Doesn't mean that the felony has to have taken place right then, that the person is escaping then. It means that there has to be an exigent circumstance, which is what the court has already adopted, that part of the language. And the exigent circumstance for the felony arrest is the flight or escape. For example, if Greg McMichael or Travis McMichael and Mr. Arbery were bowling buddies or on the golf team together, and he could look at the video and know who he is, well, then at that point, he's got to arrest him or not. He can't come back 3 years later. But in a situation where the perpetrator is not identified and is fleeing, that's an exigent circumstance because you can't go back and get him later. You got to get him then. And that's the reason that the McMichael defendants are authorized in this case, and Mr. Bryan, to assist them in doing that, if that's what the evidence suggests. There is fleeing here in the sense that if he is allowed to escape, there's no guarantee that he is going to be discovered subsequently any more than he wasn't discovered the first time he went in the house, the second time he went in the English residence, or the third time or the fourth. I mean, that's the personification of flight. And that's why this charge should be allowed. But to go back and say that that's got anything to do with whether it's the first sentence or the second sentence, that's a separate matter.
And I think it's confusing for the state to present it that way.
All right. Y'all have argued my brain into mush. So we're going to take a short recess. I'm going to clear my head and figure this out. Thank you. No, I'm just making sure that there's not still Coca-Cola flowing all over the table over there. Okay, we're back on. Council present and defendants present, represented by counsel. We are discussing on page 19 the contemporaneously language. So tell you how the court's going to charge this. I don't read the statute the same way as the defense. I read into the statute. The first line addresses both felonies and misdemeanors. The second sentence narrows that then down to felonies. It doesn't discount misdemeanors. It just says in the case of felonies, if there's an escape going on, then the arrest can be effectuated. The way I read that is if it's a misdemeanor, the guy can be arrested, guy, gal, whoever it is, can be arrested by whoever is effectuating the citizen's arrest. But if they run, then you can't go chasing after misdemeanors. In the case of a felony, you can. And a person who is chasing somebody who's escaping on a felony that is justified upon reasonable and probable grounds for suspicion can effectuate the arrest. So the charge that I am going to provide, I'm going to amend a little bit from the state's language, and that is that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during the escape. If the observer fails to make an arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. I'm not going to comment on the legality or illegality, so I'm putting a period at the end of extinguished and removing the "and a subsequent arrest is illegal." So, again, private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during escape.
I'm sorry, could you say that last portion again? Or in the
case of a felony, during escape. If the offender fails to make the arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. That's what the court intends to charge. I understand there's an exception from the defendants.
Judge, if you charge the jury the way you're contemplating, you are directing a verdict for the state. You are rendering the second sentence in which it describes reasonable and probable grounds of suspicion meaningless. It's in there presumably for a purpose. It's a different burden than immediate knowledge or presence. And so I would urge the court to reconsider and eliminate this, let the state argue what they're going to argue. We have built this whole case around the probable cause, the second sentence, last phrase that Travis McMichael and Greg McMichael had on February 23rd for events that happened previously. And you are gutting all of it if you give this particular charge.
May I ask, Your Honor, if, I know we're Friday at 2:30, if over the weekend we were able to email to you or your staff a full, complete with citations argument for what position we're arguing for here, that this contemporaneity of the offense for which you are fleeing and being chased.
Why don't we do this? This is what I intend to charge. I'm not going to reopen all of the charges. I understand the significance of the charge that is presented. I will, if I'm provided something, at least on a timely basis over the weekend, where I can digest and the state then have an opportunity to digest and respond. This charge, I will remain, the intent is as I've described. But if I'm provided different authority than I've already been provided, I will go ahead and reconsider upon the presentation of any additional authority that may come.
Could I shoot for, say, midday tomorrow? I'll be working on it all morning, tonight in the morning, not Sunday, but sometime tomorrow, get it to the court. And
That's fine.
and at some point, whatever other email addresses you'd like me to use, I'll use. I may have them all already.
Yeah, I think you've got just about everyone we've got.
Okay.
I can't think of any more that hasn't been provided.
Your Honor, I think I've already submitted all the law that I can find, but we'll certainly be happy to adopt what more learned co-counsel can submit. But I agree with Mr. Rubin. This is, and I'm not saying that it's the intention of the court. I don't want to be misunderstood. But the practical effect of this charge is a directed verdict of guilt. And it's a denial of the sole defense of at least 2, if not 3, of the defendants in this case. I mean, I think the court's indicated the court appreciates the gravity of the charge, but I'm just joining in that because that's just the way it is.
Okay. Understand where we are.
Thank you, Judge. So the next one that the state submitted would be State's 56, and that is probable cause is not enough for a citizen's arrest. The state is requesting that this charge be read based on Arbery versus Collins 1995 case, 219 Georgia Appeals 63. The existence of probable cause standing alone is not a complete defense in a false imprisonment case, because even if probable cause to believe a crime has been committed exists, a warrantless arrest would still be illegal unless it is accomplished pursuant to one of the exigent circumstances applicable to private persons, which include the fact that the crime committed was a felony and that the felony offender is escaping or attempting to escape. Now, Judge, the state will go ahead and concede a few things about the Arbery case. Arbery versus Collins was, once again, a civil case. It was an apartment complex case. It had to do with a...
Can I stop you? Isn't this simply an expansion on what I just addressed?
Yes, it is.
Okay.
Your Honor, we're prepared to argue, but I suppose we could argue all day. This is not the law as applied to this case. You have just earlier said probable cause is what you're looking for in order to support the definition necessary for a citizen's arrest. And now to say, bam, but that's not enough, is only applicable when you're talking with respect to these civil suits.
Yeah, my concern about this is I probably need at some point to look at how many times I've said on the record something's being conflated during this trial, but I feel like I need to come up with a better word. We're conflating probable cause and exigency in this charge, and I think the charge above addresses exigency, and there is a probable cause charge. So that's my concern about it from the state.
I'm still going to ask that you give it, but I understand if you choose not to, Judge.
Anything from the defense on that, I don't intend to give it. I think it's covered.
We ask that you do not.
And for Mr. Bryan?
One could make the case that it's less damaging than the one before, but I'll join in the co-defendant's motion to exclude that one.
All right.
Thank you, Judge. So I believe the next one is probable cause, done by the defense. And the state objects to this particular charge as given by I believe the court has, they've submitted one, it's a little different than the court has, so I'll read the one the court has. A private person may arrest...
May I say this? To be fair, we're now talking about the request that we've submitted, and I feel as if I have to
Yeah,
defend
let's do this.
each
Then
one of them.
let's hold on to one if the state objects to that. So I'll just put an objection, and I'll let the
Okay,
defense address that.
all right. I assume that's the same for the next one. Probable cause is a question for the jury. Whether the defendant possessed reasonable and probable grounds for suspicion is for the determination of the jury.
If it's objected to,
It is objected to.
okay.
Well, actually, no, you know what? I actually think that's the correct statement of the law, because whether the defendant possessed reasonable and probable grounds for suspicion is a determination that the jury has to make, and that is a correct statement of the law. So I don't think I'm going to object to that particular statement.
All right, we're on page 20.
And it's
We
on,
object to that next one, requested by the state.
the next one requested by the state.
Is they may not arrest upon suspicion alone.
Yes, Judge. So this one is basically, there is no authority in Georgia under which a citizen may be arrested without a warrant and held for investigation to determine if he has committed some crime merely because the person making the arrest has a suspicion that the person arrested may have committed some then unknown crime. Once again, we have Rife versus the state, R-A-I-F versus the state, 109, Georgia Appeals 354, 1964 case. That conviction was reversed where the defendant was arrested for walking near a shopping mall, and he was a suspicious character, probably an intruder, and he was illegally arrested, and then hours later it was discovered that the store in the mall had been burglarized, so they connected it up somehow later, but there was no evidence that he had been the one who had burglarized it. So in that particular case, it was just based on he's a suspicious character, and they arrested him because he was walking near a shopping mall. So based on that, you can't arrest somebody just because you have a suspicion that they may have committed some then unknown crime and then go looking for the crime, which is what they did. They said, well, he's suspicious, let's go check the mall, and oh look, the mall's been burglarized. Forehand versus the state, 130, Georgia Appeals 801, 1974 case, holding that in his presence and words with his immediate knowledge are synonymous. But they went on to say that to justify the arrest without a warrant, the officer need not see the act which constitutes the crime if by any of his senses he has personal knowledge of its commission. What the officer sees must be what he sees before the arrest and not afterward, finding illegal the detention and subsequent arrest of the defendant solely based on a reliable informant telling the officer that the defendant was engaged in the business of burglary, but the informant knew of no particular burglary, and the officers did not see or know of any particular crime the defendant had committed. Basically, what the state's getting at here is Greg McMichael tells the police, I think he must have gone and committed a crime, so we were going to hold him so the police could show up and then figure out what crime it was that he committed. The state really wants the jury to understand that you can't do that. Under the law, you can't go, suspicious character, we're going to hold you here, we're going to detain you in violation of your personal liberty because we're going to call the police now because you're a suspicious character, and we're going to go ahead and then later figure out what crime it is that you must have committed like they did in Rafe. Smith versus the state, the 2012 case, 314 Georgia Appeal 583, specifically on this point. Significantly, Smith testified that he was not present when the money was allegedly taken. His suggestion that the victim had committed the theft was based upon mere speculation. Smith's claim that he wanted to question the victim reflected that he was uncertain and did not have immediate knowledge that the victim had been the perpetrator of the alleged theft, which is required for a lawful citizen's arrest. So what we've got going is that this whole idea of, well, he's a suspicious character and he's been inside that house a couple of times and some stuff has been stolen and all these things, we're going to go ahead and detain him to investigate. And Judge, that's exactly what Mr. Rubin said in his opening statement, that he was doing a citizen's arrest to detain Mr. Arbery so that the police could show up and do whatever they wanted to do to investigate to find out what crime it was that he must have committed. That's a false imprisonment. That's an illegal citizen's arrest. And the state is very concerned that somehow the jury's going to think that detaining people for the police so they can figure out what crime they must have committed is somehow lawful. And it's not. It's false imprisonment, and it falls under that. So the state is asking for, there is no authority in Georgia under which a citizen may be arrested without a warrant and held for investigation to determine if he has committed some crime merely because the person making the arrest has a suspicion that the person arrested may have committed some then unknown crime.
And our response is that this request number 57 is not applicable to the facts of our case. We did not open by saying we had no idea what crime Mr. Arbery might have committed. There's some unknown crime. He's just suspicious. We're going to hold him and let the police figure out whether he committed a crime and what crime it may have been. The way the evidence has come out is, as we've said all along, we suspected him of a specific particular crime that we could articulate and identify and have reasonable and probable grounds to suspect him of having committed burglary in the English house. So while these are correct statements of the law, in Rafe it says you can't just arrest somebody without a warrant because of suspicion of some then unknown crime they may have committed because they're lurking around a shopping center. Yeah, that's the law, but that's not applicable to the facts of our case. So this charge just doesn't apply, and that's why it should not be given.
Your Honor, we agree and join Mr. Hoag's argument. You know, we have a continuing problem here, and I see it becoming a problem during on Monday. The state keeps, while the citizen arrest statute is the authority that I understand the McMichael defendants to be traveling under, although the statute uses the term citizen arrest, arrest encompasses detention. And this charge is misleading to the jury. There's never been any suggestion that anybody intended to grab Mr. Arbery and shove him in the trunk of their car or the back of their truck, hog tie him, and take him down to the Glenn County Detention Center. The uncontradicted evidence has been the intent to detain Mr. Arbery momentarily for the arrival of the police. Now, I think Ms. Dunikowski and I agree that that is not authorization to be Nancy Drew and to hold people for the police to see whether there's a crime. But when there is an articulated crime that the detention is being sought for, then to be continually referencing arrest in these charges is incorrect. To be tailored and adjusted to the facts of this case, although the jury should be informed it is a citizen arrest statute, the jury needs to understand, and the subsequent charges should refer to detention, which is authorized based on probable cause. And what Ms. Dunikowski is doing is conflating the permissible and impermissible in these charges. So to say that you can't arrest someone for investigation to determine if a crime is committed, that is true. But you can detain them if you have probable cause to believe that a crime is committed. You do not have to physically take them down to the jail. You can hold them for the police for a reasonable time, as long as you have probable cause to believe a specific offense has been committed. And this, again and again, through the charges submitted by the state, the way the state is using the word arrest is creating a problem here, because in almost all these instances, when we talk about arrest, what we should really be telling the jury is they're authorized to detain, because that is adjusted to the facts of the case.
Can I also just ask the court, consider using that word detention. A detention is an arrest. It's not taking them in handcuffs. It is stopping them and detaining them for the suspected and believed conduct that is illegal. The state is then going to be allowed to articulate what arrest means without further definition or further limitation by the court. I think the court needs to consider that citizens are, you've heard the state's cross-examinations throughout this case. Did they say you're under arrest? Did they say we're making a citizen's arrest? To say that we're going to stop and detain somebody, we're going to stop them for the crime that we believe they committed, that is a citizen's arrest. But the other problem with what the state is asking for here is it's allowing the jury to be confused. It's going to be confusing to the jury if you further allow this charge to have the state explain some unarticulated motive. Yeah.
Let me focus back on the charge. So here's where I'm on this charge. One of the other challenges associated with this charge and language is the upon reasonable and probable grounds of suspicion. Okay, that language exists as stated in the statute. And it sounds like, until I say this, that everybody agrees that that's probable cause, that you need probable cause for an arrest. The fact that you put suspicion in there, my concern is with a jury that that creates confusion. And so depending on what the probable cause charge is, which is what has been objected to by the state and is being proposed by the defense, it's hard to say whether or not this suspicion language is necessary. Because again, my concern is any confusion the jury would have with the upon reasonable and probable grounds of suspicion, primacy and recency. Last thing they hear is suspicion. All of a sudden, it's just suspicion that allows folks to act. I do think that probably needs to be defined or clarified. And so if the charge for probable cause is simply left the way that it is, I'm more inclined to put in, and probably not this exact language, but some language explaining that you can't just act on suspicion, to clarify that. So that's where I stand on it. I'll come back to it again then when we talk about probable cause. But if we can somehow attach those concepts together so that there isn't that gray area that sits there with the word suspicion being used in effectively the definition of probable cause, then I'm happy to go ahead and hear from you.
I think everybody agrees that you can't detain someone on mere suspicion. And I think that's what the court is driving at.
No, that's exactly what I said. What I said is that the problem in this case is the statutory language uses the word suspicion. And so when a jury hears suspicion, my concern is it adjusts what people think or pulls them away from lawyer language, probable cause, which everyone agrees is really what we're talking about. So hopefully I explained that well enough so that we'll be able to hit this maybe when the McMichaels address some of these charges. So I'm just going to leave that open right now.
Thank you, Judge. I'm assuming the court wishes us to skip over citizen's arrest duty to inquire proposed by Mr. Goff.
That's Mr. Goff's charge.
All right, and then the state and Mr. Goff both requested the right to resist an unlawful force in making a legal arrest. And for this particular charge, the state took this specifically from 3.16.40 from the pattern jury charges and modified it. And I provided some support for changing this from an officer to a citizen. So I don't know at this point in time if there's any objection to it and whether I need to argue it.
If all we've done is change citizen to person, I don't see there being a problem.
Yeah, I don't,
Okay. I didn't know if I needed to argue it. I just mentioned we were on it, so if we're good with it, we'll move on.
It's a pattern charge other than that one change.
No, we
correct?
don't want this charge.
we don't believe that it has anything to do with this case.
So I will argue it. No, actually, the pattern is for a police officer. The pattern actually, I believe, and I will pull it up. I will pull up specifically the new pattern charges. And we've got 31640. And what the pattern charges is it's usually done in the context of someone who's fought with the police and they're on trial for maybe obstruction or felony obstruction. So it normally says a police officer is authorized to use in making a lawful arrest only that degree of force that is reasonably necessary, et cetera, et cetera. And it talks about the officer, the right to use excessive force. It talks about the person being arrested has the right to resist. But what I did was I went ahead and put citizen in place of police officer. Now, I know the court has changed that, and the state does not have a problem with the change to it, which is a person is authorized to use in making a lawful arrest only that degree of force that is reasonably necessary to accomplish the arrest. The mere fact that a lawful arrest is being made does not give the person, as opposed to law enforcement officer, the right to use excessive force or an unlawful degree of force upon the person being arrested. A person being arrested, even though the arrest itself is lawful, has the right to resist And it goes on to defend against the other's use of unlawful excessive force. And the reason the judge, of course, we want this in is the jury may believe that a citizen's arrest is actually really happening here. And the state's next step is, well, okay, if you believe that there's a citizen's arrest that's actually really happening here, they have probable cause to go ahead and arrest them. Did Mr. Arbery have a right to resist that arrest because too much force was being used against him in the form of a shotgun? And we would argue that, yes, Mr. Arbery was authorized to go ahead and fight this because Travis McMichael was only authorized to make this lawful arrest using only that degree of force that's reasonably necessary to accomplish the arrest. So we feel this is completely applicable to these facts based on the defense. We have to disprove their affirmative defenses beyond a reasonable doubt, and if the jury believes this was a citizen's arrest, they were acting lawfully, our next argument is they used too much force, and Mr. Arbery was totally within his right, under the law, which he was, to resist that arrest. And we asked for this charge.
Judge, first of all, this is not Mr. Arbery's trial. If Mr. Arbery were on trial for resisting arrest, then he could avail himself to this particular jury charge. It doesn't fit. Okay, number two, the state has to disprove self-defense. The state has to disprove that they were informed enough to make a citizen's arrest, not whether Mr. Arbery, in his mind, experienced something in his mind and what his intent became to resist a citizen's arrest. That is not what the jury has to determine. They are not being asked on any level to determine Mr. Arbery's intent, and this court has forbade the state from going into Mr. Arbery's intent. This charge allows the state to get into his mind and argue his intent. You should not give this charge.
Well, I'm going to only give part of it, though. I think the second paragraph starts getting into some of what you've talked about here, but the first paragraph, which is an accurate statement of the law with regard to arrests, a person is authorized to use in making a lawful arrest only that degree of force that is reasonably necessary to accomplish the arrest. The mere fact that a lawful arrest is being made does not give the person the right to use excessive force or an unlawful degree of force upon the person being arrested. That's an accurate reflection of the law. The second paragraph then starts getting into what may have been going on with Mr. Arbery. The next charge, which is 316.41, that sentence also I think is appropriate, which is one upon whom an illegal or unlawful arrest is being made has the right to resist the arrest with such force that is reasonably necessary to prevent the arrest. So the court intends to remove that second paragraph under 316.40 and charge the first paragraph of 316.40 and also 316.41.
Will Your Honor then consider allowing us to, if you're going to allow the state to argue that Mr. Arbery had the right to resist one upon whom an illegal or unlawful arrest is being made has the right to resist, where would the state get the evidence from to support what Mr. Arbery was thinking and that his actions were in fact his choice to resist an unlawful arrest? Where is the evidence that supports that? Where would they get that from? And again, it's getting into...
Well, I'll tell you what, my thought is it's simply based on the video. I mean, the video itself. They're not going to get into what he was thinking at the time, but if they can present evidence of what happened, which is, I think, the best evidence out there, which is the video, then that's where that, if you're asking me, that's what I'm thinking in looking at this charge.
So you'll be essentially informing the jury that Mr. Arbery, or through the video, allowing the state to argue that Mr. Arbery interpreted that as an unlawful arrest.
I'm not doing anything.
Well, by giving this charge, you're
I'm
authorizing
saying
the state to argue that.
This charge is,
Yeah.
I mean, if the state wants to argue that, that's that evidence. They're not going to get into the head of Mr. Arbery other than to say, here's what you've seen. Because I agree with you. That's where the court has maintained
Right.
the entire trial.
I'm sorry. Court will let me know when it's my turn.
Yep, go ahead, Mr. Schroeder.
Your Honor, the court actually has the power to do pretty much anything. I didn't mean any disrespect, but the court shouldn't charge half of an excessive force charge and not give the other half. And to the extent that that's the position I'm being put in on behalf of defendant McMichael, we have to withdraw the whole request. The idea that the jury gets to decide if the McMichaels used excessive force, but that they don't get to consider whether the defendant used excessive force, that's just grossly wrong. I mean, and from Mr. Bryan's perspective, this is incredibly important. It's incredibly important. If the McMichael defendants used excessive force, it's an intervening circumstances. Mr. Bryan's off the hook for anything that happens after that. If Mr. Arbery uses excessive force in resisting an arrest, even if it's an unlawful arrest, it's an intervening circumstance. Mr. Bryan is off the hook. If both Travis McMichael and Mr. Arbery are both using excessive force, whether it's mutual combat or just contemporaneous excessive use of force, still, Mr. Bryan has an argument that he shouldn't be held liable for whatever happens at that point. To be coming in and saying that the state gets to argue that the McMichaels used excessive force, but we can't argue that Mr. Arbery used excessive force, that's wrong. And 3.16.4 doesn't mention excessive force on behalf of the defendant. I'm sorry that the state doesn't want to discuss Mr. Arbery's mental state at the time he turned and attacked Travis McMichael. I understand why they don't want to go there. And I understand that maybe the court may be considering the possibility that its 404B ruling in retrospect was incorrect. Because in an aggravated assault case, I don't know how you avoid it. But still, if you're going to charge the one half on excessive force, you got to charge the other half on excessive force when both parties have engaged in excessive force. And with all due respect, that's one reason why this tragedy took place. And I think the jury needs to have the full relevant law presented to them and let them sort it out, however long it takes back there.
The state does not have any intention in going into the mindset of Mr. Arbery. Mr. Arbery's dead. I don't know what he was thinking. We do know what he did. We do know what he saw. And it's not us that's contending the defendants were making a citizen's arrest. The defendants are contending they made a citizen's arrest. And so therefore, they contend they're making a lawful arrest. And the law is you have to use a degree of force that's reasonably necessary to accomplish that arrest. And one upon whom an illegal or unlawful arrest is being made has the right to resist that arrest with such force as reasonably necessary to prevent the arrest. This is the law, and we agree that it should be given. We would like the second paragraph in of 3.16.40. However, we leave it to the discretion of the court, but we request both 3.16.40 and 3.1641 based on the video itself.
Yeah.
Can I make one comment on it? Your Honor, briefly, and I'm just thinking out loud here about the consistency or inconsistency, and if it matters, between saying on the one hand, as the state has said several times, flight or fight, that Mr. Arbery was defending himself against an aggressor on the one hand, and on the other hand, he's simply resisting what he now perceives to be an unlawful citizen's arrest. That sounds to a jury possibly to be a very confusing set of laws, and I'm not sure which way the state will argue. Maybe they argue both and say, hey, take your pick. He's either defending himself against an aggressor with a shotgun, or he is resisting what he considers to be an unlawful arrest. They seem like they both can't be true at the same time.
There's no escape from his mental intent on this, Your Honor.
Well, I don't know, the 31641 is an objective standard.
I'm sorry, I can't hear.
Yeah, 31641 is an objective standard. It's not subjective.
Point 316.
31641
41.
Okay.
is an objective standard.
So is the previous one.
No.
31640 is an objective standard.
31640 actually talks about to the extent that person reasonably believes. So we start getting into the subjective with that. That's why I'm concerned about that paragraph, based
Your Honor.
upon the objection that was raised.
I'm sorry. I didn't mean to cut you off. My apologies. Perhaps the pattern charge needs to be adjusted. But when we're talking about an aggravated assault, this is an objective standard, a reasonable person in the shoes of the individual. That is the same standard. The pattern charge, it's basically one pattern charge, and it's the same reasonable person standard, reasonably objective, a reasonable person in the shoes of that person. That's the standard. And with all due respect, that's the reason the state didn't go into a whole bunch of evidence that people were expecting to hear. Because what's subjectively in the minds of the McMichael defendants is irrelevant. It's a reasonable person in their shoes. Likewise with Mr. Arbery. We don't have to get into the mind of the deceased, as if we don't do that in every murder case. We don't have to get in the mind of the deceased. It's what a reasonable person in his position, whether their actions are justified or not. There's no difference in the standard between 31640 and 31641, not intentionally, and if there needs to be an adjustment of the wording, that's fine. But clearly, that is the same standard being applied in both. And it is a reasonable person. It is an objective, not a subjective standard.
I'm actually going to agree with Mr. Goff on this point for that paragraph. Because once again, aggravated assault, were their acts such that they would put a person in reasonable apprehension of receiving serious bodily injury? You don't have to know what's in the mind of the person. It's, were their acts such that a reasonable person would feel this way? If the person being arrested, even if it's lawful, has the right to resist the use of excessive force to the extent that the person reasonably believes. So was this excessive to make a reasonable person think it's excessive and they needed to resist it? So on this level, the state agrees with Mr. Goff that the entire charge should be read, but of course we leave it to the discretion of the court.
I just see it differently. There's two separate issues going on, which is a lawful arrest and the degree of force that is allowed in a lawful arrest, which is 31640. And I understand, and that defines what the amount of force that can be used in the arrest. So that in this particular case, that would be Travis McMichael. What degree of force could be used? Only that degree of force that's necessary to accomplish the arrest, right? Just the fact that he can make an arrest doesn't allow excessive force. So there's the first paragraph. Then in the context of that lawful arrest, you've got the second paragraph. 31641 is actually a different idea. It is, if there's an illegal or unlawful arrest being made, what is the right to resist? And that's whatever's reasonably necessary to prevent the arrest. I still read that as an objective standard, but I mean, maybe I'm reading that wrong then.
The state agrees that that's an objective standard on 3.1641.
Okay, well, that's what I was wondering about. I read that as an objective standard.
We agree that we read it as an objective standard, but come back to the question that would be the sort of jury instruction you would be looking at if it were Ahmaud Arbery on trial.
To help the jury understand that he has the right to resist an unlawful arrest with reasonable force. It is totally improper.
Well, I see what you're saying. I see where we're getting hung up on two. I'm getting hung up on something different. I'm getting hung up on the reasonably necessary. You're getting hung up on was he actually thinking that it was an illegal or unlawful arrest?
Which is nothing concerning this case.
I see what you're saying.
This case is about whether they murdered him or not.
Okay, I'm sorry. We were on
Obviously,
parallel
we have a continuing
tracks.
different perspective.
That would be a good charge, and I resist a police arrest.
That's right.
Saying it was unlawful. And again, if it was Ahmaud Arbery on trial, great charge for him. I would be happy to defend that.
Yeah, in no way is the jury seeking to determine whether or not Mr. Arbery had the right to resist what was happening. They are simply trying to answer the question, did Travis McMichael perform a citizen's arrest under the law based on what he understood and believed, and did he have the right to use self-defense?
Okay, so I think I understand the argument. You're basically saying in this context, normally it's a police officer and an individual who doesn't believe they're being lawfully arrested.
And they get charged with assault or obstruction or something like
And they
that.
can use whatever force is reasonably necessary to prevent that
Correct,
arrest.
Your Honor.
And the state's problem, of course, is that's exactly what they're going to argue. They're going to get up here and go, They were making a legitimate citizen's arrest, and he's not entitled to do what he did, which is turn around the front of the
Well,
truck.
let's do this then. I understand what's going on here. I guess that would be a concern. I guess the court needs to consider it based on what I hear in closing argument then.
Well, Your Honor, I don't think it is
Well,
the.
well, let me explain, because the defense then gets into whether he was resisting or not, or whether he was acting in a certain way at a certain time. All of a sudden, this does become a charge that becomes quite relevant.
Here's where I think we would disagree, and I think Ms. Dunikoski would agree with this statement. There's two questions for this jury. Did we have the right to execute a citizen's arrest, and were we doing it lawfully? If the answer to either one of those is no, then everything after that makes us the aggressor, and Ahmaud Arbery can't have been defending himself. So that's how this.
And
Then,
Arbery would
Travis-
be defending himself against your unlawful aggression.
You're saying that.
Oh, did I say that? This is going on so well. Ahmaud Arbery only had the right to attack Travis if we were not lawfully executing a citizen's arrest. Because otherwise, if we can't meet those two tiers of citizen's arrest, we then are the aggressors. We're pointing a shotgun at this guy, and we didn't have any right to do that. That's the state's case. That's what we've made all the way through when we've described the two sentences of citizen's arrest. So that's why we come back to probable cause. If we had the goods to be able to effectuate a citizen's arrest, he could have run away, of course. He could have run away, could have sat, he could have flipped us off, whatever. But he wouldn't have had the right then to turn around and attack a man holding a shotgun. At that point, we switch out of citizen's arrest into justification and self-defense. So this sentence is only, this charge of 3.16.41 is only valuable if Ahmaud had survived and we were having an argument about what was going on out there. But we're not having that kind of argument. Ms. Dunikoski has every bit of law she needs to make her case without this piece.
If I could put one point on co-counsel.
Okay.
How many people am I gonna get attacked by?
Well, I'm not, just to having a conversation, I take it, and just to add a point, and I think it makes it clear, citizen's arrest never was completed. It ended. It was an attempted citizen's arrest that stopped at the point of the front of the McMichael's truck. And then it turned, if it was a citizen's arrest at all, up to that point, it then turned into a self-defense case from the defense's point of view, or a self-defense case from the state's point of
Let me
view.
say, I'm inclined to leave it there. I'll continue to think about it because there's more to it than just what happened in front of the truck. There are the various interactions between Mr. Arbery and the McMichaels on Burford. There are a number of interactions but mainly Burford is what I'm thinking about, all which is part of this larger interaction, which would be the attempt to detain or arrest, depending on how you want to say that. So if one thinks about it separate from the actual incident that resulted in the death of Mr. Arbery, and we look at it in the broader sense from the moment, for example, the McMichaels left the driveway and were trying to detain him or arrest him, he has the right to resist that in some way or run away, if necessary, to prevent the arrest. That's where I'm getting hung up. So I'm going to keep it in there for the time being. I'll spend some time over the weekend thinking that through, just as there's another charge out there that we need to. But at this point, I'll plan to give it with the understanding I'm going to spend some time thinking it through.
Thank you, Judge. So,
All right,
going on.
We got one standing.
Oh, sorry.
Your Honor, the court might consider the alternative of taking the last sentence under 31640 and adding it to the sentence under 31641, because respectfully to learned co-counsel, there is a third issue. That issue is assuming that the arrest of Mr. Arbery was unlawful. Does that convert or translate into a license to kill? I would submit not. The court needs to charge the jury that last sentence that in resisting, the person being arrested would not be authorized to use force that is unlawful or disproportionate to the amount of force necessary to prevent the unlawful force being used against the person. Under these facts, a jury could conclude, arguably, that the arrest was unlawful, but at the same time that the force used to resist that arrest was excessive and disproportionate. Otherwise, what we're doing is we're translating the right to resist an unlawful arrest effectively into a license to kill if we don't explain to the jury what it means to say whether such force is reasonably necessary to prevent the arrest or not. You need that last sentence, if not that whole paragraph, you need that last sentence in 31640 for the jury to understand the concept that the concept of excessive force applies both to the defendants on trial and to the person that is deceased. And all this talk about whether Mr. Arbery is a defendant might be relevant on issues like how you burden shifting in charges and all. They don't apply here. But in terms of the rules for the use of force, the fact that Mr. Arbery is deceased has absolutely nothing to do with the legal analysis here.
Moving on. Is that okay, Your Honor?
26832.
268, this is criminal trespass. I believe we all had agreed to this and it was pre-charged.
It was pre-charged.
Correct.
And then the state,
I do. I don't believe I agreed to the criminal trespass charge.
It was in,
I think it's
it was
already
in the
been
preliminary
charged
charge.
to the jury.
Well, now that the evidence is presented, if there's no evidence to support criminal trespass, then the court should not repeat the charge in closing. We object to that charge.
Fine. The court plans to keep 26832.
and then the state requested duty owed to a trespasser. And the state is requesting this because there's a duty owed by a landowner or his agent to not willfully or intentionally injure a trespasser. And this is based on Mansfield versus Caldwell Construction, a 2000 case. And the duty owed to a trespasser is to avoid willfully or wantonly injuring that person. Even when the property owner knows that it is customary for trespassers to come upon the premises, the duty owed is merely to refrain from willfully and wantonly injuring him once his presence is known, and no duty of anticipating the decedent's presence is imposed. In other words, you can't set traps. You can't go ahead and do something to harm this person. In this case, we thought that it was appropriate to let the jury know that just because they may consider, I don't know if they will, they may consider Mr. Arbery a trespasser, that somehow being a trespasser allowed someone to commit aggravated assault or false imprisonment or shoot him. And that is why we asked for this charge.
Interesting charge if Mr. English were on
I was going to say,
Thank you.
the court doesn't plan to charge on it. This addresses a landowner or his agent, and I think there was, I believe, through Mr. English himself, if not one other witness, discussion about whether they were acting as agents for the landowner. So,
And I didn't know if that was going to come out. I had no idea if Mr. English was going to go ahead and, because I filed these in July, say that, oh yeah, they were acting as my agent, and if they had.
so the court does not intend to charge that.
All right, and then we had burglary in the first degree, which everyone asked for, and it is pattern. We have burglary entry amplified, which is pattern.
Your Honor, before we move past 26211, we don't believe that is an accurate statement of the law. And I would remind Your Honor of the 10 million times that the state referred to the open secured construction site in this case. Under Georgia law, Smith v. State, 226 Georgia Appeals 9 at 11 to 12, previously cited in the charge submitted, a house under construction which is so completed as to be capable of sheltering people, animals, or property constitutes a dwelling under Georgia law. It's not simply whether it's intended or designed. If it is sufficiently complete that it provides shelter for property, then it is a structure covered by the burglary statute. And one can see in the video that the home, while not fully dried in, as a contractor might refer to it, because the doors and windows aren't there, but the roof is there, and the expensive tools and building materials inside are clearly sheltered from the rain and most of the wind, and therefore we're entitled to have that language from Smith v. State included when the court charges a jury on what a dwelling is.
The state disagrees. This is sufficient because it says a dwelling includes any house, building, or structure which is designed or intended for occupancy for residential use. It makes no difference whether the building or structure was occupied, unoccupied, or vacant. However, you may consider occupation status in determining whether or not the structure in question was designed or intended for residential use. So in this case, that covers everything. It's obvious it's a house under construction. Everybody's referred to it as a house. I don't think there needs to be any additional discussion about that. This pattern charge covers everything.
Well, Your Honor, if there's no disagreement or discussion to be had about whether the open, unsecured construction site constitutes a dwelling, then why don't we just go ahead and charge the jury that I charge you that the residence at 220 Satilla at the time of these events is a structure under the burglary statute or under the laws of the state of Georgia, and eliminate that so the state isn't backdoor arguing residual doubt as an excuse to convict these defendants.
Like that?
State asked for the pattern, Judge.
Yeah, the court will go ahead and charge the pattern just like I charged in the preliminary instructions.
And
So
then
the court is not going to charge the jury under Smith v. State?
I'm going to charge, I just said I'm going to charge the pattern just like I charged in the preliminary instruction. Yes.
So burglary entry amplified is also a pattern charge. And the next one, burglary intent to steal amplified, is also a pattern charge, and that continues from page 21 over to the top of page 22. And
Your Honor, I believe we, with respect to the top of page 22, we've also asked the court to charge on flight, and I think that was generally discussed earlier, but it comes up again here under the burglary statute, reminding the court again that a defendant on trial, there are presumption of innocence, there's all kinds of case law and burden shifting instructions, and that's what makes charging a jury on flight challenging when a defendant is on trial. But as the state has so frequently noted, Mr. Arbery is not on trial, but his conduct, again, is in question. If Mr. Arbery was on trial, could the state today, under the current law, get a charge on flight? I would think it still probably could. But all the complications involved in getting a flight instruction in the trial of a criminal defendant in a burglary case don't apply in this situation because technically Mr. Arbery is not on trial. And because he's not on trial, all those concerns expressed in the case law and in the adjustment of the charges don't apply here. There's no reason why the court could not and should not give a charge on flight in this case, particularly because the burglary cases themselves, there's a whole body of case law, particular burglary cases on flight, and that distinguishes this from any other case involving flight, given those cases, including Anthony v. State, 347 Georgia Ave. 807, Evans v. State, 148 Georgia Ave. 422, and Battle v. State, 178 Georgia Ave. 655. The particular case law for burglary demonstrates why a charge on flight is appropriate in this case.
the state disagrees that flight is appropriate in this case. As you know, flight has been disapproved. Flight has been approved for a limiting instruction on behalf of a defendant when the state presents some evidence of flight. It doesn't apply here in this case. I understand the court has already ruled and decided, or they can argue it, but that it's not appropriate as a jury charge because it has only been used to limit under a limiting instruction.
Yeah, no, the court doesn't, as I said earlier, the court does not intend to charge on flight. That doesn't prevent the argument. Again, the charge on flight, even I think at this point, would get into some of this discussion about what was in Mr. Arbery's mind at the time, and so again, the court is not going to charge on it. The argument based on, if the argument is made based upon reasonable conclusions made from the evidence presented, that's fine, but I'm not going to charge on it.
All right, Judge affirmative defenses by the McMichaels. I think this is old pattern because I recognize it. However, the new pattern is a little different, and that is 3.0000. And it reads this way: the defendant has raised a defense that even if he committed the act described in the indictment, there are circumstances that, and then it has parentheses, justify, excuse, mitigate it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. And it's sort of just a general thing. So I think the state would prefer, and well, that's good law, 3.00.00, that it should be generically done for the defense has raised a defense that even if he committed the act described in the indictment, there are circumstances that justify it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. And then, of course, we're going to go into justification in the use of force in defense of self or others.
So the objection to what's in there, self-defense is an affirmative defense, which is a defense that admits the doing of an act charged but invokes a legal defense to justify it. And once an affirmative defense is raised, the burden is on the state to disprove it beyond a reasonable doubt.
Yes, I prefer the wording from the pattern that I just read versus how they charged it, because it only talks about self-defense. And the problem is they've also got the affirmative defense of citizen's arrest. And so the way I just read it is, an affirmative defense is something that basically says, I'm justified in doing what I did. And it doesn't list self-defense, it doesn't list citizen's arrest. It's a little bit more generic because it does encompass both of their defenses that way. As opposed to specifically saying it's a defense that admits the doing of the act charged but invokes a legal defense to justify it. The state does not think that the words "but" invokes a legal defense to justify it were patterned previously and are patterned now, and the state just would prefer 3.00.00.
I'm trying to keep up. You
Yeah, I
can speak
think
very
that-
quickly, and so I'm trying to figure out which part of this you say is no longer the suggested pattern instruction of 3.0000, which was our defense request to charge number 9.
Right, none of it. I'm sorry, I'll read it. This is the new pattern jury instructions, and I'll read it very slowly. 3.00.00, affirmative defense, definition, burden of proof. The defendant has raised a defense that even if he committed the act described in the indictment, there are circumstances that justify, in parentheses, excuse, parentheses, mitigate it. Once this defense is raised, the state must disprove it beyond a reasonable doubt.
I like that.
I'll give you a page out of this
Okay.
if you want to take a look at it. That's the charge itself.
Yes, I
Takes
like
the
that,
word
except
self-defense.
where does, do we then say self-defense is an affirmative defense?
Oh, it's the very next thing.
Okay, all right. No, I'm not fighting with you. I'm
Right.
just trying-
No, no, it's the very next thing. I believe we both asked for pattern on 3.10.10, and it's the pattern which starts off sometimes, well, that's not the pattern.
You're probably looking at the old pattern, 3.101. Let's see.
Must have just on that time switched back. I didn't
Yeah,
realize.
there's-
I'd done that.
The next is, on the new pattern, the next is 3.10.10.
No,
Someti-
3.10.10 is actually self-defense. It's actually 3.01.10,
That's right.
just to have a lot of fun with the numbers.
Generally, yeah.
Right,
All
so
right.
justification generally. I don't think anybody's asked for justification generally. So I think we need to probably include 3.01.10 and modify it for the facts of this case.
Well, I actually like that new language better. It
Okay.
reads better.
Okay, so here's the thing. I think, let's look at it, I'm talking to the defense here. Let's look at 3.01.10 over the weekend because like B, C, D, E, and F don't apply. And then it says when the person's conduct is justified under OCGA sections.
Yeah, I normally tailor that to the actual, I mean, in this case, I don't think anybody's disputing what the affirmative defenses are. And so it
Yeah.
can be put in, let's see, the defendant has raised a defense I guess the defendant has raised defenses, or the defendants have raised defenses that even if an act was committed as described in the indictment, there are circumstances that justify it. Once such a defense is raised, the state must disprove it by a reasonable doubt, or beyond a reasonable doubt. Then 3.01.10, the fact that a person's conduct is justified is a defense to prosecution for any crime based on that conduct. The defense of justification can be claimed in the case of self-defense and citizen's arrest, or, I guess it would be and/or citizen's arrest.
Correct,
And/or citizen's arrest. And then you go into 3.10.10, which is justification.
Yes.
Okay. I'm not sure whether, I said that, but I'm not sure whether we got that. Did we get that? I'm not getting anybody's attention.
We follow,
Did we get that?
we follow.
All right. Just because I said it doesn't mean it was written down at the time I said it. Just want to make sure we've got that. All right, we will attempt to make sure that language then appears in the charge. Okay?
All right, so 3.10.10, justification, use of force. This is the self-defense charge. I believe, based on Travis McMichael's testimony, that he was worried about his dad in the truck, that they are going to request, and correct me if I'm wrong, himself or a third person.
Correct.
All right, no objection from the state. The state understands that.
To defend himself or a third person?
Correct.
Okay.
And then the problem that we have here is the first part: a defendant is justified in threatening or using force against another when 1, 2, and 3 is fine. Then we have a defendant is justified in using force that is intended to or likely to cause death or serious bodily injury. So we've got two different sections. We've got one that's just basically, hey, we're going to have a knife fight or a fist fight, and the other one is likely to cause death or serious bodily injury. So I think we take out the first subset of 1, 2, and 3, and it just goes right into
No.
likely.
Because there's two different acts that are alleged by the state. The pointing of the pistol would be self-defense also. Of the, I'm sorry, the shotgun.
You asked for A and B.
Yeah. I left it in there because that's why I understood it too. There are a couple different acts which this covers, which are all arguable before the jury. And this allows the parties to argue them either as use of force generally or use of force, deadly force. This just gives the jury what the standard is for both or either, depending on what's being argued.
Okay, I understand. So then when we come down to a defendant is justified in using deadly force, he reasonably believes that the use of such force is necessary to prevent death or serious bodily injury to himself, a third person. Well, at that point, if we're talking about deadly force, not the pointing of the shotgun, but the shooting of the shotgun, third person doesn't apply here.
It does apply.
I'm sorry.
It does apply.
not?
Yeah, because if the shotgun is taken out of his hands, he's testified he was afraid he was going to take the shotgun and use it to shoot himself or his father.
That's a arguable fact.
All right. The commission of a forcible felony, which means a felony that involves the use of force or violence against another. And of course, that felony is blank.
We would ask for aggravated assault, using fists and punching, and trying to take the shotgun and use the shotgun.
Trying to take the shotgun would be an aggravated assault.
Well, and the fists punching, because the evidence is he was punched all over the face and the side. There was some testimony that
Is a
fists
felony
are.
which has been defined.
I think,
No, it hasn't been defined.
yes, it
needs
has
to
been
be
defined by this point.
It has to be defined. Let's see.
You might have to, in the definition of aggravated assault, where you define use of a truck, use of a gun, may have to also add use of hands and fists.
Well, actually, or violence against women, aggravated assault is a felony, which can also be defined as.
Well, actually, it actually doesn't say, it says pickup truck in one location, but it adds to the indictment, it says by objects when used offensively against another person. And so they're gonna argue, well, hands and fists are objects when used offensively against another person can cause serious bodily injury. So it actually just generically says objects.
Yeah, but then we get into the whole, there's language though that at least I use when we talk about fists that define a fist as a weapon depending on how they've been used. So you would need that language, I think, if we're gonna go down this path.
Okay, state understands.
And aggravated assault can also, because I've already defined aggravated assault as a felony. So aggravated assault can also occur with use of fists if you determine them to be a deadly weapon.
I think an offensive weapon.
Offensive weapon.
Yeah.
Okay, so what I've got here is B, the commission of a forcible felony, which means a felony that involves the use of force or violence against another. Aggravated assault is again a felony which can occur by use of fists if they are used as an offensive weapon.
Yes, Judge.
Sounds good with us.
Okay. All right.
And then on to the top of page 23, we of course have a defendant is not justified in threatening or using force if he, and we have our second thing, which is committing a felony, and we ask that all three felonies, aggravated assault, false imprisonment, and criminal attempt at false imprisonment, which have previously been defined for you.
It sounds to me as if we're now circular after we've just defined justification. I mean, isn't really what we're saying just the third dot? We're not justified in threatening or using force if we're the initial aggressor.
You look at 310.
Judge, the state's position, and always has been, is that the defendants are doing all three of these things, and the state is going to argue all three of these things. They committed felonies against him, they were the initial aggressors, and that they attempted to provoke him, but provoke his threat or use of force in order to use that against him because they wish to harm him. I mean, we're going to go ahead, that we're going to argue all three, and we feel that the facts of the case, we can make a reasonable inference that that's what the defendants were doing all three of these things, and they're not justified. So we want all three of those in there. We feel we can make a reasonable inference from the evidence based on that.
No, I don't think that sentence is included in the pattern. Which one? It says the defendant is not justified in threatening or using force. This is on 31010. If he provokes the threat or use of force against, intending to use that threat as an excuse to harm. Number two is attempting to commit a felony. Blank is a felony.
Committing a felony.
Yeah, I see it. I
Yeah.
see it. It's the initial aggressor.
Yeah, I removed the third, which is the combat, not third, fourth, which is the combat by agreement language. That clearly doesn't apply.
Your Honor, this does bring back, though, that point that we were raising very early on with the court about the idea of initial aggressor and the law around other acts that establish who the initial aggressor is. This is sort of where, remember we were talking about 404B acts? And where you start having that term initial aggressor, this is why we were focused on that term, because the law thinks about, is it possible that Mr. Arbery could be the initial aggressor, which that evidence supports, even though it's not known by the
Yeah,
McMichael.
no, and I've considered that. To me, this is something, again, that is or can be determined by the jury by looking at the video as well as taking into consideration. I mean, it depends, I realize, on the definition of when this started. But the court is going to include that, because the way I see it is the jury can make that determination without going beyond the evidence that's been presented in the case.
Your Honor, I got to object to this third portion of that being the initial aggressor. It's not tailored to the case. This is a citizen arrest case. Anytime someone's attempting to arrest someone, they are always the aggressor. They're entitled to use force to do it. So if the state wants the court to charge this, they're going to have to adjust it to the facts of the case. Or the court's going to have to give more specific instructions on use of force than I see in this charge. Anytime someone, including a police officer, any police officer is arguably the aggressor if they are trying to arrest someone, because arrest inherently involves the application of force or potential application of force. So to just give this pattern justification charge without additional or instructions or qualification of that is misrepresenting the applicable law in this case. If they're trying to make a citizen arrest, of course they're the aggressor.
That makes some sense. The remedy is the issue of how the language you use, and it would seem to me to be the initial unlawful aggressor might solve that problem.
Your Honor, the state's position is that they were the aggressors. Their defense to that is, we were doing a citizen's arrest. So they're trying to put the cart before the horse by going, oh, well, you have to do, they're the initial aggressors. If they're trying to say they're not, then they get to put up citizen's arrest, and then we have to disprove it beyond a reasonable doubt. But our opinion is, it's the initial aggressor. You start this, you don't get to claim self-defense.
Let them present that argument to Cobb County SO when this case is over. I mean, you're not an aggressor simply because you're trying to make an arrest. And the assumption that you're an aggressor because you're doing that, that's an affront to the entire law enforcement community, aside from being not adjusted to the facts of this case.
I think it is an unjustified initial aggressor. I think that's accurate. I mean, if they're not, let's see, is the initial aggressor is an unjustified initial aggressor.
The state respectfully asks not to put unjustified in there. And the reason for this is, once again, the cart before the horse. The assumption is that, how do I put this? Someone who's the initial aggressor, you go, hey, you were the initial aggressor. Well, then you step in front and you go, hey, I wasn't the initial aggressor because of these facts. To say, well, state, you have to go ahead and say unjustified initial aggressor, really puts the cart before the horse in this case, because the state's going to argue they're the initial aggressors. They're going to argue citizen's arrest. And I really would like to stick with pattern on this, Your Honor, and putting in unjustified initial aggressor. That means somehow there is justification to be the initial aggressor. This conflation of law enforcement officer making a legitimate arrest is completely different than the affirmative defense to a murder case of citizen's arrest. So to compare the two of them is not correct. That's not what's happening here. This is not for law enforcement. They're not law enforcement. The defendants aren't. This is a self-defense case, and a defendant is not justified in threatening, meaning putting up a shotgun, or using force, meaning shooting someone, if he is the initial aggressor. Not the initial unjustified aggressor, just the initial aggressor. So
I guess what it really comes down to is really the issue is the citizen's arrest and whether the citizen's arrest was proper.
mm-hmm.
If it was, then this whole idea of initial aggressor, I mean, the aggression was justified. So what I'm trying to avoid is this becoming the issue as opposed to citizen's arrest, which is really the core of it, because the citizen's arrest is the justification.
The citizen's arrest is the justification for being the initial aggressor,
Right.
okay? The citizen's arrest is, I guess, the justification also for, hey, we committed these felonies. We're agreeing we committed these felonies, okay? But my concern is that putting in unjustified initial aggressor somehow elevates this and it's going to start conflating self-defense with citizen's arrest. I feel that they can go ahead and make their argument that, hey, he was acting in self-defense, and the reason he was acting in self-defense is he was attacked. We know that's coming. And he was unjustly attacked because he was making a citizen's arrest. And therefore, that takes it out of the initial aggressor category. So the state's just concerned by adding language here, it really puts a different onerous on the state and the state's argument.
One final point, Your Honor, is a citizen making a lawful citizen's arrest stands in the same shoes as a police officer. And there's case law, plenty of case law on that. There's no difference between them at that point. So a police officer making the arrest, as Mr. Goff said, would almost by definition be the aggressor in that situation, even though he's allowed to do that. So I do think there needs to be some modification of that adjective.
Could the state perhaps show us a case, a precedent? Of course, there aren't many precedents in Georgia where police officers have been prosecuted for anything, but can they show some precedent where in an arrest context this charge is appropriate? Because I can't find it. All the cases I see draw no distinction when making an arrest between a police officer, a bail bondsman, or a private citizen, here or anywhere else. Now, I've submitted a charge, and I know the state doesn't like it, but the state is the one conflating issues here when it comes to citizen arrest. They're the ones conflating the issues. They're confusing issues that don't matter in this case. The authority of a private citizen to investigate crime is different than that of a police officer. We agree. The circumstances under which a private citizen may make an arrest are more limited than those under which a police officer may do so. That's true. And it is certainly true that the consequences of an unlawful arrest by a private citizen are very different than the consequences of a police officer. But the application of the rules of force is identical. And we certainly want to take that up, certainly today, because I got my little layout, I forget what they call it, from the toy store, and I got my police car, because that's going to be part of our demonstrations in front of the jury. So if we're not allowed to argue that, we sure better know before the day is out. Among other things, I'd like to be able to go take the police car and the street diagram back and get a refund.
Your Honor, the state does have case law.
Okay. Can I focus us back on where we are? We're dancing on the head of a pin, okay? I'm going to charge it as is an unjustified initial aggressor. Okay, let's keep moving.
Reasonable beliefs, I believe that's pattern and everyone has requested that. No duty to retreat, pattern. Justification, use of force, defense of property, that is something the state has requested.
Can I wait? I'm sorry, can I slow down? I'm sorry. 310.13, no duty to retreat, is actually not what the statute says. The statute, and I know there's code sections, so we don't want to necessarily use the statute, but it says a person who uses threats or force in accordance with the code sections relating to the use of force in defense of self or others has no duty to retreat and has the right to stand his or her ground and use force as provided, including deadly force. And I would ask the court to include that phrase, including deadly force. That's 16-3-23.1.
You join.
Agreed.
They talked about going too fast.
I'm sorry.
Can you give me the code section?
Yeah, 16-3-23.1.
So, Your Honor, what we have here, it appears, is there's a distinction, there's a difference between the pattern charge. The pattern is 3.10.13, and it is, as the court has right here, a person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. And of course, the statute actually says, has no duty to retreat, this is the very last sentence, or last part, has no duty to retreat and has the right to stand his or her ground and use force as provided in said code sections, okay, which are self-defense, defensive habitation, including deadly force.
Can I back up? I'm planning to charge it the way that it is, and let me just tell you, it is under 310.13. 310.13 provides as authority 16.323.1, but it also goes through a number of cases, including most recently Reed versus State. But we've got 6 or 7 cases that this particular charge has been tailored with, and I'm comfortable that it's an accurate reflection of the law. I understand the statute's there, that the charge itself cites the statute and the cases underneath it.
Okay.
And may we just streamlining purposes here, the next one, 3.14.10, use of force in defense of property, that I don't see any authority, any factual basis for that. We'd ask that that be removed.
Likewise, Jordan.
Well, Your Honor, the reason we asked for this is kind of the last part. The use of force that is intended or likely to cause death or great bodily harm in order to prevent a trespass is not justified unless the person using force reasonably believes that such force is necessary to prevent the commission of a forcible felony. Burglary, theft, and trespass are not forcible felonies. So basically what the state is asking is that you inform the jury that you can't go killing people in order to prevent them from trespassing or committing burglary or theft, because this appears to be a, hey, he's a burglar, must have stolen that stuff off that boat back in November. We're justified in using lethal force at this point. So the state wishes for this charge to be given so that the jury's not under the misapprehension that burglary somehow allows lethal force.
Feel pretty sure that nobody thinks that there's such a thing like that, especially after the admonition. Ms. Dunikoski is the only person who would ever be arguing anything like, we thought he should be killed because he might have been a trespasser. This is not somebody coming onto that property and just shooting him dead like that. That description sounds like social media, not like what happened in this trial.
Yeah, the court doesn't intend to charge on use of force in defense of property.
Yes, Your Honor. Excessive force, 3.16.20, this is the pattern charge.
Why do I feel like this is the third time we've read this charge?
It's not. The reason you feel that way is because Mr. Goff brought up excessive force repeatedly during the resisting arrest part, which isn't part of that. So I think that's why you probably think you've heard it. But this is the first time excessive force is being used here.
Well, hold on, but that gets back to the prior discussion, because how many different times are we getting charged about excess? I mean, I want to charge once. I think some other people in the room don't want to charge at all. But to be charging it multiple times, the problem is we have specific rules of force that apply to the context of an arrest, and those supersede general rules that would otherwise apply in the justification charge. Justification covers all kinds of force cases. The resisting arrest and the right to make the arrest, the rules of force that apply are specific to this case. And that's what the jury should be charged with. There's no reason to be given this 316.20 charge at all.
Actually, there is, Judge, because what we've got excessive force relates specifically to self-defense. A defendant is not justified in using excessive force while acting in self-defense. So this relates specifically to self-defense, which is why it's right here. And if you decide that a defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. So, Judge, that's of course the core of the state's case. You pulled a shotgun on an unarmed jogger. It's excessive force, even if we get there. Because, of course, we've got to overcome citizen's arrest, then we've got to overcome self-defense, then we've got to overcome, well, even if you think it was self-defense, it was excessive. The previous excessive force related specifically to making a citizen's arrest. So this relates to self-defense specifically, and we ask that you give it as the pattern.
If I may, Your Honor. What we have here is a situation that's comparable to what we used to call a sequential charge problem. The primary charge in the primary defense in this case is citizen arrest. Self-defense is a secondary defense. And justification in the rules of force allowed in a citizen arrest context take priority over the rules of force in the general justification charge. For example, if a jury finds that the McMichael defendants did not use excessive force in attempting to effectuate an arrest, then how could they be authorized to use that force under the citizen arrest, but not authorized to use that force under self-defense? That would make no sense. You wouldn't even get to addressing the excessive use of force under justification. You wouldn't even get to self-defense until after the jury has considered whether the defendants have lawfully effectuated a citizen arrest. You wouldn't get there. And this is implying to the jury that there's two different standards for excessive force in the one situation and the other. There isn't. The rules of force that apply in this case, which is an arrest context, are what they are. And the state doesn't get to come back in and say, well, maybe it wasn't excessive when they were trying to arrest him, but somehow it is excessive for self-defense. That's just going to confuse the jury. There's only one standard as to whether it's excessive or not. The state doesn't get two bites at the apple.
I think that's my issue, Your Honor, is it's confusing, and here's why. 31010. 31010 is called, yeah, I'm seeing you flipping, I'm just giving the title of it. Justification and the use of force in defense of self or others. So there's a whole charge that deals with this already. And in that charge, it tells you you can use force if you reasonably believe it's necessary. And then it goes into saying you can use deadly force if you reasonably believe it's necessary and for the reasons that you can use it. It's explained and encapsulated in this charge. Excessive force is now another term that the jury's being asked to consider. And in a case like this, especially where the state is saying, none of this should have happened, it all could have been prevented, it's all excessive, I think that is going to be now confusing to the jury, especially where it's laid out very clearly in the charge that deals specifically with it. So I think it's not only repetitive, but now it's going to be confusing.
We ask that you please give the pattern, Judge. Excessive force is a central concept to self-defense because lots of people can go, well, I use self-defense, but you went overboard. It's excessive, and that is usually what we've got. And here, it's essential to the state's case because while Mr. Goff just argued they don't get two bites at the apple, that's not what's happening here. Mr. Goff asked for 3.16.40, which is the right to resist an unlawful arrest, where the excessive force comes into play. And that's talking about the arrest. That citizen's arrest. This specifically relates to self-defense, and it is part of the pattern, and it is part of the law that goes hand in hand with the concept of self-defense. You want to claim self-defense, that's great. But if what you did was excessive and resulted in someone's death, then the defendant's actions would not be justified. And that is what the state is going to argue here.
See, that's why it's confusing. If what you did was excessive and it resulted in someone's death, the state is defining excessive as something that results in someone's death. But the law allows the death of a person, and it's justified. And that's where 31010 makes the most sense. This confuses the issue and now allows the state to argue that death is, quote unquote, per law, per se, excessive.
No, that's not what we're arguing. Actually, the whole entire thing says, if you decide the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. It is not confusing at all. It's obvious the defense does not want this because their client pointed a shotgun at an unarmed jogger. So of course it was excessive. It's excessive just based on the video alone. And I understand why they don't want it, but the idea that it's confusing when it's been the pattern for years in every single self-defense case?
You know what happened?
Your Honor, if the state wants discharged twice, then we, again, sequentially, I would humbly suggest that the jury needs to be charged first on citizen arrest and the use of force in citizen arrest, and then secondarily as to self-defense. Only after the jury is determined that the use of force wasn't justified in the context of the citizen arrest do they get to the self-defense issue. And it's the only way to make what the state's doing palatable and plausible where it's not reversible error.
Okay. Yeah, now 31010 simply addresses when force can be used, the justification of force. And I've gone back through the language. I've got the charge book in front of me, taking a look at it, and having read through it, it does. It discusses when you are justified in using force generally. It does not, 31010, or any of the 310s for that matter, address excessive force, which is this separate issue, which is under 31620. Let me just get to 316s.
So then, Your Honors, you've got also, don't forget, at the bottom of 31010, where it says a defendant is not justified.
Right, correct.
So this is now a,
It's not justified, right. When you can't justify the force, which is different than using excessive force when justified. Those are two different issues.
okay,
That's what I'm reading. That's why I'm going through it, because 31010 doesn't actually address if you're justified, if you can use 31010 and claim you are justified. What if it goes overboard? And that's where we get to 31620. So it's two different concepts that I'm reading, and based on that, I'll go ahead and keep it in.
Thank you, Judge. The state then asked for revenge.
And we oppose that, there don't see any evidence for that one.
We oppose it. Again, it's not supported by the evidence in the case.
Your Honor, it states the defendants are not justified in threatening or using force against another person solely in revenge for something that the person said or did on a previous occasion, no matter how serious the past wrong may have been. On February 11th, 2020, Travis McMichael testified that he saw Mr. Arbery, and Mr. Arbery, lifted his shirt up or something, or then put his right hand in his left pocket, or made it seem as if he had a gun. And it scared him. He got the heck out and he went on home and told his dad, and they got their guns and came back down. It scared him. You could hear it in his voice, and his attorneys even asked him, is that you breathing there? And so at this point in time, the state's contention is that it's upsetting. No one wants to be scared. No one likes someone who scares them. No one likes the unknown. So at this point in time, our position is Travis McMichael's mad at this guy. Travis McMichael is upset and mad at Mr. Arbery. He scared him. He ran home. He had to call the police. There was this whole thing that happened, and now he's out to get him. And you can't be out to get somebody and do revenge on them for what they had done previously. And I know they're going to say, well, it actually justified his behavior because he was afraid of the guy and wanted to pull the gun out on him because he was his threat. But our position is it's actually the other way around. He's mad at him. He was scared. And this is revenge. This is, you can't do this. You can't come into my neighborhood. You can't go over that house and trespass. You can't be doing these things where I live, and I'm taking it out on you because you've been over at that house that's only a few houses down from mine, and I don't want you here. And therefore, you just can't go after somebody in revenge for previously being on a property a few houses down from your property, or for scaring you one night. And that is an argument the state wishes to make, and that is why we can make that reasonable inference based on the facts of this case and the evidence and Travis McMichael's testimony here that this was actually revenge for the prior interaction that they had on February 11th.
yeah, there's nothing in this case to support it. He never testified about it. obviously was concerned, but the state wants to argue, we understand what that means, but not to give a charge on
I don't
revenge.
intend to charge him that.
I'd like to hear this argument, Doug.
Verdict generally is the pattern.
So maybe I can accelerate this. Does anybody have any objections to verdict generally, multiple defendants, verdict form, and I'll reference the fact we're getting separate verdict forms. Court has no interest, sympathy, responsibility for sentencing, deliberations, unanimous verdict, and retire to the jury room.
None from the state.
Oh, good. A couple things came up though, Your Honor.
Well,
Still got our
Oh, we did? Well, just on those, because we're going to
Those,
take a short
nothing,
break.
but we got two that have come up.
Okay. Take a
Well,
short
we
break.
still have to go back to where the court said, page 19, our request to charge on probable cause, and the one that you put in there, oh, I'm sorry. Oh,
I could use a
sorry.
break.
Okay, we're going to take a 10-minute recess. Thank you. Clean up on what's left out there. So just before we broke, Ms. Hoag, you'd mentioned page 19, and I assume you're referring to the probable cause charge along with this suspicion language?
Exactly, Your Honor. It is our request to charge number 4 on probable cause. It looks as if you put in some of it.
All right.
I
Well,
appreciate that.
I left that in the back.
What page?
Yeah. Yeah, hold on a second.
Oh, it's on page 19.
I left everything in the back. Yeah, all of it, the big, thick group.
This is all that was back there, the first draft was
No, that's fine. All right, I've got McMichael's first request to charge, said it's number 4.
Number 4. It looks as if you have the first portion, upon reasonable, private person may arrest an offender upon reasonable and probable grounds of suspicion, that is, on probable cause, and then you indicate if the offense is a felony
Actually,
and,
you did.
oh, that's me, I'm sorry. Oh, all right, that's right. And that's as far as you went. You didn't,
I just took out the if the offense is a felony and the offender is attempting to escape,
all right.
and then got into the facts necessary.
Fair enough. And then you got into the and then you went to the facts necessary to establish probable cause. You gave me all of that. Ooh, I have it. Sorry, typos on mine. Beyond a reasonable doubt at trial. The test merely requires a probability less than a certainty, but more than mere suspicion or possibility. Then I was asking for that last paragraph. In determining whether probable cause existed, the totality of the circumstances must be considered. And these are based on those cases below. Probable cause can be based upon the collective knowledge of others, so long as there's some degree of communication between them. I also, right now, would like to add, when we're if you would look on state's request to charge number 57, they have a nice quote from the forehand case, page 22.
Forehand, got it.
Right in the middle of it, it says that the officer need not see the act which constitutes that the crime takes place, but I like if by any of his senses he has personal knowledge of its commission, which is consistent not only with forehand, but also the language of those other cases. So if we were to stick that clause in as well to help explain where probable cause can come from. So it could be based on the collective knowledge of others, you know, any of his senses, he has personal knowledge of its commission. Actually, that's very clumsy, but where maybe with you have it in front of you, wherever you thought that clause could come in. Because I think, you know, obviously the state and the defense would agree that that's how one develops probable cause. what you hear, what you see, what you smell, what you taste, what you understand, what you, through all of your senses. Or just the development of probable cause through all of your senses. Because you made a good point, Your Honor, between the hearing things, seeing Matt Albenzi.
So I'm confused a little bit then. You're asking that that be dropped into the probable cause charge?
In determining, when we're talking about the totality of the circumstances, where probable cause can be based upon just something having to do with information gathered through any of the individual senses, but it also can be based upon the collective knowledge of others, so long as there's some degree of communication between them.
So, Your Honor, if I may, first off, by the existence of any of his senses is already going to be charged on the top of page 19. So that is up there with terms are synonymous, and it talks about if by the exercise of any of his senses he has knowledge of its commission.
Oh, okay.
So that's already there.
That's fine.
Yeah.
I was just getting late, and I didn't,
Okay.
I knew I liked that line.
And it's there. Your Honor, the problem the state has with this request is that the state agreed that if we were going to put this in, that we wanted it if the offense is a felony and the offender's attempting to escape. If we take out those two lines, then it's a private person can arrest the offender upon probable cause. But that's not really what the statute says. It says you have to may arrest the offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, that's when the probable cause comes into play. So the state, if we're going to do the definition of probable cause, would agree with the defense that the offense is a felony and the offender is attempting to escape.
Okay, well, maybe looking at some of my concern then with this suspicion alone. Gets satisfied if, going off the request to charge number 4, I do the entire thing, including 1, the offense is a felony, and 2, the offender is attempting to escape, and then I'm comfortable taking it down to and including the line in determining whether probable cause existed, the totality of the circumstances must be considered, because then you go back up to this language that the state's referred to at the top of 19, talking about use of senses and has knowledge of the commission or that the accused admitted that such crime is being or has been committed.
And that final line, based on the collective knowledge of others, so long as there's some degree of communication between them.
Yeah, my notes, the problem or the concern I have with that's talking about police cases. I know that I think Goodman and Burgesson were at least police cases.
All
I don't have
police
notes.
cases.
They're all police
All
cases?
police cases.
Judge, I just want to make clear, for the first time maybe in 30 years, I disagree with Ms. Hope.
Get the court reporter to market.
We are conflating immediate knowledge, presence or immediate knowledge with probable cause. There's not a single case that distinguishes what probable cause means for a policeman versus a citizen. Probable cause is the level of suspicion of a reasonable and prudent person under the totality of the circumstances. It's Fourth Amendment law.
Yeah.
There's
Yes. And I think I agree. And I was just, I don't know, I got caught maybe at the end of the day into a discussion in trying to parse this even further. I think in determining whether probable cause existed, the totality of the circumstances must be considered as appropriate language. My concern about the last sentence is we start getting into these police cases that are very different circumstances than we have here. But I think totality of the circumstances allows the parties to argue everything that was known, appropriately known for probable cause to be developed in this particular case.
Well, the other problem I'm having, Judge, with this charge is what Mr. Rubin just stood up and said is nowhere in this charge. There is no definition.
no.
And that's a problem for me because Right now, the definition of probable cause has been given to this jury by Travis McMichael and not by this court. So unless the actual words of this is what probable cause is in there, this charge doesn't provide the jury with a definition of probable cause.
And like I said, the definition of probable cause is the same whether it's a citizen or a police officer. It's Fourth Amendment law. It's a seizure of a person.
I see what you're saying.
Yeah.
And so actually the definition that Travis McMichael
Well,
gave is Fourth Amendment law.
The way to solve it here then is adding in determining whether probable cause exists, the totality of the circumstances must be considered to the end of it. I think in the middle though, where it says a private person may arrest an offender upon reasonable and probable grounds of suspicion, that is probable cause, which is defined as.
The level of suspicion. Yeah.
Now we need to decide what that language is.
Well, there's plenty of cases that define probable cause.
There are, and I pulled I pulled a whole bunch of them. But yeah, this is Michigan versus D. Filippo, which is a 1979 U.S. Supreme Court case, 433 U.S. 31 at 37. Probable cause exists if the arresting officer has knowledge and reasonably trustworthy information about facts and circumstances sufficient for a prudent person to believe the accused has committed an offense. There's a bunch of other cases out there. It's slightly different. Probable cause is defined to be the existence of such facts and circumstances as would excite the belief in a reasonable mind that the person charged was guilty of the crime for which he was arrested or prosecuted. And that's McGonigal versus Treadwell, 216 Georgia App, 850. It's a 1995 case. A lot of the cases, even Adams versus Carlisle, which we've been talking about here, 278 Georgia Appeal 777, 2006.
Can we agree on a definition then?
Yes.
Because that then solves the problem that I was working through, which is the way this discusses probable cause. It simply talks about reasonable and probable grounds of suspicion. But then if we further define probable cause, I think that addresses this suspicion language to the satisfaction of the court.
Well,
If we could just not do it right now, because there's a lot of U.S. Supreme Court cases that define it under Fourth Amendment law. If we could maybe communicate.
When Mr. Hogue emails me this short brief, the art of the brief is important on Saturday. Maybe we can just email that to the court.
That would be great.
I will email you what I've got, Judge.
All right.
And I'm openly saying that I agree that Mr. Rubin was right, that we were disagreeing, but now I agree with him.
We've
So
reconciled.
there's been there's no divorce.
Okay.
So,
All right.
Judge, I want to make sure what you're saying is that once we go ahead and say the definition of probable cause is this, and we've all agreed that the definition of probable cause is that, that will be what is charged.
That will be what's charged, and I do not then intend to charge this language about suspicion because, again, probable cause has been defined and explains when, under what circumstances that arrest can be made.
Okay. So I just want to be clear. We're not using any of this language from defendants 4. We're just using the probable cause language.
Well, the
No, let me
statute
read it.
says- Yeah.
Okay.
What I plan to charge is a private person may arrest an offender upon reasonable and probable grounds of suspicion. That is, on probable cause, which is defined as blah. The facts necessary to establish probable cause for arrest are much less than those required to prove guilt beyond a reasonable doubt at trial. The test merely requires a probability less than a certainty, but more than a mere suspicion or possibility. In determining whether probable cause existed, the totality of the circumstances must be considered.
Excellent, with one exception from the state. And that is, of course, that is on probable cause defined as this, if the offense is a felony and the offender is attempting to escape. As requested by the defense, because we're relating it back to the citizen's arrest. And so a private person may arrest an offender not just upon probable cause or grounds of suspicion. The citizen's arrest statute actually says only when it's a felony and the offender's attempting to escape. So that has to be included in here in the state's opinion.
Okay, which may then get us back, though, to the debate which Mr. Hoag's going to address.
Right.
I will take that into consideration. It probably depends a little bit on where we land after I get this additional brief on Saturday.
Thank you, Judge.
Okay. Two things.
Oh, Your Honor, we would ask the court to define arrest. As you know, it's a term of art. It's not, and it's used in the statute, but it's not defined under the citizen's arrest statute. So an arrest doesn't have to, when you arrest someone, you don't have to use the term arrest, as the state has argued. If a reasonable person would believe their liberty is detained, that is essentially an arrest for purposes of the law. DUI law, it's Fourth Amendment law. We're arguing to the jury that a detention and an arrest are two different things. We're arguing it's the same thing. And I think the jury's going to need guidance on what is an arrest. And we would ask the court to define it. We're happy to provide a definition.
Let's do this then. Submit it as a proposed charge.
Yes, we'll do that Saturday.
And I'll take it under advisement then.
And the other one, Your Honor.
Your Honor, if I
Oh, I'm
may,
sorry.
momentarily on that, and the only reason I bring it up is because the fear from the state is we've got Terry stops, which apply to police, and that is a detention to investigate. This says citizens arrest, and we understand, thanks Mr. Hoag, the origin of this in 1852, and it never got changed. So
I think we tracked it back to medieval England.
12:15.
whatever. So the problem is what we've got is 17421, OCGA 17421, where we have the duty of the arresting officer to take the arrested person before a judicial officer. And we all know that because we all practice criminal law. You gotta arrest. You gotta put in handcuffs, you gotta transport, you gotta take him to jail, you gotta put him before a judge. So you got this whole sequence of events that happens when you arrest somebody, which is you gotta take him before a judge. It is not, hey, I'm holding you here and doing a Terry stop to investigate, and that conflation is
I agree.
a big
I agree
problem.
with that.
That's why I want to see it as a proposed charge.
And as the state knows, and the court I'm sure knows by now, a citizen does not take the arrestee to the magistrate. All the case law says you hold them for the police to do their job.
I would love to see that case law, because everything I found is from the 1800s, where there were no police to call on any cell phone
Oh, we
to
got
go
plenty.
ahead and
Yeah,
do
all
all
of your
that.
shoplifting cases will be
Okay,
having
well,
them.
it sounds like,
help
in
it.
addition to some of the homework we have, this adds in because, as you all know, one of the reasons that we try to get all the charges before the court with support at the beginning of the trial is so that we don't run into this. I mean, this is obviously something that I need a charge, I need support, but this is not something I'm just going to shoot from the hip on.
The other one, Your Honor, is pattern charge 3, I'll go slow, 3.16.10, threats justifying a homicide. I'll let everybody get on the same page.
So, sorry, Mr. Rico, go ahead.
3.16.10, the defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's or another's life is in imminent danger, then the defendant's use of deadly force may be justified. We have heard the state argue that Mr. McMichael and Mr. Arbery were inches apart at the least when the shooting occurred. I'm sorry.
We join in that request.
Okay, I've read it.
I believe this fits the facts of our case, where the chain of events begins with Mr. Arbery running at Travis McMichael. Mr. McMichael testified. There's additional evidence that he felt threatened by his actions alone, despite Mr. Arbery not having a weapon, and despite there being no physical contact at that point, which led to the pointing of the shotgun. and Mr. Arbery's then, again, the chain of events running around the truck and getting shot either when he put his hand on the gun and it pulled out and he was striking Mr. McMichael, as Mr. McMichael testified, or before he ever touched Mr. McMichael, but they were within inches of each other, Mr. Arbery was menacing Mr. McMichael, putting Mr. McMichael in reasonable fear for his life. I think the charge applies, and so we would ask the court to give that as well.
Your Honor, we ask that this charge not apply. This is verbal threats. That's the entire last line. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force. So in this case, this is all talking about verbal threats. It starts off with the defendant's use of deadly force may be justified even when there has not been physical contact between anyone, if the menacing action of the alleged victim is sufficient to create a reasonable belief that he needed to go ahead and do this. Words alone never justify it. So this really doesn't apply. The evidence in this case is the man was running, and he was running for 5 minutes, and then he was running toward Travis McMichael. There is no evidence of menacing action. It would have been one thing if Travis McMichael had testified to menacing action. All he said was the guy was running toward me. And so we don't have the facts to support menacing action of the alleged victim sufficient to create a reasonable belief about life being in danger at all. And it may be justified is what this says. And then it goes into words alone may never justify it. We have the evidence from everyone that Mr. Arbery never said a word. So this really doesn't apply to the facts of this case.
And I agree that the second paragraph, words alone may never justify, since there were no words spoken. But the first paragraph, the menacing actions of Mr. Arbery, as testified to by Mr. McMichael, would apply in this case.
I think this was actually covered, I think, in 31010, because it says 31010 is a defendant is justified in using force that is intended or likely to cause death or serious bodily injury when he reasonably believes that the use of force is necessary to prevent death or serious bodily injury to himself or a third person, or the commission of a forcible felony, which means a felony that involves the use of force or violence against another, and we've defined that on the request of the defense as aggravated assault is again a felony which can occur by the use of fists if they are used as an offensive weapon. So I think that covers it.
Yes, Judge.
Looking this way, I'll come back.
What I'm saying, Judge, is there's a point in the chain of events where there is no physical contact between Mr. McMichael and Mr. Arbery. The state is arguing that he was shot before there was ever physical contact. But menacing actions alone can cause a reasonable belief of imminent death or bodily injury. And that's what this charge covers.
Okay. I think, for the purposes of the charge, I think it's covered here. I mean, this charge, the only difference is the physical contact language, but that again is still covered under the language.
If I could add, Your Honor, the state's going to argue that this was jogging and running. That's all it was. It was just simple jogging and running. What the testimony was, in fact, is that there were 2 passes at Mr. McMichael. The first one, where he came within 10 feet of the back of his truck, making eye contact with Mr. McMichael while Mr. McMichael was yelling, "Stop, stop, don't come any closer." And his actions were to continue to run, looking into his eyes, which caused him to fear and then reach inside his car to go for his gun. And that action caused Mr. Arbery to turn. Then he comes back for the second pass, and he wavers between staying on course and going around. And the state is going to argue that this jogging, that these actions were simple and were not menacing, and Travis has testified that they were, in fact, what placed him in fear. I think that the additional help from this from this piece helps the jury understand that these types of actions can cause somebody to believe that they're about to receive a violent injury. And in fact, Travis, in his statement to No Hill, he says,
Do y'all have 31010 in front of you?
we do.
Because to me, it's a, under the circumstances, it's almost a better charge than 31610.
We're not saying to replace it. We're not saying to replace it. I think it further narrows it. We think it further narrows that the kind of conduct that could justify is the kind of conduct that's been testified about. We think it aids us and also allows us to rebut the state's argument of jogging and running.
And just for clarity, Judge, Travis McMichael's statement to Officer No Hill was never tendered into evidence.
Sure it was. The recording of it and the transcript. The recording.
No, it's
Yeah,
not.
but neither one of them is actually going to the jury.
No, they're not going to the jury. That's right.
No.
But he was questioned about it. He was shown his statement. He was questioned about his statement. Those
Yeah.
portions
No,
came in.
Well, right, I just want to be really, really clear, the
Okay.
portions on cross-examination, because the
Can I-
reason
can I-
I'm being really careful at this moment, Judge,
Can I
is
get you to stop? Because I've simply got a request to charge 31610. Okay. I think that language is covered and it probably more completely and more tailored to the facts of this case under 31010, which we've already discussed, which would include the definition of aggravated assault that was agreed to a little bit earlier in the day. Okay. From Travis McMichael, you said there were two. I assume those are the two?
Arrest in 31610.
Okay. All right, I'm going to get a follow-up on the arrest language as a proposed charge, and I just ruled on 31610.
Yeah.
Anything further from Greg McMichael?
No, Your Honor.
All right, from Mr. Bryan?
Yes, Your Honor. Going back in the order as I have it, Your Honor, to page 26, unanimous verdict. We believe in this case, the pattern charge and unanimous verdict is inadequate. The jury's verdict must be unanimous as to every count of the indictment. It must be unanimous as to every element of the indictment. There's an entire body of case law which gets fairly complex. A bunch of Supreme Court justices, I think Justice Scalia, going back and forth over how far unanimity must go. We submitted a charge, a special instruction on unanimity, and we're asking the court to give that charge. This charge, the pattern charge, works in your typical one-count felony indictment. It doesn't work in a 9-count case where you've got 3 different defendants charged in all the counts, either as principals or parties to a crime, and different manners in which the offenses can take place. So we need a jury charge that has teeth in it as to unanimity, and that's why we submitted that request. And
I will add in language, unanimous verdict. Whatever your verdict is, it must be unanimous. That is agreed by all as to each count of the indictment and as to each defendant individually. I'll add that language.
well, we appreciate that, Your Honor. It's certainly closer to where we wanted, but we have submitted a special instruction on unanimity that requires that the jury agree specifically with assault as to the existence of one discrete act constituting an assault. The jury doesn't have to determine the precise location or exact time of the assault or the exact sequence of events. Those are certainly issues that have been foreclosed by the appellate cases in this state. But they have to agree unanimously on an assault. And, also they have to unanimously agree on false imprisonment. 6 can't agree to a false imprisonment on Burford. 6 can't agree to a false imprisonment on Holmes. All 12 have to agree that there's a false imprisonment. So, again, I didn't create the problem here. That was the state in their charging decisions. But we don't believe that the issue of jury unanimity it's better than it was. You've made a substantial improvement to the pattern charge, but we still don't believe it's adequate. And so we're asking for additionally that special instruction. And depending on what the state's direction is or what the state's response is, we may well come back over the weekend with yet another more specific unanimity request. I mean, there are legitimate questions as to what is required for a unanimous verdict, what that means. But in this case, we think we need more than we have.
State request for the pattern charge, it's sufficient to cover the fact that the verdicts must be unanimous.
Okay. Well, again, the court's going to charge the pattern with the added language that I've just indicated.
Thank you, Judge.
Thank you, Your Honor. Moving on to page 9 of what seems now pretty much, it's not just a proposal, it seems most of it's in place, but with respect to page 9, voluntariness of statements, we had previously submitted to the court case law with respect to third-party threats. Now, arguably, the way the pattern charge reads in the second sentence, a statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. Arguably, that includes threats from third parties. But my concern is we're going to get up and we're going to argue that the defendant's statements, without which there can be no conviction under Jackson v. Virginia, without Mr. Bryan's statements, that's an acquittal. We're going to get up there and argue that Mr. Bryan was in fear for his life at the time he was making these statements. And whether or not that's induced by the police officer or the totality of the circumstances or a combination of thereof, that the statements are not voluntary. Then the state's going to get up and they're going to say, oh, no, it's voluntary. It doesn't matter whether there were people out there trying to kill him as long as the police officer didn't hand him a gun. And then the jury's going to come back and they're going to ask, what does it mean? And then we're going to do then what I'm trying to get done now. As long as the state's not going to challenge that, if they agree with me that third-party threats and fear of injury from third parties can render a statement involuntary, if they're not going to argue that the fear has to be the product of police action, then we're good. But if they're going to get up with the last word and then throw out some theory to that effect, then we would need this charge to be more specific. That it doesn't have to, the threat, the fear of injury does not have to come from the law enforcement officer who's conducting the interview. So I don't mind leaving it as it is as long as the state isn't going to come back and challenge that. Because if the state's challenging that, then we need to address it now in the charge.
Judge, actually, the case law on Jackson Deno, when we do these arguments, is one of, you can't induce the fear yourself. It can't be self-created fear. It has to be induced by another, and the other person it has to be induced by is the law enforcement officer. And we all know that from Jackson v. Deno. We all know that in motions to suppress. So it cannot be, you have something else going on in your life that you're worried about, and you bring your fear in, and therefore my statement's not voluntary. And here, what Agent Seacrest actually said was that he never made threats or promises or did anything to influence Mr. Bryan. And in fact, Mr. Bryan was seated next to Mr. Goff the entire time. His lawyer was right there. So this idea that somehow he's giving his statement because of third-party pressure that Mr. Bryan, by the way, never testified to, this was all Seacrest, wasn't this what was going on, and weren't there these threats out there, and weren't these third parties out there? Mr. Bryan never said, I'm under the influence or under the threats, or I'm saying all this stuff against my will. It's basically, we've got his on-scene statements, which are his on-scene statements. There's nothing there about third-party coercion. And then we've got his statements to Seacrest. The state asks that there be no additional language about third-party threats as to the voluntariness of Mr. Bryan's statements, especially since he was seated right next to his attorney the entire time. Thank you.
Your Honor, it does, unless they're packing, it does, respectfully, it doesn't matter how many attorneys Mr. Bryan has. The question is not the ability of the defense lawyers to provide physical protection. The question is what's going to happen to him when he steps out of the police station. Now, as long as the state's not going to challenge the argument, the pattern charge is fine. But if they're going to get up and they're going to object during my closing, or they're going to get up and argue the contrary, then the jury may well come back with questions, and if the court doesn't deal with it now, it may have to deal with it then. the idea that the officer was unaware of the third-party threats, which arguably are not fully third-party. It was the GBI director who gave the press conference with the agent Seacrest standing there that contributed to the media storm, putting my client's life in danger. Putting that issue to the side, the officer was well aware at the time the statement was made of what was going out there. Mr. Bryan doesn't have to testify to it when the officers testify to it. And that's not something that's induced by Mr. Bryan. He didn't ask the Arbery family attorneys and their entourage, or whoever, however you want to describe them, to go out there in the media and call for his arrest, call for him for nasty, horrible things to be done, and other people joining in on that.
At this point, Judge, the soliloquy about all of this stuff, we've heard this before, we understand where it's coming from. I guess I'm asking, can we get to the point? And
The point is, Your Honor, that again, and this seems to be the theme today, where one side has one theory of the law, the other side has another theory of law, the pattern charge doesn't fully address it, and then we end up in a situation of jurors coming back with questions. We also end up with the reality that for most jurors in South Georgia, the state district attorney's office and criminal defense lawyers, we're not really in an equal posture. If the state says the law is one thing and we say the law is something different, in South Georgia, it's what the state said. So it's very dangerous and precarious for a defense lawyer in this part of the state to do that.
I don't really know what you're getting at there, but let me just put this. The voluntariness charge that's there does not prevent you from arguing whatever reasonable inferences you can argue. But the charge is accurate, and I'm going to keep the voluntariness charge the way that it is.
Thank you, Your Honor. I'll move on. Your Honor, with respect to page 12, fingerprints, we have no objection to the majority of that charge, but the last portion of it is troubling. The last paragraph of that charge, right above definition of crime, says, if you believe that fingerprints were found and identified, their evidentiary value, if any, would be diminished to the extent that they could reasonably have been left on the article alleged at another time or under different circumstances. In this case, there's been no evidence whatsoever to suggest that Mr. Arbery had any cause or reason to be at the Bryan residence or have any contact with the vehicle. There's been no suggestion, for example, in this case, that Mr. Arbery worked at a car wash or car detailing business and that Mr. Bryan might have been a customer. There's no suggestion that maybe he works on cars and somehow access to cars.
The state doesn't want it.
I'll take yes for an answer. Thank you.
I assume there's no objection from the remaining defendants that the last paragraph be taken out.
No.
Your Honor, with respect, thank you, and thank you.
It
With
is
respect to paragraph, page 16, we are asking that the court add, after the second sentence, that there must be some causal connection between the felony and death. We're asking.
You're moving quickly enough where I know the court reporter's struggling. I haven't caught you yet.
It's the New York coming out of me, Your Honor. I apologize.
So where are we?
We are on page 16.
Okay.
Pattern charge 2.10.30, causation and felony murder pattern.
Okay.
After the second sentence being, there must be some causal connection between the felony and death, we are asking the court to insert an additional sentence. The death must be a reasonably foreseeable consequence of the underlying felony. Must be a reasonably foreseeable consequence of the underlying felony. In other words, if it is not reasonably foreseeable to Mr. Bryan that the death will take place, then there is no causation under Georgia law, and he cannot be found guilty under felony murder for that count, whichever count they're considering at that time. Again, the sentence that we're asking to include would be
I heard you.
You got it.
I
Okay.
got it. Nothing from the state.
Your Honor, actually under causation and felony murder, there's a bench note that says felony murder is not applicable to non-dangerous felonies unless the attendant circumstances create a foreseeable risk of death. So foreseeable risk of death only applies when you've got a non-dangerous felony where there's attendant circumstances. Here we have 3 dangerous felonies. Using pickup trucks to falsely imprison something, attempting to falsely imprison someone with the pickup trucks, and aggravated assault with a firearm, etc. So there is no question that there is a foreseeable risk when you try and falsely imprison someone using a pickup truck to do it, running them off the road, that it might result in serious bodily injury or harm, even death, and that was testified to by the medical examiner. So we don't think that this applies as a charge, the foreseeability. I'm sure Mr. Goff will argue that there's no way Mr. Bryan could have foreseen this happening, but I don't believe it's part of the pattern. When I searched the PDF, it came up only once for non-dangerous felonies. We asked that it be excluded.
If I may, Your Honor, going from the bottom to the top of the indictment, criminal attempt to commit false imprisonment, with all respect to the state, is about as non-dangerous as it can be. And clearly, a charge with respect to reasonable foreseeability would be appropriate. In many states, the state doesn't even get to argue for felony murder. But certainly in this case, we should be entitled for the jury to determine whether it was reasonably foreseeable that a criminal attempt to commit false imprisonment could result or would result in death. By further extension of that, I think the same argument applies to the false imprisonment itself. And the reason I'm bringing this up, Your Honor, is anytime there's an arrest, 99% of which, 99.9% are by police officers, theoretically, any arrest involves a use of force. Use of force is inherent to the arrest. But still, it's not reasonably foreseeable that there is going to be a crime committed in that context. For example, 5 police officers respond to the scene of a purported crime. One of the police officers...
I'm going to object to the examples and the narrative and the argument for closing. If Mr. Goff has some case law that would support a charge on foreseeability, we might be able to get to that point a little sooner.
Your Honor, foreseeability is discussed with the case law for a long time. I'm contending, in response to the state's position, and the example of the police is certainly relevant here. If one person of 5 people making an arrest inexplicably, without warning, without any reason to expect it, kills somebody for no reason, without justification, which is the state's position as to what Travis McMichael did in this case, how are the other 4 people responsible unless that was reasonably foreseeable beyond the application of force inherent to any arrest? So with respect to the criminal attempt, I think it's very clear. With respect to the false imprisonment, I think it's clear. With respect to the aggravated assaults, I think the state has a stronger argument. But with respect to the criminal attempt and the false imprisonment, that's what we're asking for.
No, the court's going to charge the pattern. The pattern's very clear. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. That's the language of a portion of the pattern, and court's going to rely upon the pattern.
Feeling somewhat in the position of Abraham before the Lord, if the court's not going to give the charge on foreseeability as part of the charge on causation, I take it the state has no objection to the defense making that argument, but the court might. So I'm asking the court, do I understand that even though it will not be included in the charge, that there's no problem with the defense making that argument?
Reasonable foreseeability and causal connection are 2 different things, Mr. Goff.
So what I'm asking the court essentially is the court prohibiting, is the court barring the defense, Mr. Bryan's defense, from telling a jury that Mr. Bryan could not reasonably foresee the death. Because obviously I don't want to make an argument in front of the jury and trigger an admonishment or anything else. So if the court's telling me I can't argue to the jury that they should acquit him because it wasn't reasonably foreseeable, obviously I won't do that, but it certainly creates an interesting issue on appeal.
If he committed one of the felonies that is charged, then the jury, using this charge, can make a determination on whether or not he committed felony murder. That's what's here. First sentence. If you believe he caused the death of another person by committing one of the felonies just discussed in the indictment, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. You can argue causal connection, but I would suggest that you argue consistent with the law and read the charge so that you're not injecting issues that would not otherwise be appropriate.
And I certainly don't want to do that. On a related note, since we're also charging the jury about aiding and abetting, the way I interpret the court's charge on aiding and abetting, the charge as in this document I'm looking at, that with respect to the mens rea, Mr. Bryan could not aid and abet in the commission of any of these felony murders if it was not reasonably foreseeable to him that his assistance with the criminal attempt
Where are you in the pattern? I mean, not the pattern. Where are you in the proposed charge?
Well, Your Honor, I haven't moved back to the other page, but the aiding and abetting charge is earlier in the court's charge. We talked about it earlier with the A, B, and C subsections. I think the court rejected the defense position on the applicability of the C subsection, but I'm going back and I'm trying to find it.
It's page 13, is parties to a crime, Judge.
Page 13, parties to a crime. Your Honor, I would contend, irrespective of whether reasonable foreseeability is an issue with respect to causation, under 1.42.10 parties to a crime, where it says under B that the defendant intentionally helps in the commission of the crime, if it is not reasonably foreseeable to the defendant that the death would take place or the offense, criminal attempt to commit false imprisonment, and even aggravated assaults, if the defendant doesn't intentionally help in the commission of the crime, then he's not guilty. And consequently, as a mens rea issue in this case, if it's not reasonably foreseeable to the defendant that that is going to take place, then that is a defense not as a causation issue, but as a mens rea issue. So I just want to make sure that by arguing to the jury that it's not reasonably foreseeable, that I'm not going to draw an admonishment from the court. Now, the state obviously is going to be free to argue to the contrary. But I just want to make sure, as far as me being good with the court, that I'm not going to draw the admonishment of the court or have the court instruct the jury to disregard an argument that with respect to mens rea and aiding and abetting, that they should consider whether what happened was reasonably foreseeable to Mr. Bryan in the course of, as alleged by the state, attempting to imprison falsely Mr. Arbery or actually imprisoning Mr. Arbery. It's a mens rea issue under 1.42.10, and I just want to make sure before I get there that I'm not going to be rebuked by the court. That would be kind of painful in a closing argument.
Anything from the state?
The state's heard no case law that supports a charge on this, so we ask that you not give it.
Yeah, the whole reasonable foreseeability under parties to a crime, if you've got a case out, then go ahead and get it to me. But the way the court understands it is, I mean, it's whether they intentionally, whether they directly commit the crime, intentionally helps in the commission of a crime, or intentionally advises, encourages. Reasonable foreseeability may have actually come up. I had a case a while back about that where we didn't get into it. And I won't get into the facts of the case. I'll look at it, but I don't think that necessarily comes into play under the parties to a crime statute or parties to a crime charge.
Your Honor, we'll endeavor to find a case that might satisfy Your Honor, but
I would suggest before you make any, I'm not going to charge it. I would suggest to very carefully consider the argument unless you have some support for it.
Well, we will look, but what I understand the court to say that is unless and until we come up with a case that says we can do that, that we are prohibited from arguing that Mr. Bryan didn't have the mens rea based on a lack of foreseeability. But I think what the court's, if I understand what the court's telling me, if I use the words reasonable foreseeability with respect to his mental state, with respect to aiding and abetting, that I'm going to draw the rebuke of the court. I don't want to do that.
I just suggested that you've got some time to find some cases that would allow you to make that argument. I'm looking at the charge, and nowhere in the charge does it talk about reasonable foreseeability or any other type of limiting factor. So if you're going to argue that, I would suggest that you have some support for it before you do that.
Thank you, Your Honor. May I continue, Your Honor?
Yes.
Your Honor, we submitted a number of charges, actually some of them twice, and I just want to make sure I haven't missed any of them. Your Honor, specifically with respect to use of force, we submitted 4 charges. The first one is the charge that with respect to the degree of force that a private citizen may use to effectuate an arrest, that a private citizen has the same right and authority to use force as does a police officer. And we have cited numerous authorities to that effect. And we believe that charge should be included in the court's charge in this case. It's kind of a pivotal charge.
The charge that you're referring to was submitted to the court on November 8th. Now, I do point out that requests to charge were requested by the court by October 18th. We've looked at the request to charge, in fact, gone over them and understand the requests. The court has already put together the charge and has gone through what the court intends to charge with regard to use of force. The charge as is currently drafted by the court, again, is what the court intends to charge. I have considered these. They were untimely. And I don't intend to modify the charge as is currently proposed.
Well, if the court's refusing to consider them because they're untimely, I won't discuss it any further. If the court's going to entertain the untimely jury charges, then I'll continue.
Mr. Goff, what issue do these charges raise beyond what is contained in the charge that we have spent a good amount of time today reviewing, with you adding in your position as we went through the charge already? So what new exists in these charges that is not currently contained in the charge that I just went over with the parties?
Maybe, Your Honor, I misunderstood, and if so, my apologies. But it was unclear, at least when we started the process, whether we were bringing up our own charges during that process or waiting to, we went through the court's draft and the state's response to it. So if I've waived these, either by being untimely or not raising them earlier today, then I'll just sit down. But if the court will hear me out, I don't intend to take a lot of time on it. But I do specifically am asking the court to give use of force supplemental charge number 2, number 3, and number 4. And I'm not going to belabor the issue. If the court's going to prevent me from doing that based on their being filed untimely or being waived today.
No, let me be very clear for the record. No, I think I've shown you, there's a bunch of notes and I've reviewed these. They were untimely. Despite that, the court has reviewed them, taken them in consideration in the draft charge that was provided to the parties. And having considered them, drafted the proposed charge, which we have just reviewed with the parties. And what I'm simply trying to understand is whether there is something specific in your proposed charges on use of force that has not been addressed at this point that you believe needs to be addressed.
Your Honor, I don't believe the principles reflected in those 4 charges are covered by the charges. And if the court had already expressly or implicitly denied those requests and I didn't gather that or catch it, my apologies. All I'm trying to do is perfect the record here. And I know the court wants the lawyers to do that. And I think I've done that with respect to the use of force. And I'm going to move on if the court will allow me.
Well, let me be clear then. The court did consider despite them being untimely, the court did consider the charges filed on November 8th. And to the extent that the court found them appropriate under the facts of this case, they've been incorporated into the proposed charge at this time.
Your Honor, next, there is a proposed charge on abandonment that we submitted in this case, specifically with the attempt to commit a crime. And we believe that we are entitled to that charge. It is adjusted to the evidence in this case. The evidence, as you will remember, that came up through the presentation of the now famous video during the testimony of Officer Dial, it's quite clear. Well, you know what? Maybe I shouldn't say anything's clear, but there's certainly a basis in the evidence for the suggestion that contrary to the state presented in the opening, in fact, when the defendant said that he was going to go on or keep on, that he was in fact traveling in the opposite direction from Mr. Arbery, the opposite direction of the McMichaels, for a considerable distance, had put his camera down, and then turned around, put the camera up, and drove back towards what turned out to be the site of Mr. Arbery's tragic death. We contend under Georgia law that constitutes an abandonment. And I understand that complicates the state's position because of all the discussion about which false imprisonment, where that takes place. With respect to abandonment, obviously it makes a huge difference what the state's theory of false imprisonment is and what's charged in the indictment. Because at the point where Mr. Bryan deliberately drives away from Mr. Arbery and away from Travis McMichael, at that point he has abandoned any criminal enterprise, and the jury could well infer, as suggested during the examination of Officer Dial, that when he turned around, he did so as a witness, not as a participant in criminal activity. That he was, in fact, at the time of the shooting, a witness to those events. That is essentially an abandonment, and we believe we're entitled to a charge on it.
All right. This is a charge that was filed with the court today.
And, Your Honor, it is also in fair response to part of the proposed charge that we received yesterday, which I believe was negativing abandonment, at least in the context of one or more of the other offenses. It's certainly a fair response to that issue.
I know that there is pattern jury charge 2.02.50, which is renunciation and abandonment of a criminal enterprise as it relates to conspiracy. So I think that may be what Mr. Goff's talking about, conspiracy, and then you can abandon the conspiracy, but you have to do it before anybody performs any overt act. You have to withdraw, you have to do it voluntarily, and completely renounce and abandon all participation in the criminal endeavor prior to the commission of any offense. Basically, at that point, that wouldn't apply because, of course, he's committed a whole bunch of offenses as part of this 5-minute ongoing thing, both with his car aggravated assault, criminal attempted false imprisonment, further aggravated assault for going up homes after Mr. Arbery, and then coming back around and falsely imprisoning him at the very end. So that would not apply, and therefore abandonment in general does not apply. Obviously, Mr. Goff is going to make that argument. The state's not going to object to any argument that he abandoned it based on what he's saying, but a jury charge on it I don't think is appropriate.
I would point out that the charge that the state is referring to, I think was 2.01.25. I'm talking about the 2.01.20, which is very close in location and in concept, which is also based on OCGA 16-4-5. Certainly, I would like to have this charge, particularly when the state is putting in another charge which is not adjusted to this issue in this case. I don't know what the conspiracy theory is as opposed to Mr. Bryan, but with respect to the commission of a false imprisonment or attempt to commit a false imprisonment, we believe that 2.01.2 is appropriate in this case. Certainly, if the court's going to allow me to argue that, it's better than nothing, but I would rather have a charge to back up the argument if the state's going to contest that, and I presume they will.
All right, again, the charge is filed today. It's untimely, but even considering the charge, the court is not going to charge on abandonment. Again, the counsel is welcome to argue reasonable inferences from the facts as presented to the jury.
And Your Honor, I could be mistaken for the record. I believe that what I printed out today and filed actually previously been filed, and I don't mean to quibble with the court. It certainly wasn't filed.
Well, it wasn't filed as a request to charge. If that's the case, then I would suggest you find out where it is and how it was presented, which is again why the court is willing to go ahead and address the matters, although they are untimely. Just in case, these are issues that were in fact presented previously.
Thank you, Your Honor. We also have citizen arrest. We are asking the court to charge what was originally referenced as citizen arrest part 1. That was filed, I believe, well before jury selection in this case. Specifically, I would concur, assuming the state's position, that the first paragraph on that first page doesn't apply, and that the first portion of the first sentence of the second paragraph doesn't apply. But I believe, pursuant to Myers v. Redwood City, 400 F3D 765 at 772773, and Padilla v. Meese, 229 California Reporter 310, that charge is appropriate. And that charge essentially addresses issues that the state has raised over and over again during the trial through the presentation of witnesses. I charge you that no magic words are required to communicate or demonstrate an intent to detain someone, nor are any words required at all, so long as the totality of circumstances demonstrate to your satisfaction that defendants objectively manifested an intent to arrest, actually we should say detain, the deceased. There is no duty to call 911, but intent to make a citizen arrest may be inferred from acts such as summoning a law enforcement officer, supported by the evidence in this case, reporting criminal activity, supported by the evidence in this case, or identifying an offender for law enforcement purposes, supported by the facts in this case, and it is for you, the jury, to determine from the totality of circumstances whether defendants did in fact intend to make a citizen arrest. That charge, although it's not lifted from a particular Georgia case, is consistent with the body of Georgia case law on citizen arrest and is explicitly referenced in other cases from other jurisdictions. With all due respect to the state, they've been arguing the contrary to that, the contrary to the Georgia law, the whole trial. And all we're asking for the court to do is to correct the misappression that's created to the jury and presumably will be repeated in closing argument, that the defendants have to call 911 before they can conduct a citizen arrest, that the defendants have to announce you're under arrest. None of that is Georgia law. It's not even logical. And we're asking the court for that charge. That's a critically important charge in this case.
Your Honor, Greg McMichael would join in that request.
We'll join as well.
I'm still trying to find the charge.
Yeah, I'm not sure if I have it either.
I'm not sure
What
I've
was
got it.
just read. And I say that because I have been, at the risk of missing our dinner reservation, I have been concerned about Ms. Dunikoski's focus on certain words, as if there's some magic words that need to be said, or that there is some significant difference between a detention and an arrest, or whether a certain thing was done in a certain way that the statute simply doesn't set forth. So I think that would be a good idea on behalf of Greg McMichael.
So well, I was desperately looking for what Mr. Goff was reading and could not find it. I'm going to ask if it's the October 29th, Defendant Bryan's first request to charge.
It probably is, but I can hand you my copy right here as well.
Let me see what you got.
What are you calling it again?
It was denominated Citizen Arrest Part 1. I believe it was attached to it wasn't denominated request to charge. I think it was attached to the memorandum. There's a long body of citizen arrest law behind it as authority. It had several parts. And I thought I had resubmitted it separately as a charge, but nevertheless, the principle of law applies, and it is certainly adjusted to the evidence that was presented this week in this case.
Judge, it's 5:15 and I've never seen this before. So I don't know when it was filed or what this is. And I, of course, ask that it not be given. It's not pattern, and while it sounds great or sounded great while I was desperately trying to figure out if I'd had it or had been served with it, I can't find it. I've never been served with it. I don't know what Mr. Goff's talking about, and we ask that it not be given, I have no idea where this is coming from.
Well, Your Honor, and I don't mean to cut off Ms. Dunikoski, but, you know, we had a conference with the court a good while back, and I made a point of saying that we need to address the citizen arrest law.
Let me stop for a second. The court's looked at this, looked at your brief. It was filed a while ago as a brief, I think, or a bench brief or whatever it may have been. I went through it. And again, although a bunch of these charges are not timely, the court has considered the charges that have been proposed, particularly on citizen's arrest. And the court is comfortable that the way citizen's arrest is proposed in the current charge covers the issues. I understand that there is at least some discussion here about these questions that were asked by the state about, did you say you were under arrest, and various things that Travis McMichael in particular was asked about when it came to his claim of citizen's arrest. There's nothing in the charge that requires an announcement. There's nothing in the charge that indicates that that is a prerequisite. So I think that, quite honestly, is maybe argument or theater. I think the law as laid out in the charge is clear and can be argued that way. There is nothing in the law that requires that you announce, I am a citizen that is here to arrest you. It's reasonable and probable grounds for suspicion, probable cause, which we've addressed, and that's something the jury is going to be presented with. So that can be addressed through argument. I am comfortable that having read the proposed charges on citizen's arrest, including the bench brief that was provided by counsel some months ago, the court is satisfied that the charge as proposed accurately reflects the law. I'm going to be waiting on some additional citation from Mr. Hogue, and I intend to charge that way to the extent then that the proposed charges on citizen's arrest are not covered by that charge with respect to Mr. Bryan, then the court has rejected those charges and intends to charge as described.
Thank you, Robert. For the record, and I'm not going to belabor the point. We also submitted citizen arrest part 3, which is basically a good faith defense for Mr. Bryan. That was based on pattern charge 1.415, the Henderson case, the 95 Georgia Act 830 from 1957, and the Model Penal Code 3.074, Commonwealth Decline. We believe that Mr. Bryan is in charge. Mr. Bryan is entitled to a charge on good faith, and unless the state has some authority that has expressly overruled the Henderson case, then we believe we're entitled to that charge.
There is no good faith exception in the state of Georgia to any of this. However, Your Honor, at this time, the state is going to ask that in place of the good faith charge, that you charge mistake of fact. 3.40.10. And I believe that Mr. Goff at some point, somewhere had listed it. I can't find it now, but then he didn't ask for it in his charge. And I was very surprised, but he did ask for the citizen's arrest of good faith. I'm presuming that he is going to attempt to argue it, and therefore he's entitled to the mistake of fact charge, and it should be included.
Your Honor, a half a loaf is better than no loaf at all. We would suggest that the court consider the Henderson language as well.
So we're talking about
3.40.10, mistake of fact.
I got it.
I had 1.41.50.
Where is that as far as the request, just so I know what I'm looking at? Where, just reference it back.
There is no request from Mr. Goff. There is now just a request from the state based on his, what date was this? This was his October 29th citizen arrest good faith, which I think he was arguing right now because he mentioned the Henderson case. The state expected an additional jury charge from him because he requested this on mistake of fact. It was not forthcoming, and it's the state's feeling that it should be in the charge.
We like the one we submitted better than the pattern charge, but like I said, a half loaf is better than none at all. And if the court's not going to give the good faith charge based on Henderson, we would ask for the mistake of fact charge.
All right, I will plug in mistake of fact 3.40.10, just above verdict generally.
Your Honor, if I may, I hate to do that, but where it normally falls, I thought, was like on page 13, where it's knowledge. It may be a little bit better under knowledge, because that way it'd be between conspiracy and knowledge, so it kind of fits into this, where you gotta have knowledge, can't be mistake of fact, conspiracy. It just may fit in there a little bit better.
We would agree.
It's knowledge. I'll go ahead and put it after knowledge, which is on page 13. Going over to page 14. All right. Go ahead and do that.
Thank you, Judge.
Two more, Your Honor. On behalf of Mr. Bryan, Your Honor, we're asking for charges on lesser offenses to count 7 of simple assault, simple battery, reckless conduct, and reckless driving. We've submitted what I believe is the statute for those 4 offenses. The count 7 alleges aggravated assault in 2 different ways. It alleges aggravated assault with intent to strike. It also alleges aggravated assault based on the reasonable fear of the defendant, not defendant, of Mr. Arbery. To the extent that the state is pursuing a theory that Mr. Bryan intended to strike Mr. Arbery with the vehicle, or that he did strike Mr. Arbery with the vehicle, which I think was the suggestion that they made during the trial, those lesser offenses are all appropriate as a matter of law. They would not be appropriate to the reasonable apprehension aggravated assault, but they would be appropriate to the other, and we're asking the court to charge all 4 of them, or as many of them as the court is willing to give.
Well, if that's the case, then you can't give any of them, because the aggravated assault with a motor vehicle is based on reasonable apprehension. The aggravated assault with a shotgun is based on having a deadly weapon and attempting to cause a violent injury to somebody. So I'm confused.
Well, all I know is what I heard at opening and the evidence that was presented by the state. If the state is agreeing to withdraw from the jury's consideration the allegation that Mr. Bryan intended to strike Mr. Arbery with his vehicle, and we're only proceeding with respect to the motor vehicle count 7 aggravated assault, if we're only proceeding on reasonable apprehension, that the state is not going to be arguing that there was any intent, then we're okay.
No. I'm pretty sure I have to argue he intentionally did an act that placed Mr. Arbery in reasonable apprehension, so I have to prove intent, and that is an essential element that's in the charge.
Your Honor, this is not actually splitting hairs. This is an important distinction. The intent to commit the act that places Mr. Arbery in reasonable apprehension is different than the intent to strike him with the vehicle, the intent to assault on behalf of Mr. Bryan. If the state is willing to concede and have the court charge the jury that the state is withdrawing the allegation that Mr. Bryan attempted to strike Mr. Arbery with the vehicle, then we're good. But if the state wants to pursue both theories of liability, then we're entitled to have the lesser offenses. If the state elects to proceed only under a theory of reasonable apprehension and give up the theory that Mr. Bryan intended to assault Mr. Arbery with the vehicle, then we would not be entitled to the lesser offenses. But if they're pursuing both theories, then we are. There's an intent required for aggravated assault either way, but it's a different level of intent. It's a different level of intent, and it makes a difference in this case. Now, I thought I heard the state say several times in their opening and the presentation of evidence that Mr. Bryan intended to strike Mr. Arbery with his vehicle. We're entitled to the lesser offenses if we're still there. If they're only contending that Mr. Bryan, as a principal or as a part of the crime, intended to place him in reasonable apprehension of injury without not intending to strike him, but only intending to scare him, then we would not be entitled to the lesser offenses. But the state has to choose the theory, elect the theory that it's presenting to the jury.
The state
And
disagrees.
that's the reason that we've
Mr.
got
Goff.
to demur.
You got to give the other side an opportunity to speak.
I will shut up and sit down.
Thank you.
The state does not have to elect. You do an intentional act. If the intentional act is trying to hit somebody, and that intentional act then puts them in reasonable apprehension of receiving serious bodily injury, that's what we're intending. And yes, Mr. Bryan intended to try and hit Mr. Arbery. He tried to run him off the road and into the ditch, and Mr. Arbery actually did go into the ditch. So that is the reasonable apprehension, because Mr. Arbery had to jump out of the way because his truck was coming at him. The state understands the lesser includeds. The state's not opposed to the lesser includeds except simple battery, because simple battery is that the person intentionally makes physical contact of an insulting or provoking nature. Okay, nobody touched
We'll
anybody
concede.
else's.
If
There
we
you
have
go.
the other three, we'll let simple battery go.
Reckless driving, I assumed that's what he was going to argue, and reckless conduct as lesser includeds of, I'm assuming, of the aggravated assault with the motor vehicle is what you're seeking.
Count 7.
So what I understand is, under aggravated assault on Mr. Bryan's verdict form, you're going to be requesting lesser included of simple assault, guilty, not guilty, reckless conduct, not guilty, guilty, reckless driving, not guilty, guilty.
Yes.
Ag assault under 7,
Correct.
under count 7. Don't think it falls under count 9. The lesser's under count 9. I think it's just
Well,
7.
yeah, I think they would be properly lessers under count 9 as well.
False imprisonment, criminal attempt at false imprisonment, criminal attempt to detain him in violation of his personal liberty. It's not going to be simple assault, reckless conduct, and reckless driving. The state
Well,
disagrees.
If he was attempting to stop or block his path of travel, he might not be guilty of a false imprisonment or an attempt, but he might well be guilty of these offenses. Again, the jury is the ultimate determiner of the facts in the case, and they may well conclude that Mr. Bryan did not have the intent to confine and detain, but may have had the intent to stop or block his path, which could well be reckless conduct or reckless driving. So these are also appropriate lesser offenses of those latter counts. Certainly 9 and arguably 8.
Nothing then from the state.
State disagrees on the false imprisonment and criminal attempt at false imprisonment. State sees what Mr. Bryan's asking for the underlying aggravated assault with the motor vehicle to simple assault, reckless conduct, and reckless driving. And we leave it to the discretion of the court. Thank you, Judge.
All right, I'm inclined, it's late, and so it's getting harder and harder to think through this, but I believe at this point, count 7, I'll go ahead and charge on the lesser simple assault, reckless conduct, and reckless driving. That would, I'm trying to remember where I normally put them in the charge. I think that would just go underneath the, in order to make sure that it's clear, I'm going to need to put some language in on the lessers, only applying then to Mr. Bryan, and I'll probably drop them in around the aggravated, probably at the end of the aggravated assault charge, and just do it that way, and make sure that it's clear on what those apply to. Okay.
One more. Easy one. honest, easy,
Well,
easy.
let's not belabor it then.
Win or lose. We previously requested, I believe, a charge on carjacking, which we believe is adjusted to the evidence in the case, especially given the testimony of Travis McMichael yesterday. Under 16-544, a person commits the offense of carjacking that is hijacking a motor vehicle in the second degree when, without the use of a firearm or a weapon, such person attempts to obtain a motor vehicle from an individual without his consent. Now, the court's already going to charge what it is to attempt to commit a crime. And the offense of hijacking a motor vehicle, the jury probably needs to know, in the second degree is a felony, whether or not the attempt is successful. Again, that's 16-544. Now, if opposing counsel or co-counsel are opposed to that charge, I would be open to suggestion, but I think it's adjusted to the evidence in this case.
At no point in time did anyone say Mr. Arbery was attempting to obtain a motor vehicle from an individual without his consent. All Mr. Bryan ever said was he started reaching for my door handle and I sped off. There's palm print on the side of the car. This is after he's already tried to run him off the road into the ditch. This is after he's already tried to hit him with the car. And now we're on like the third aggravated assault with the motor vehicle and he's reaching for the door. The state's argument, of course, is that of course he's reaching for the door. You got so close to him, he's trying to push off away from this truck so that you don't hit him so he doesn't get hurt. And this idea from his perspective of, oh, my window's open and now I'm starting to think, oh my gosh, I'm actually getting really close to this person, I should speed off. To claim that that's carjacking is well, ludicrous. But on this one, I'm going to leave it to the discretion of the court to determine if there was sufficient evidence. All Travis McMichael said was, I wonder why that guy's attacking that truck. Once again, no indication of an intent to obtain a motor vehicle from an individual without his consent. Obviously, Mr. Arbery never said anything. There was no weapon ever shown. And this isn't a slider crime. As we all know, hijacking a motor vehicle in the second degree was all designed for slider crimes. Gas stations, you pull up, you slide in, you drive off in the car without a weapon. So without a weapon, attempting to obtain the motor vehicle from Mr. Bryan, there's actually no evidence that that actually took place. And Mr. Bryan, of course, never said that.
So the only thing I can see is just Mr. Sheffield from the top of his shoulders up. And
A slider is a meat
okay.
sandwich that's a smaller version of a larger sandwich. That's what I know.
I figured it was something like that.
Sheffield knows his slider.
Yeah. All right.
I think there is evidence that there's been an attempted carjacking or something. I mean, Travis McMichael testified to it twice, that he saw him trying to get into the truck and it caused him apprehension. He testified that he looked down the street, he saw Mr. Arbery trying to get into the truck. He thought one of three things: that this was somebody confronting him from 220, that this was somebody who was with him, that he was going to try to get in the car, or that he was trying to take this person's car, and that he looked angry and aggressive when doing it. So I think there is evidence to support it.
It's not an insubstantial matter. If the jury, and it's for the jury to decide, it's second degree, not first degree. But if the jury were to decide that Mr. Arbery, the probable cause existed in the presence and immediate knowledge of Mr. Bryan and the presence and immediate knowledge of the McMichaels, if they were to conclude that the evidence supported the carjacking, then at that moment, they are independently authorized to effectuate a citizen arrest. And it's up to the jury to decide whether Mr. Arbery was justified in committing a violent property crime under the circumstances in order to escape or elude capture, whether by law enforcement or by these defendants. You can't take that issue away from the jury, and it's a critical point in this case. Now, there's some dispute,
Okay.
and I'll sit down.
All right. I'll think that through. It's too late in the day for me to make that decision. Okay? I will think that through. And when I get back on the issues that I'm going to receive some emails on, I will clarify where the court is on it. All right.
You Your Honor, did you leave the conspiracy issues on page 14?
I
just
did.
for your, you didn't, my notes indicate you don't need anything more from
I
us
don't.
than we've already provided.
I don't, I just gotta finish thinking that through, and I just haven't had an opportunity to do that yet.
Thank you, Your Honor.
I don't dare go around the room one more time.
Okay.
I will go ahead and address the matters that I need to address. I will look for the information that council has promised me by tomorrow, and I will try to get you a clean draft of the charge late Saturday or sometime Sunday. We will then reconvene at 9 o'clock Monday morning. And, yeah, sheriff's deputies almost fell out of the chairs. We'll reconvene at 9 o'clock Monday morning and hopefully be able to move into closings at that time. I don't dare ask, but does anyone have anything pressing for the court before we recess?
No, Judge.
No, Your Honor.
No.
All right. Thank you, everybody. We will see everybody Monday.
Thank you, Judge.